Your Lordship, signed leave, my lord.
Lords, kindly, my lord, the court's video and audio is off, my lord. Serial number 13, I appear for petitioner, my lord.
Make your submission, counsel.
My lord, my lord, the court is not audible, my lord. I'm sorry, my lord.
Not audible ಅಂತ ನೋಡ್ರಿ ಯಾರು ಇದ್ದಾರ ಏನೋ ಆಗಿದೆಯಾ ಏನ್ Are you able to hear court now?
My lord, now we are able to hear, my lord. Please, my lord.
Yes, counsel, make your submission regarding delay.
My lord, may I make one submission, my lord? Senior counsel CH Chandramouli is on record, my lord. There is a bereavement in his family today. I was waiting to make that mention in the morning, my lord, at 10:30. Unfortunately, I could not, my lord.
Counsel, you can argue for delay is concerned. You want
Please, my
senior
lord.
for arguing this counsel?
My lord, the instructions are, my lord, that the matter may have been settled, my lord. This is an NI Act revision, my lord. The matter may have been settled between the parties.
Then you withdraw the revision petition, that's all.
My lord, I will seek instructions, my lord. Can it kindly be taken up tomorrow, my lord? Please,
Junior counsel seeks time. This matter on 21/3.
Grateful.
Release of amount by the respondent. Siddhaya.
This case appear for
ಕಾಪಿ ಶುರು ಮಾಡಿದಿರಾ ಅದರ ಸೈಡ್ ಕಾಪಿ
yes,
ಶುರು ಮಾಡಿದಿರಾ
yes my lord.
ನೋಡಿ ಯಾವಾಗ ಶುರು ಮಾಡಿರಿ ಯಾವಾಗ ಶುರು ಮಾಡಿದಾರೆ ನೋಡಿ
ಮಾರ್ಚ್ ಸೊ ಇದ್ರ ಕೊರಿಯರ್ ಸರ್ವಿಸ್ ಅಲ್ಲಿ ಹೋಗಿದ್ದು ಅದು ತಲುಪಿದೆ ಸ್ವಾಮಿ
ಅಲ್ಲಿ ನೋಡೋದಲ್ಲ ಇಲ್ಲಿ ನೋಡ್ಬೇಕು ಮೇಡಮ್ ರಿಲೀಸ್ ಅಪ್ಲಿಕೇಶನ್ ಥ್ರೂ ಕೊರಿಯರ್ ಸರ್ವಿಸ್
ಅಲ್ಲ ಅದರಲ್ಲೂ ಮಾಡಿದ್ದೆ ಬೈ ಪರ್ಸನ್ ಆಗಿ ಹೋಗೋದು ಸರ್ವ್ ಮಾಡಿದ್ವಿ
ಕೊಡಿ ಅದೇನ್ ತಗೊಳ್ರಿ ಅದೇನ್ ನೋಡ್ರಿ
ಎರಡು ತಲುಪಿದೆ ಸ್ವಾಮಿ
The counsel for the respondent filed acknowledgement for having served the copy on the petitioner for release of the amount. And also counsel submits that earlier. Also sent the same through courier. And counsel is not before this court. This court, while suspending the sentence, ordered to deposit 50% of the amount.
$50% of the fine amount ಅಂತ ಹೇಳಿದ್ರೆ ಅವರು 50% ಚೆಕ್ ಅಮೌಂಟ್ ಕಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ
ಆರ್ಡರ್ ಏನಂತಿದೆ
50% of the fine amount ಅಂತ ಹೇಳಿದೆ
50% of ನೀವು ಹಾಕಿರೋ ಚೆಕ್ ಅಮೌಂಟ್ ಅಂತ ಈಗ
ಚೆಕ್ ಅಮೌಂಟೇ ಅವ್ರು ಕಟ್ಟಿರೋದು ಚೆಕ್
is to pass an order to release the 50% of the check amount, that is 1 lakh deposited by the petitioner / accused, and for the reason stated in the accompanying application and affidavit, and also the respondent, though served with copy, not filed any objections, and hence order to release the amount in favor of the revision petitioner. With an undertaking to repay the amount if the revision petitioner succeeds in the revision, and directed to execute a bond for indemnity bond for the said amount.
ಸ್ವಾಮಿ ಇನ್ನೊಂದು ಸಬ್ಮಿಷನ್ ಇನ್ನು LCR ಕಳಿಸಿದ್ರೆ ಅದು ರಿಲೀಸ್ ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ, ಇಲ್ಲ ಅಂತಂದ್ರೆ ರಿಲೀಸೇ ಮಾಡಲ್ಲ.
ಇಲ್ಲಿ ಇಲ್ವಾ ರೆಕಾರ್ಡ್ ಇಲ್ಲಿ ಇದೆಯಾ?
ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ.
LCR ಇದೆಯಾ ಮೇಡಮ್? TCR ಏನು ಇದೆಯಾ? ಇಲ್ಲ ಅಲ್ಲ, TCR ಕ್ಯಾಪ್ಟನ್ ಇದಂತ ಇದೆಯಲ್ಲ ಇವ್ರದಲ್ವಾ? TCR ಬಂದಂಗಿಲ್ಲಲ್ರಿ, ಇದ್ರಲ್ಲಿ ಹಾಕಿಲ್ಲಲ್ಲ TCR ಕ್ಯಾಪ್ಟನ್ ಅಂತ. ಕೆಪ್ ಬಿಲೋ ಮಾಡಿಲ್ಲ, ಇಲ್ಲ ಅಂದ್ರೆ ಒಂದು ಮೂವ್ ಮಾಡಿ ರೆಕಾರ್ಡ್ಸ್ ಇಲ್ಲ ಅಂದ್ರೆ.
ಸರಿ ಸ್ವಾಮಿ, ಮತ್ತೆ
ತೊಗೊಳ್ಳಿ. If any TCR is received, send the same to the trial court for payment and get back the same ಅಂತ ಹಾಕ್ಬಿಡಿ ಅಲ್ಲಿ.
ಮತ್ತೊಬ್ಳು
Anshuman.
For the respondent in this case, my lord.
Yes, counsel, ಹೇಳಿ.
My lord, postal acknowledgement filed in the counter yesterday morning itself, my lord.
ಫೈಲಿಂಗ್ NOC ವಕಾಲತ್ petitioner.
ಹಾಕಿದಿರಾ?
Don't have copy. ಹಾಕಿದೀವಿ. ನನ್ನ ಹೆಸರಲ್ಲಿ ಲೀಸ್ಟ್ ಆಗಿ ಶಾರ್ಟ್ ಅಕೌಂಟ್.
ನಿಮ್ಮ ಹೆಸರೇನು?
ನಾರಾಯಣ್ ಸ್ವಾಮಿ.
ತೋರಿಸಿದೆಯಲ್ಲ ನಿಮ್ಮ ಹೆಸರು?
ತೋರಿಸಿದೆ. ಐ ಡೋಂಟ್ ಹ್ಯಾವ್ ಕಾಪಿ, ಎನಿ ಕಾಪೀಸ್.
ಏನ್ ಮಾಡ್ಬೇಕು? ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆಯಾ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ನಿಮ್ಗೆ.
ಹೌದು
ರಿಲೀಸ್ಗೆ.
ಹೌದು
ತಗೊಳ್ಳಿ. Petitioner counsel seeks time to file objections to IA 1/24.
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ.
List this matter on 21/3.
ಕಾಪಿ ನಾಟ್ ಸರ್.
ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರೇನ್ರಿ ಅದರ್ ಸೈಡ್ಗೆ?
Yes, my lord. I have served it to the party itself, not the advocate. I have served it to the party itself, my lord. For the petitioner itself, I have served.
Copy was served on the party itself ಅಂತ ನೋಡ್ರಿ. ಅದರ್ ಸೈಡ್ RPD ಅಲ್ಲಿ ಕಳಿಸಿದ್ದಾರೆ. This matter on 21/3.
Please, ma'am.
Mohammed Tahir Lakshmikant. Extension of time filed by the petitioner counsel.
So remaining balance I have paid to phone pay lots.
ಮಾಡಿದೀರಾ?
ಮಾಡಿದ್ವಿ.
ಅದೇ ಡಿಫರೆನ್ಸ್ ಅಮೌಂಟ್ ಇತ್ತಲ್ಲ ಅದ
18,000 we have paid
18,000 by way of
to phone pay.
phone pay. Revision petitioner counsel submits that the remaining amount of rupees 18,000 is paid through phone pay. And the counsel for the respondent is present and also respondent also present, and respondent admits the receipt of rupees 18,000 through phone pay. ಏನಾಗ್ಬೇಕು ನೆಕ್ಸ್ಟ್?
Order has to be modified.
ಇನ್ನೇನ್ ಮಾಡಿಫೈ ಮಾಡೋದು ಕೊಟ್ಟಾದ್ಮೇಲೆ? ಇನ್ನೆಂತ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಟೈಮ್ ರೀ?
Trial court has to
list the matter for admission if not admitted.
duty has to be furnished.
ಅಲ್ಲಿ ಕೊಡಿ, ಹೋಗ್ಬೇಕಲ್ಲಿ.
Trial court put up ಆಗಿದೆ ಸರ್. Trial court record.
ಅಲ್ಲಿ ಹೋಗಿ ಮಾಡಿ ಬಾಂಡ್ ಬರ್ಕೊಡಿ. ಆರ್ಡರ್ ಇದೆಯಲ್ಲ ತಗೊಳ್ಳಿ, ಅಲ್ಲೇ ಹಾಕ್ಬಿಡಿ. ದಿ ಪಿಟಿಷನರ್ is permitted to execute the bond within 2 weeks from today before the trial court. Chandrahas Rai, Firoz.
I appear for the respondent, my lord.
I give for extension of time. The fine is 10,25,000. On 7/12, the honorable court.
What
has
was
directed-
date of order? Date of order, counsel.
Date of 7/12/23.
7/12. Have you made the payment or not?
No.
Huh?
It's for a extra. No, they could not pay the fine amount of 5 lakhs.
Whatever it may be, have you made any payment?
ಇಲ್ಲ ಇನ್ನು ಮಾಡಿಲ್ಲ.
Then no question of extension.
ಅಲ್ಲ ಇದು ಈ ಪೇಮೆಂಟ್ ಮಾಡಿ.
For
ಸಸ್ಪೆನ್ಷನ್ ಸೆಂಟೆನ್ಸ್ ಗೆ
suspension of sentence with conditions ಮಾಡಿರೋದು.
ಹೌದು
7/12/23 ಅಲ್ಲಿ.
ಮಾಡಿಲ್ಲ, ಅದಕ್ಕೆ we are seeking extension.
ಎಕ್ಸ್ಟೆನ್ಷನ್ ಕೊಡೋದಿಲ್ಲ.
4 weeks ಕೊಡಿ.
ಯಾವಾಗ ಆಗಿರೋದು? 7/12 ಅಲ್ಲಿ ಆರ್ಡರ್. ನಿಮಗೆ ಟೈಮ್ ಕೊಟ್ಟಿರೋದು ಎಷ್ಟು ದಿವಸದೊಳಗೆ ಮಾಡಬೇಕು?
Lordship has granted 6 weeks. But he could not pay.
ಒಂದು ಫಾರ್ಮ್ಯಾಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಈಸಿ ಫಾರ್ ಯು ಟು. ಪ್ರತಿ ಸರಿ ನಾನು ಓದೋದು ತಪ್ಪುತ್ತೆ, ಕಂಡೀಷನ್ಸ್ ಏನಿರುತ್ತೆ ಅಂತ.
ಏನಾಯ್ತು? 6 weeks granted on 7/12. But he could not pay. So thereafter the trial court did not accept. So now we seek at least 2 weeks.
No, counsel, this court already granted time on 7/12 within a period failing which the 6 weeks ಕೊಟ್ಟಿದೆ.
ಹೌದು,
6 weeks
ಆಗ್ಲಿಲ್ಲ. Because amount is substantial.
ಆಯ್ತ್ರಿ, ಡಿಸೆಂಬರ್ ಆಯ್ತು, ಜನವರಿ ಆಯ್ತು, ಫೆಬ್ರವರಿ ಆಯ್ತು, 3 ತಿಂಗಳಾಯ್ತು. 6 weeks time
After 6 months, after 6 weeks they accept ಮಾಡೋದಿಲ್ಲ ಸ್ವಾಮಿ. After 6 months, 6 weeks, they did not, trial court did not accept because of the time granted by the honorable court.
Then why you have filed the application belatedly?
Now we are seeking permission.
Why you have filed the application belatedly?
Perfect that.
When you have filed the application for extension of time?
Because I was not keeping well, so I could not.
You slept for a period of 3 months and then now filed an application for extension of time.
2 weeks.
My lordship, my
This
lordship,
cannot be,
2
What-
weeks ಕೊಟ್ಟುಬಿಡಿ means, I mean, thereafter will not seek any further extension.
my
no
lordship,
further
one
extension.
one submission, my lordship.
From 7/12 till another 2 weeks.
ಎಲ್ಲಿದೆ application ಇದು? Extension of time application ನೋಡಿ.
My lordship, one submission ಸ್ವಾಮಿ. ಇದು ಪೆಟಿಷನ್ ಫೈಲ್ ಮಾಡಕ್ಕೆ 1.25 ವರ್ಷ ತಗೊಂಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಡಿಲೇ ಆಫ್ 1.25 ವರ್ಷ ಇದೆ ಈ ಪೆಟಿಷನ್.
ಏನ್ ತಗೊಳಕ್ಕೆ?
ಈ ಪೆಟಿಷನ್ ಕ್ರಿಮಿನಲ್ ಡಿವಿಷನ್ ಪೆಟಿಷನ್ ಫೈಲ್ ಮಾಡಕ್ಕೆ ತಮ್ಮ ಮುಂದೆ ಡಿಲೇನೆ 1.25 ವರ್ಷ ಆದ್ಮೇಲೆ ಈ ಪೆಟಿಷನ್ ಫೈಲ್ ಮಾಡಿರೋದು ಸ್ವಾಮಿ.
ನೀವೇನ್ ಮಾಡ್ತಾ ಇದ್ರಿ ಇದುವರೆಗೂ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ದಲೇನೆ ವಾರೆಂಟ್ ನ?
ಸ್ವಾಮಿ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿದ್ರೆ ಇವರು ಡಾಕ್ಟ್ರು ಅಲ್ಲಿ ಹಾಸ್ಪಿಟಲ್ ಹತ್ರ ಹೋದ್ರೆ ಓಡೋಗ್ಬಿಡ್ತಾರೆ ಸ್ವಾಮಿ, ಹಿಂದೆ ಬ್ಯಾಕ್ ಡೋರ್ ಇಂದ.
ಓಡೋಗ್ಬಿಡ್ತಾರೆ, ಏನ್ ಹಿಡ್ಕೊ ಬರ್ಬೇಕು ಅಷ್ಟೇ ಓಡೋದ್ರೆ. ಹಾ, ಯಾವಾಗ ಆರ್ಡರ್ ಆಗಿರೋದು ಯಾವಾಗ ರೀ?
7/12 order ಅದು.
ಅಪೀಲ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿರೋದು ಯಾವಾಗ? ಈ ಆರ್ಡರ್ ಬಿಟ್ಬಿಡಿ.
ಅಲ್ಲ 7/12 ಗೆ.
ನಿಮ್ಮ ಅಪೀಲ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದ್ದೆ ಯಾವಾಗ?
ಇಲ್ಲ ಸರ್.
ಆರ್ಡರ್ ಚೆಕ್ ಬೌನ್ಸ್ ಕೇಸ್ ಡಿಸೈಡ್ ಆಗಿರೋ 2018 ಅಲ್ಲಿ, ಹೌದಾ?
ಹೌದು.
ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ಡಿಸ್ಪೋಸ್ ಆಗಿದ್ದೆ ಯಾವಾಗ?
ಅಲ್ಲ.
15th day of November 2021. ನೀವು ಈ ರಿವಿಷನ್ ಹಾಕಿರೋದು ಯಾವ ವರ್ಷದಲ್ಲಿ?
8/8/23.
23 ಅಲ್ಲಿ. Then again why you are seeking time? 21 orders appeal confirmed. No grounds.
2 weeks ಕೊಟ್ಟುಬಿಟ್ಟು ಸರ್.
No. Heard the revision petitioner counsel and also the counsel appearing for the respondent, and this court granted. This court suspended the sentence with a condition to pay the 50% of the amount within 6 weeks. And this order was passed on ಯಾವಾಗದು?
7/12.
7/12/23. And the application is also filed belatedly in the month of January.
24/1/24.
And also on perusal of records discloses that criminal appeal was disposed in 2021. And there was a delay in filing the revision petition also. And even there was a delay, and this court exercised the discretion in suspending the sentence. The amount has not been paid, and hence no grounds are made out to extension of time, and hence IA is rejected.
Apply.
Proceedings. Check
Delay of
amount is,
462 days in filing. Yes.
my lordship, petitioner had the financial difficulty, my lordship.
Financial
Difficulty, as well as he has some small scale industry.
issue notice against the respondent on IA and also on main.
Lord, sir.
For opponent.
Lordship has last time asked me to produce the documents to show that they have knowledge about the sales. Even the documents produced by them, sale deeds, kindly see the date of application. See how long, old document they have produced. So that itself shows that they are aware of the sale transactions. And in the two sale deeds, that 2000 and 2002, one of the plaintiffs, that is second plaintiff, is a party to that. Sorry, first plaintiff is a party to that.
ಎಲ್ಲಿದೆ ಯಾವ್ದು ಡಾಕ್ಯುಮೆಂಟ್?
ಅವ್ರು ಹಾಕಿರೋ ಸೇಲ್ ಡೀಡ್ಗಳು, ಇಟ್ಸ್ ಇನ್ ಪೇಜ್ ನಂಬರ್. ಅದು ಫಸ್ಟ್ ಇದು ಸೇಲ್ ಡೀಡು, ಇಟ್ಸ್ ಇನ್ ಪೇಜ್ ನಂಬರ್ 144.
ಎಲ್ಲ ಅಪಲೆಂಟೇ ಇದೆ, ಅವ್ರ ಡಾಕ್ಯುಮೆಂಟ್ ಯಾವ್ದು ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ?
ಅಲ್ಲ, ಅವ್ರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅದಲ್ಲ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಪ್ಲೇಂಟ್ ಒಟ್ಟಿಗೆ.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ
ಎಲ್ಲ ಪ್ಲೇಂಟ್ ಒಟ್ಟಿಗೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ, ಎಲ್ಲ ಆಗ್ಲೇ ತಕೊಂಡದ್ದು ಓಲ್ಡ್.
ಆ ಡಾಕ್ಯುಮೆಂಟ್ ನ ನೀವು ಹಾಕಿದೀರಾ?
ಯಾರು
ಆ ಡಾಕ್ಯುಮೆಂಟ್ ನ ಈ ಕೋರ್ಟ್ ಮುಂದೆ ನೀವು ಹಾಕಿದೀರಾ?
ಅದನ್ನೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ ನಾನು.
ನೀವು
ಅವ್ರು ಹಾಕಿದ್ದಾನೆ, ಜೆರಾಕ್ಸ್ ಮಾಡಿ ಹಾಕಿ.
ಅದನ್ನೇ ಹೇಳ್ರಿ, ಎಲ್ಲಿದೆ ಅಂತ, ಯಾವ ಪೇಜ್ ನಂಬರ್ ಹೇಳಿ.
ಅದರಲ್ಲಿ ಇದ್ರಲ್ಲಿ ಕಾಣುತ್ತೆ ಸ್ವಾಮಿ, ಲಾಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಅವ್ರು ಅಪ್ಲೈ ಮಾಡಿ ತೆಕ್ಕೊಂಡ
ಕಾಣುತ್ತೆ, ಯಾವ ಪೇಜ್ ಅಲ್ಲಿ ಇದೆ ಅಂತ ಕಾಣುತ್ತೆ ಅಂತ ನಂಗೆ ಹೇಳಿ,
ಅದು
ನೋಡ್ತೀನಿ ನಾನು.
155 ಅಲ್ಲಿ ಇದೆ.
ಅದನ್ನ ಹೇಳ್ಬೇಕಲ್ವಾ? 155 ನೀವು ಹಾಕಿರೋ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಲ್ಲೇ ಪೇಜ್ 155 ಅಲ್ಲಿ ಇದೆ.
156 ಅಲ್ಲಿ ಇದೆ, 2006 ಅಲ್ಲಿ ತಗೊಂಡಿದ್ದಾರೆ. ಕೇಶವ ಮೂರ್ತಿ ಅಂತ 156 ಅಲ್ಲಿ, ಪೇಜ್ ನಂಬರ್ 156.
156
ಕೇಶವ ಮೂರ್ತಿ ಅಂತ ಇದೆ, 2006, 6/9/2006.
ಕೇಶವಮೂರ್ತಿ ಯಾರು?
ಅವರೇ ಹಾಕಿದ್ದು, ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದು ಕಾಪಿ.
ಕೇಶವಮೂರ್ತಿ ಅವರೇನಾ?
ಅಲ್ಲ, ಅವ್ರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರು, ಅವ್ರನ್ನ ತೆಕೊಂಡು ಹಾಕಿದ್ರು. The document they have obtained in the year 2006 itself, it shows. Those documents they have produced in the trial court. Next document, 2002 sale deed. That are also obtained in 2003, it's in page number 168. And in that sale deed, in page, kind of see page number 167,
2003 ಅಲ್ಲೇ ತಗೊಂಡಿದ್ದಾರೆ ಅಂತ.
ಹೌದು.
ಹಾ, ಇನ್ನು-
ಅದರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 167 ನೋಡಿ.
ಹ್ಮ್.
ಸಿ ಪದ್ಮಾ, she is the first plaintiff. Consenting witness.
ಯಾರು?
ಸಿ ಪದ್ಮಾ, consenting witness.
ಹಾ, ಪದ್ಮಾ.
ಹೌದು, ಅವರು one of the plaintiffs, first plaintiff. So she is a party to that sale deed. And next to sale deed. That is 2000.
ಯಾರು ಅದರ್ ಸೈಡ್ ಅಲ್ವಾ? ಎಲ್ಲೋರವರು? ಆಯ್ತು, ಬರ್ಲಿ, ಅವರು ಬರ್ಲಿ, ನೋಡೋಣ. ಓನ್ಲಿ ಫರ್ದರ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಅಲ್ಲ.
ಅವ್ರೇನೋ ಸ್ವಲ್ಪ ಫೋನ್ ಮಾಡಿದ್ರು ಬೆಳಗ್ಗೆ, ಇನ್ನು ಮಗಳಿಗೆ ಹುಷಾರಿಲ್ಲ ಅಂತಾನು ಫೋನ್ ಮಾಡಿದ್ರು. She called me.
ಮತ್ ನೀವ್ ಹೇಳಲ್ಲ ಅದು?
Sorry,
ಹಾ?
mistake ಆಯ್ತು.
ಹುಷಾರಿಲ್ಲ.
Monday or Tuesday ಹಾಕ್ಬಿಟ್ರೆ
ಆಯ್ತು, ತೋರಿ. ಹುಷಾರಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ಮೇಲೆ ನೀವು ಅದ್ ಹೇಳ್ಬೇಕು.
ಸಾರಿ, ಅಲ್ಲ ಫೋನ್ ಮಾಡಿ ಬರ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು, ಆದ್ರೂ ಬರ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು ಅವರು. ಮಾರ್ನಿಂಗ್ ಬಂದು ಬೇಗ ಹೋಗ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು.
ಆಯ್ತು, ತೋಳಿ. Appellant counsel present, respondent counsel absent. List this matter on Tuesday ಹಾಕಿ.
Tuesday. ಮಚ್ಚೊಬ್ಳು
12/3.
Respondent almost ಆಗಿದೆ. Next Thursday ಹಾಕೊಂಡ್ರೆ report.
Next Thursday. Both counsel submits that already they have settled the matter and then list this matter on Thursday ಅಂದ್ರೆ date 14th ಅಲ್ಲ? 14.
Pass over synopsis have been made. Arguments.
ಕೊಡಿ.
Please. My lords, in this matter, my lords, there were two cases filed by the complainant. One under CC 14/822 bar 2013. Another one was 14/823 bar 2013. 14/8/223/2013 was ended up in compromise. The 14/8/22 ended up in conviction, my lord.
Ended?
In conviction.
In conviction.
Now that order is under challenge before this honorable court. Lord, my two submissions, my lord. The first submission is this, my lord. It is in their own pleading in their complaint. They have stated that the money was given from one Antariksha consultants to the petitioner. The same is reiterated in the legal notice also. That is to say, the money of Antariksha consultant was given to the petitioner. Now, my lord, the complainant before this honorable court is an individual. So he does not classify under the category called holder in due course. It is the money of the company which has to be recovered.
Check given in favor of whom?
Check is given by me only.
In favor of whom? In favor of Antariksha or in favor of the individual capacity?
Individual. Now, another factor in this is, my lord, that they claim that they gave money under two checks. One is 674790 for 15 lakhs. Another one is 161225 of, that is for 5 lakhs. My lord, as I mentioned earlier in 14/8/23, there also they lay the claim under 161225 that 5 lakhs was given. In that 5 lakhs has been settled. As such, 161225 liability is not made out. What remains is this before your lord is only for 10 lakh rupees. My submission is this, my lord.
In this proceedings is only for one check or two checks?
Two checks.
But another check he has filed separate case.
ಹೌದು, ಅದರಲ್ಲೂ ಹಾಕಿದ್ದಾರೆ. ದುಡ್ಡು ಕೊಟ್ಟಿರೋದನ್ನ ಎರಡು ಚೆಕ್ ಅಲ್ಲಿ ದುಡ್ಡು ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ ಏನ್ ಹೇಳಿದ್ದಾರೆ.
ಹೌದು,
ಇದ್ರಲ್ಲೂ ಸಹ ಅದೇ ಚೆಕ್ ನಂಬರ್ ಹೇಳಿದ್ದಾರೆ. ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದ್ದ ಚೆಕ್ ಕೇಸಲ್ಲೂ ಸಹ ಅದೇ ನಂಬರ್ ಹೇಳಿದ್ದಾರೆ. 5 ಲಕ್ಷ ರೂಪಾಯಿಗೆ 10 ಲಕ್ಷ ರೂಪಾಯಿಗೆ ಹೇಳಿಲ್ಲ ಅವ್ರು. ಅವ್ರ ಕೇಸ್ ಏನಂದ್ರೆ 20 ಲಕ್ಷ ರೂಪಾಯಿ ನಮಗೆ ಕೊಟ್ಟಿದ್ವಿ ನಾವು.
ಟೋಟಲ್
20 lakhs. ಅದ್ರೊಳಗೆ 20 ಲಕ್ಷ ರೂಪಾಯಿಗೆ ತೀರ್ಸ್ಲಿಕ್ಕೆ ನಾವು 15 ಲಕ್ಷ ಕೊಟ್ಟಿದೀವಿ ಅಂತ. ಆ 15 ಲಕ್ಷಕ್ಕೆ ಇಲ್ಲಿ ಪ್ರಾಸಿಕ್ಯೂಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಈ ಇವರು ಹೇಳೋ ಪ್ರಕಾರ ಏನ್ 20 ಲಕ್ಷ.
ನಿಮ್ಮ ಹಳೆ ಕೇಸ್ ಕಾಂಪ್ರಮೈಸ್ ಆಯ್ತಲ್ಲ?
ಹೌದು.
ಅದ್ರ ರೆಕಾರ್ಡ್ಸ್ ಇದೆಯಾ?
ಇದೆ.
ಇಲ್ಲ ಇದೆಯಾ?
ಅಲ್ಲೇ.
ಅದು ಚೆಕ್ ನಂಬರ್ ಸೇಮ್
ಇದೆ.
ಏನ್ರಿ?
Check numbers are different. There are 3 checks. Your lordship kindly see.
Total 3 checks.
Yes, this is 10 lakh and 5 lakh subject matter. This is a revision petition.
15 lakhs.
Enter different check.
10 plus 5, 15 lakhs.
No, this is 15 lakhs. That one is 5 lakhs. It is settled. and compromise has been.
ಅವ್ರೇನೋ ಹೇಳ್ತಾರಲ್ಲ ಎರಡು ಒಂದೇ ಚೆಕ್ ಅಂತ.
My lord, you kindly see, I am
ಹಾ.
making submissions based on their own documents.
ಆಯ್ತು ಏನ್ ಹೇಳಿ ಏನ್
Exhibit D5 ಅಲ್ಲಿ ನೋಡಿ ಸುಮ್ನೆ.
ಕೊಡ್ರಿ ಮೇಡಮ್ ರೆಕಾರ್ಡ್ಸ್ ಕೊಡಿ. ಎಕ್ಸಿಬಿಟ್ D5
ಹೌದು.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ನಮ್ದು
Certified copy.
ಆಯ್ತು ಇನ್ನೊಂದಿದೆ ನೋಡಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ TCR ಇದು ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಇರೋದು ಹಾ ಒಂದೇ ಇರೋದ ಏನು SCR ಕೆಟ್ ಬೈ ಅಂತಿದೆ ಇರ್ಲಿ ಆರ್ಡರ್ ಆಗಿದೆಯಾ ನೋಡಿ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ ಅದು ಇಲ್ಲಿದೆ ಅಲ್ಲ
15/9/19 ಅಲ್ಲಿ ಕಾಲ್ ಫಾರ್ ಆಗಿದೆ.
15/9
15/11/19
90 ಅಲ್ಲ
15/11/19 15/11
19
yes 19.
Hmm?
Yes, I took the 50% of the amount by way of filing the
ಮತ್ತೆ
application.
ವಾಪಸ್ ಬಂದಿಲ್ವಾ ರೆಕಾರ್ಡ್ಸ್
ನನಗೆ
told. The registry is directed to get the records of the trial court. List this matter on 21/3.
I applied for the. One 30 proceeding, my lord.
Learned counsel for the petitioner is permitted to deposit demand draft
I
along
already
with memo
complied, my
before
lord. I
this court.
filed the
Huh?
memo. Complied.
Hmm.
Memo no ಹಾಕಿ.
Hmm.
Kindly see.
Hmm.
Subject matter of the check is 5 lakhs
Hmm.
as per exhibit P1, my lord.
Hmm.
And trial court has been convicted and thereafter the appellate court confirmed by dismissing my appeal, my lord, and I am before you, lord.
Hmm.
First ground, my lord.
Hmm.
Second ground, the respondent has not produced any piece of paper to show that he lent the amount of rupees 5 lakhs
Hmm.
to the petitioners.
Hmm.
And he has not produced income tax for the said years also
Hmm.
connected.
Hmm.
And the trial court has.
Have you led any evidence before the trial court?
Yes,
Have you led any evidence
yes,
before
I
the
have.
trial court?
yes. I led the evidence.
What is your defense? What is your defense?
Before that, can I go ahead with the cross-examination portion of
Hmm.
PW1, my lord?
PW1.
Yes.
Your
Then-
ನಿಮ್ ಡಿಫೆನ್ಸ್ ಫಸ್ಟ್ ಓದಿ ನೋಡೋಣ
ಹಾ.
ವಿಲ್ ಸಿ
ಆಯ್ತು.
ಅವ್ರದ್ದು ಓದಕ್ ಮುಂಚೆ ನೀವೇನ್ ಹೇಳಿದಿರಿ ನೋಡೋಣ ಅವ್ರದ್ದು ಓದೋ ಅವಶ್ಯಕತೆ ಇರಲ್ಲ ಕೆಲವು ಟೈಮ್ ಅಡ್ಮಿಷನ್ ಇದ್ಬಿಟ್ರೆ
Copy this. I'm sorry, sir, I don't have the copy.
The accused has not examined the brother of the complainant to prove that the alleged check in question given to the said Narasimha Murthy.
ಅವರ
But at
ಅಣ್ಣನಿಗೆ
that time of cross examination, DW1 admitted that his house owner, one Narasimha Murthy, has also filed a check bounce case against him in CC number so and so Bangalore. And his shop owner Sushila has also filed PCR case against this accused. Though this accused has stated is the ignorance, and also he has stated that several persons have filed check bounce cases against him. Though he had denied the same, but on the fact basis of cross examination of DW1 and also the clear admission of accused at exhibit P1 check belongs to him, and also identified the signature of the accused belongs to him, it is clearly established that accused issuance of check in question was not honored. The legal notice sent to the accused is not served to the accused, but as per the acknowledgement of exhibit P 7 to 10. Clearly established that alleged notice was duly served to the accused. But he has taken the untenable contention that said legal notice was not served on him, and at that time, addressing on the so-and-so on merit, the complainant counsel furnished PAN card, so-and-so, and also the income tax returns for the year 2013-14. So that complainant is the income tax assessee, but he has not shown in the income tax returns about lending the amount of rupees 5 lakhs to the accused, but the accused counsel himself got elicited that alleged amount has been obtained from his father's friend, Babanna, an amount of rupees 2 lakh, and rest of the amount if collected from him, and same has been given to the accused by way of cash. In support of the case of accused, the respondent so and so your admission ಇದೆಯಲ್ಲ ನಿಮ್ದೇನೆ
2 days ನನಗೆ ಡಿಪೋಸಿಷನ್ 1 ನಿಮಿಷ ನೋಡಿ, ಒಂದು 3 days ಟೈಮ್ ಕೊಡಿ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಹಾಕೊಂಡು ನಾನು I have it along with this one 21-3 my lord.
Revision petitioner counsel seeks time on the ground that he is not having
Deposition.
the copy of the deposition, and hence list this matter on 21-3.
Petition. ಮೊಬೈಲ್ ಫೋನ್ ಸೀಸ್ ಮಾಡಿದ್ದಾರೆ, ಬಿಲ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀವಿ.
First time ನಿಮ್ಗೆ ನೋಟಿಸ್ ಆಗಿದೆ ಏನ್ರಿ ಇದು? ಆಗಿದೆ. ಹೇಳ್ರಿ ಕೌನ್ಸಿಲ್ ಹೇಳ್ರಿ.
ಮೊಬೈಲ್ ಫೋನ್ ಸೀಸ್ ಮಾಡಿದ್ದಾರೆ 14/5/21 ಅಲ್ಲಿ ಮೊಬೈಲ್ ಫೋನ್ ಸೀಸ್ ಮಾಡಿದ್ದಾರೆ.
ಮೊಬೈಲ್ ಫೋನ್
ಸೀಸ್ ಮಾಡಿದ್ದಾರೆ. ಪ್ರಾಪರ್ಟಿ ಹೌದು.
ಹಾ
2 years ಆಗಿದೆ. 2 years ಆಗಿದೆ, ಬಟ್ ಅದನ್ನ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಎಲ್ಲ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ.
ಏನಾಗಿದೆ?
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಎಲ್ಲ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ.
ಹಾ
ರಿಲೀಸ್ ಪ್ರಾಪರ್ಟಿ ರಿಲೀಸ್ ಮಾಡಕ್ಕೆ.
ಏನ್ರಿ ಮೊಬೈಲ್ ಏನ ಸೀಸ್ ಮಾಡಿದಿರಂತೆ?
This mobile is involved in the crime.
ಕ್ರೈಮ್. ಹಾ
It was used for the commission of offense.
ಆಯ್ತು, FSL ರಿಪೋರ್ಟ್ ಎಲ್ಲ ಬಂತಾ?
ಇನ್ನು ಬಂದಿಲ್ಲ sir.
ಬಂದಿಲ್ಲ ಅಂತಲ್ಲ FSL.
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಚಾರ್ಜ್ ಶೀಟ್ ಎಲ್ಲ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ.
ಹಾ
ಚಾರ್ಜ್ ಶೀಟ್ ಎಲ್ಲ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ.
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದಾರೆ.
ಹೌದು ಸರ್.
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದಾರೆ ಅಂತಲ್ರಿ?
ಕ್ರೈಮ್ ನಂಬರ್ 2020 ಮ್ಯಾಟರ್.
ಪೇಜ್ ನಂಬರ್
2020 ಮ್ಯಾಟರ್. ಕ್ರೈಮ್ ನಂಬರ್ 170
20 ಮ್ಯಾಟರ್ ಸೀಸ್ ಮಾಡಿದ್ದೆ ಅವಾಗ
21
13/2/2021.
21
ಅಲ್ಲಿ seize
ಮತ್ತೆ ಇನ್ನು ಇದು ಏನಕ್ಕೆ ಇಟ್ಕೊಂಡಿದ್ದೀರಿ ಮೊಬೈಲ್ ನ? 3 ವರ್ಷ
14 May 21 ಅಲ್ಲಿ ಸೀಸ್ ಮಾಡಿದ್ದಾರೆ.
If the release
21 ಅಲ್ಲಿ ಸೀಸ್ ಆಗಿದೆ.
seize ಆಗಿದೆ.
ಪೇಜ್ ನಂಬರ್.
Why you are keeping that mobile
It is used for the commission of offense.
from 3 years?
It is used for the commission of offense.
ಏನ?
It is used for the commission of offense.
ಇನ್ನೇನ್ ನಂಗೆ ಅರ್ಥ ಆಗ್ಲಿಲ್ಲ.
ಅಲ್ಲ, ಅದನ್ನ ಅಫೆನ್ಸ್ ಗೋಸ್ಕರ ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ.
ಆಯ್ತ್ರಿ, ಸೀಸ್ ಮಾಡಿದ್ಮೇಲೆ ಏನ್ ಮಾಡ್ಬೇಕು ನೀವು? FSL ಕಳ್ಸ್ಕೋಬೇಕು, ರಿಪೋರ್ಟ್ ತರ್ಸ್ಕೋಬೇಕು, ವಾಪಸ್ ಕೊಡ್ಬೇಕು. ಹೌ ಲಾಂಗ್ ಯು ಕ್ಯಾನ್ ಕೀಪ್ ದಿ ಮೊಬೈಲ್ ವಿತ್ ಯು? ಏನಾಗಿದೆ ನೋಡಿ, ವೆರಿಫೈ ಮಾಡಿ. FSL ರಿಪೋರ್ಟ್ ಬಂದಿದೆಯಾ?
ನೋಡ್ತೀನಿ.
ನೋಡಿಲ್ಲ? ನೋಡಿ ಮತ್ತೆ
ಪ್ರಾಪರ್ಟಿ ಫಾರ್ಮ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀವಿ.
21 ಇಂದ ಯಾಕೆ ನೀವು ಅವ್ನ ಮೊಬೈಲ್ ಇಟ್ಕೊಂಡು ಏನ್ ಮಾಡ್ತೀರಿ? ಏನ್ ಅಫೆನ್ಸ್ ಏನು?
302.
302. ಹಾ,
ಬಟ್
he is one of the culprit accused.
ಅಕ್ಯೂಸ್ ನಂಬರ್ 14 ಮೇಲೆ.
Accused number 14.
ಬಟ್ ಇವು
ಹಾ, ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಏನಿದೆ ರೀ ಮೆಟೀರಿಯಲ್ ಅವನ ಮೇಲೆ?
Charge sheet.
During the course of investigation, what you have collected? ಚಾರ್ಜ್ ಶೀಟ್ ಕಾಪಿ ಹಾಕಿಲ್ಲೇನ್ರಿ ನೀವು?
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ವಿ. ಪ್ರಾಪರ್ಟಿ ಫಾರ್ಮ್ ಹಾಕಿದೀವಿ.
ಏನ?
ಪ್ರಾಪರ್ಟಿ ಫಾರ್ಮ್ ಹಾಕಿದೀವಿ.
ಹಾಕಿಲ್ಲ.
ಪ್ರಾಪರ್ಟಿ ಫಾರ್ಮ್ ಹಾಕಿದ್ರಿ, ನಿಮ್ಮ ಮೇಲೆ ಅಲಿಗೇಷನ್ ಏನು ಅಂತ ಕೇಳ್ತಾ ಇದೀನಿ. ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ
ಅದು
ಏನು ಹಾಕಿಲ್ಲ ನೀವು?
ಏನು
ನೀವು ನೋಡಿ ತರ್ಸ್ಕೊಳ್ಳಿ, ಅಷ್ಟೊಳಗೆ ನೋಡಿ.
ಪ್ಲೀಸ್
ಅಷ್ಟೊಳಗೆ ನೋಡಿ.
ಆಯ್ತು.
ರೀಸನ್ ಫಾರ್ ಸೀಸಿಂಗ್ ಆಫ್ ಮೊಬೈಲ್ ಏನಾರು ಇನ್ಕ್ರಿಮಿನೇಟಿಂಗ್ ಮೆಟೀರಿಯಲ್ ಏನಾರು ಇದೆಯಾ,
ಅಕ್ಯೂಸ್
ಅಥವಾ ಏನಾರು ಕಳ್ಸಿದಾರ ಅದನ್ನ?
ಅಕ್ಯೂಸ್ ಜೊತೆ
ಯಾವ PF ಯಾವ್ದು ಹಾಕ್ತಿರೋದು ನೀವು?
PF
ಪೇಜ್
ನಂಬರ್
23 ಇದೆಯಲ್ಲ ಅದ?
23.
ರಿತಿನ್.
ಹೌದು.
ಐಫೋನ್ ಮೊಬೈಲ್ ನಂಬರ್ ಇದರಲ್ಲಿ
ಇದರಲ್ಲಿ ಅಕ್ಯೂಸ್ ಜೊತೆ ಫೋನ್ ಅಲ್ಲಿ ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಅಷ್ಟೇ ಸ್ವಾಮಿ. ಅದು ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಅಲಿಗೇಷನ್.
ಫೋನ್ ಅಲ್ಲಿ
ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ, ಫೋನ್ ನಮ್ಮ ಕಾಂಟ್ಯಾಕ್ಟ್ ಅಲ್ಲಿ ಇದ್ರು ಅಂತ ಅಷ್ಟೇ.
PF number 55.
ಕಾಲ್ ರೆಕಾರ್ಡ್ಸ್ ತರಿಸಿಕೊಂಡಿರ್ತಿರಲ್ಲ ನೀವು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡುವಾಗ. ವೈ ಯು ಹ್ಯಾವ್ ಟು ಕೀಪ್ ದಿ ಮೊಬೈಲ್? ಈಗ ಫೋನ್ ಮಾಡಿದ್ರೆ ಫೋನ್ ಮಾಡಿದ ಕಾಲ್ ಡೀಟೇಲ್ಸ್ ಇರುತ್ತೆ. ಕಾಲ್ ಡೀಟೇಲ್ಸ್ ತಗೊಂಡಿದ್ದೀರಾ ನೋಡಿ, ನೋಡ್ಕೊಂಡು ಹೇಳಿ.
1 week.
ಹಾ?
1 week.
1 week ತಗೊಳ್ಳಿ. HCGP seeks time to get the instructions and hence list this matter on 21-3.
Petitioner, my lord, so the relevant time was working as a sub-inspector of police. He was working as a sub-inspector of police in Ulimau police station.
Sub-inspector of police.
Police. On the allegations, my lord, he has demanded a sum of rupees 10,000 from CW1. Case came to be registered, please, my lord. Thereafter, investigation was carried out. Charge sheet was filed. My lord, after the charge sheet was filed for the offence under section 713(1)(d), section 13(2) of PC Act, please, my lord. He appeared before the court, took bail, and thereafter, please, my lord, he filed an application for discharge. My lord would find the order of the trial court at Annexure B, please, my lord.
Annexure G.
Annexure B. 23, so page. This was the, my lords, the order. But I would start from page number 24. Para 2, so. The accused was secured and supplied copies of the charge sheet as contemplated so and so. Thereafter, the case was posted for hearing before charge. After hearing both the parties, the charge for the offence punishable section so and so against the accused, and it was read over and explained to the accused, who plead not guilty and claimed to be tried. The prosecution, in order to bring home the guilt against the accused, taken out summons to CWs 1 to 3, and CW1, the complainant has been examined in chief on 3/10/2016, and he was cross-examined by the accused. CW1, Shri Prashant Kumar Thakur has been examined as PW2 and got marked document the sanction order at Exhibit P9, and he was cross-examined by the accused. The counsel for the accused submits that in view of the answers given by PW2, he is not the competent officer to issue sanction to prosecute the case, and requested to hear the arguments with regard to the validity and the competency of sanction order at Exhibit P9 issued by PW2. In view of the submission of the learned counsel for the accused, the case was posted for arguments with regard to validity and competency of the sanction order. My lord, at the end of, please, words, after hearing both the sides, please, lord. Page number 30 is the order, please. Accused is discharged for the time being. Operative portion. It is ordered to
start from time being.
For the time being. It is ordered to return the charge sheet to the investigating officer with a
Fresh sanction ತಗೊಳ್ಳಿ ಅಂತ.
Fresh sanction ತಗೊಳ್ಳಿ ಅಂತ. As against this order, please, lords. Page number 32, Annexure C. They filed a review petition, please, lords.
In petition?
Review of this recall of this order. That was dismissed by order dated 28/4/2017. My lord would kindly find it in page number 33. Thereafter, please, lords, they filed an application of the revision before this honorable court. As per Annexure D, please, lords. Annexure D may kindly be seen. Page number 34. Page number 36, I would start with. Para 4. Learned counsel for the revision petitioner vehemently contended that the learned child yet failed to consider that there was no necessity to obtain fresh sanction order in view of the circular passed by the government, and therefore the discharge order is incorrect, and thus sought for allowing the revision petition. Per contra, so and so, learned counsel for the respondent contended that there is a higher authority who has got the power to pass an order of sanction to prosecute. The said power cannot be delegated to a lower authority, and therefore the sanction order is incorrect. It is settled principles of law that an order of discharge does not amount to acquittal. Prosecuting agency has got every right to file fresh or supplementary charge sheet after curing defects, if any, in the sanction order. Even if the contention of the revision petition is accepted, by virtue of the circular issued by the government, the sanctioning authority was already issued a sanction order is perfectly valid. The same can be subject matter of fresh charge sheet or supplementary charge sheet. Reserving liberty for the Lokayukta to file fresh charges or supplementary charge sheet, this revision petition stands disposed of. My lord, this order, my lords, of the trial court was not set aside, saying that, my lord, the sanction order which is already there is perfectly valid. So liberty was given to these were disposed of with liberty to, my lords, the Lokayukta police to cure the defects, if any, and file supplementary charge sheet. And, my lords, even if the contention of the revision petition, they contended, my lord, there was a circular which enabled, my lord, PW11, who was the competent officer then, according to them, to issue the sanction order. They said, this honorable court said, even if by virtue of the circular, the sanction given by the competent authority is held to be valid, then it can be subject matter.
The same can be subject matter.
Fresh charge sheet. This was the direction given. Subsequently, please note, without complying with this direction or the order passed by this honorable court, they would refile the charge sheet before the court with the same the sanction order which was there, which was held to be invalid by virtue of a speaking order.
Fresh charge sheet ಹಾಕಿದಾರ ಇಲ್ಲ?
Fresh charge sheet ಹಾಕಿಲ್ಲ sir. Same charge sheet ಹಾಕಿದ್ದಾರೆ.
Fresh charge sheet ಅಂದ್ರೆ ಅದೇನು ಅದ್ರ ಜೊತೆ
ಅದನ್ನೇ
ಇಲ್ಲ.
along with the
ಸಬ್ಜೆಕ್ಟ್
circuit.
ಮ್ಯಾಟರ್ ಫ್ರೆಶ್ ಚಾರ್ಜ್ ಶೀಟ್ ಅಂತ ಇದೆ ಇಲ್ಲಿ.
That is what my lords the court said, court ordered.
ಹಾ.
But my lord, it appears they have filed the very same order,
Hmm.
very same charge sheet.
Hmm.
Subsequently,
Even if the contention of the revision petitioner is accepted by virtue of the circular issued by the government,
Please lords.
the sanctioning authority, who has already issued sanction order is perfectly valid. Who has already issued sanction valid. The same can be subject matter of fresh charge sheet ಅಂದ್ರೆ.
ಹೌದು. ಅಂದ್ರೆ
ಹಾಕಿದ್ವಿ
ಆ ನೋಟಿಫಿಕೇಶನ್ ಹಾಕ್ಬೇಕಷ್ಟೇ.
ಹಾಕಿದ್ವಿ
ಹಾಕ್ಬೇಕಾಗಿತ್ತು. ಅವ್ರು ಹಾಕ್ಲಿಲ್ಲ.
ಹಾಕಿದಾರಂತಲ್ಲ
ಹಾಕಿದ್ವಿ
notification.
That is what my lords is. I have applied for the certificate copy. I did not find it.
ಆಯ್ತು
My lord,
ನೋಡಿ.
curiously enough, please lords,
ಏನಿದೆ fresh charge sheet?
my lord would kindly see.
I'll place it that circular and the
ಹಾ.
C&R rules.
ಹಾ.
Before that,
ನೋಟಿಫಿಕೇಶನ್ ಇದೆಯಾ?
ಹೌದು
ಅದನ್ನ ಹಾಕಿದ್ರ ನಿಮ್ charge
ಹಾಕಿದೀವಿ
sheet?
along with
charge
the-
sheet ಜೊತೆ?
ಹೌದು
ಹಾ, ಎಲ್ಲಿದೆ ಅದು? ನೋಡ್ರಿ, ಹಾಕಿದಾರಂತಲ್ಲ?
ಅಲ್ಲ ಅದು
Along with
ಹಾಕಿದ್ರೆ
charge sheet.
ಅಲ್ಲ ಹಾಕಿದ್ರೆ ಸ್ವಲ್ಪ. No, this is what my lords happened.
ನೋಟಿಫಿಕೇಶನ್ ಜೊತೆ
ಇಲ್ಲ,
ಹಾಕಿದಾರ?
I would come to that, please.
ಹಾ.
My lords, this is, my lords, they failed, they refiled the charge sheet. Thereafter, please, my lords, this honorable court, the honorable trial court, without issuing notice to me, my lord, it passed an order. My lord, kindly see, this is the order.
Hmm.
Which said, my lord, the Honorable High Court of Karnataka, by its order dated 23/10/2021,
23?
granted liberty, ಅಲ್ಲ, ಇದು 21 to
ಯಾವ ಆರ್ಡರ್ ಓದ್ತಾ ಇರೋದು?
ಇದರಲ್ಲಿ
ಪೇಜ್ ನಂಬರ್ 39 ಅಲ್ಲಿ ಇದೆಯಲ್ಲ ಅದ?
one ನಿಮಿಷ.
again they filed a discharge application.
ಹೌದಾ?
Before that.
Against the accused for the offense punishment. After filing of the charge sheet, cognizance of the offense was taken and the charge sheet was framed.
My lord, kindly turn to page number 39.
39 ಓದ್ತಾ ಇರೋದು.
Please, lords. I would start from,
Both the parties as per order dated surrounded, this court was pleased to hold that the sanction secured by the prosecution was not valid and returned the charge sheet with a direction to obtain fresh sanction order from the so-and-so, agreed by the said order, so-and-so, settled principle of law that order of discharge does not amount to acquittal. Even if the contention of the reason accepted after disposal of the above resolution, the police inspector has resubmitted the same charge sheet against the after a resubmission of the charge sheet, this court passed an order on 29/29 restoring the case and issued summons to the accused, and in furtherance his presence came to be secured. The learned counsel appearing on behalf of the accused has submitted that since already an order came to be passed by discharging the accused, whether the court is required to take fresh cognizance has to be decided. He further submitted that in the revision petition issuing regarding the validity of the sanction order is not conclusively decided by the High Court. The order passed by this court discharging the accused on the ground of validity of the sanction is not decided by the Honorable High Court. The burden is on the prosecution to clarify whether the sanction accorded by the Commissioner of Police is valid and issued by the competent authority. After disposal of the revision petition by the Honorable High Court, the prosecution has not filed a fresh or additional sanction. The learned public prosecutor has submitted that prosecution is ready to comply any order passed in this regard by this court.
please.
This proceeding before passing of the discharge of the case, the prosecution has examined PW2 Additional Commissioner of Police and he has recorded evidence sanction. After considering evidence of PW2 sanction order on made, this court passed an order dated so-and-so discharge. Honorable High Court, its order dated so-and-so granted liberty to the police to file so charge sheet. Hence, it is for the prosecution to prove that by virtue of circular issued by the government, PW2 is the competent authority to accord sanction to the so-and-so is valid. Whether sanction order produced by the prosecution along with charge sheet is valid or not is a matter of trial. It is settled law that absence of sanction can be hesitated at any stage, but the validity of the sanction can be challenged only during the trial. In view of the discharging of the accused as per order dated so-and-so, this is resuming. Resubmitting of the charge sheet by the prosecution, taking of fresh cognizance of the case is necessary from the material placed on record. Contents of the pre-trap and trap master so-and-so, there are sufficient materials to take cognizance. So, ನೀವು ಮತ್ತೆ challenge ಮಾಡ್ಕೊ ಬಂದಿರೋದು ಕಾಗ್ನಿಜೆನ್ಸ್ ತಗೊಂಡಿದ್ರ ಮೇಲೆ
What happened, my lord, when see in page number 34, which my lord, my lord just
ಅಪ್ಲಿಕೇಶನ್
read.
ಡಿಸ್ಚಾರ್ಜ್ ಅಪ್ಲಿಕೇಶನ್
Discharge.
ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಸ್ವಾಮಿ, ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಫ್ರೆಶ್ ಚಾರ್ಜ್ ಹಾಕಿದ್ರಲ್ಲ, ಫ್ರೆಶ್ ಚಾರ್ಜ್ ಹಾಕಿದ್ರು. ಹಾಕಿದಾಗ ಸ್ವಾಮಿ, this is the order which was passed by the learned judge, please, my lords, in my absence, without my notice. But this is what, my lords, the page number 34. The learned process, the page number 42, please, page number para 4.
ನಿಮ್ಗೆ ಕಾಗ್ನಿಜೆನ್ಸ್ ತಗೊಳ್ಳುವಾಗ ನಿಮ್ಮನ್ನ ಕೇಳ್ಬೇಕು ಅಂತಿಲ್ಲ.
ಅಲ್ಲ, correct, sir. My lords, may kindly see, if my lords, the court has held that, my lord, that the earlier sanction, fresh cognizance,
Now the order impugned, what is the impugned order? counsel?
impugned order is, my lords, thereafter, please, my lords, after this matter was restored, I filed another, my lords, the
Application for discharge.
please, my lords.
ಆಯ್ತು.
In that, please, my lords, the court said, annexure A, please, my lord, page 25, 24. 23, it starts, my lord, 24. I would, my lords, skip, my lords, page number 25 also. Page number 26, please, my lord, reasons.
26 already, 2022 nal is order.
I'm sorry, please.
Paragraph
I'm sorry,
number eight.
I'm sorry, please. Page number 18, please.
Para 9 nodi.
Please, lords.
But while deciding the criminal petitions, also
True that,
matter to the charge sheet, supplementary charge sheet directed to file by the agency. Thus, the question of instituting the investigating agency by this court to obtain the correction would not arise. Here, the learned counsel for the accused is not disputing the correctness or otherwise of the charge sheet. Rather, his grievance is that the prosecution sanction is defective in nature. This type of contention is beyond the observations made by the Honorable High Court on the one hand and misleading this court on the other hand. Therefore, I find no necessity for further discussion to hold that the present application is devoid of merits accordingly. I pass the following.
My lord, earlier, please, my lord, the very same court, please, my lord, has held that this sanction order itself was invalid.
Sare re, other male revision
No, my lord,
Can you see the revision order?
my lord, may kindly see, in the revision petition, the order of the trial court was not set aside. It was not said that, my lord.
Why the word has to be used as set aside, Anta? Then
Yes,
you see the order of the court.
Please, my lord.
Revision order.
My lord, may kindly see. My lord,
Revision order is very clear.
my lord, may kindly see now.
If the contention of the revision petitioner is accepted by virtue of the circular issued by the government,
Also,
and the government circular is enta.
idrunu kuda,
The sanctioning authority who has already issued sanction order is perfectly valid anta heltaralla.
if that is perfectly valid, again, that will be subject matter of the fresh from sentencing ಅಂತ ಹೇಳ್ತಾರೆ sir.
ಹೌದು ಫ್ರೆಶ್ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದಾರಲ್ಲ ಈಗ.
ಅಲ್ಲ ಅದೇ ಸರ್, ಅದ್ರಲ್ಲಿ ಏನಂತಂದ್ರೆ,
ಚಾರ್ಜ್ ಶೀಟ್ ಜೊತೆ ನೋಟಿಫಿಕೇಶನ್ ಹಾಕಿರ್ತಾರೆ.
that was not brought to the notice of the court. That was not brought to the notice of the court. The contention, my lord, of the prosecution that, my lord, they have filed the additional charge sheet or the supplementary charge sheet curing the defect ಅಂತ ಎಲ್ಲೂ ಹೇಳಿಲ್ಲ ಅವರು. My lord would kindly see in annexure.
ಅಂತ ಹೇಳೋ ಅವಶ್ಯಕತೆ ಇಲ್ಲ.
ಅಲ್ಲ ಸರ್, ಅದರಲ್ಲಿ ಅಲ್ಲಲ್ಲ.
Notification itself is enough ಅಂತ.
My lord may kindly see that was not brought to the notice of the court.
ಹಾಕಿದಾರ ಇಲ್ರಿ ಫೈಲ್ ಆಗಿ ಚಾರ್ಜ್ ಶೀಟ್
That is
ಮಾಡುವಾಗ.
not there, please, according to my knowledge, please, because I obtained the circular copy.
ಅಡಿಷನಲ್ ಚಾರ್ಜ್ ಶೀಟ್ ಜೊತೆ ಕೊಡಿ. ಎಲ್ಲಿದೆ ಕೊಡಿ ಇದು ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ. ಇದು ನೀವು ಕೋರ್ಟ್ ಮುಂದೆ ನೋಟಿಫಿಕೇಶನ್ ಇದೆ ರೀ, ಕೋರ್ಟ್ ಮುಂದೆ ಹಾಕಿದೀರಾ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
ಹಾಕಿದೀವಿ along with the charge sheet.
That was not brought to the
ಅಲಾಂಗ್
notice of the
ವಿತ್
court.
ಫ್ರೆಶ್ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ರಲ್ಲ.
ಹೌದು.
ಎಲ್ಲಿದೆ ಅದು ತೋರಿಸಿ ಎನ್ಕ್ಲೋಸರ್ಸ್. ನಿಮ್ ಅಲಾಂಗ್ ವಿತ್ ಚಾರ್ಜ್ ಶೀಟ್ ಜೊತೆ ಎನ್ಕ್ಲೋಸರ್ ಇರ್ತದೆ. ನೀವು ಯಾವ್ದೇ ಒಂದು ರೆಕಾರ್ಡ್ ನ ಹಾಕ್ಬೇಕಾದ್ರೆ ಕೋರ್ಟ್ಗೆ ಎನ್ಕ್ಲೋಸರ್ಸ್ ಇರುತ್ತೆ ಏನೇನಿದೆ ಅಂತ. ಅದರಲ್ಲಿ ನೋಟಿಫಿಕೇಶನ್ ಇದೆಯಾ ಇಲ್ಲ? ಲಾಸ್ಟ್ ಪೇಜ್ ಅನ್ನು ಅವ್ರದ್ದು ಲಾಸ್ಟ್ ಪೇಜ್ ಇರ್ಬೇಕು.
ನೀವೇನು ಪ್ಲೀಸ್ ಮಾಡ್ಸ್.
ನೀವು ಫ್ರೆಶ್ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದಾಗ ಆ ನೋಟಿಫಿಕೇಶನ್ ಎನ್ಕ್ಲೋಸ್ ಮಾಡಿದ್ರೆ ಇಲ್ಲ.
That index.
ಇಂಡೆಕ್ಸ್ ಅಲ್ಲಿ ನೋಡಿ ಹೇಳ್ರಿ, ಬೇರೆ ಏನಾದ್ರು ಗ್ರೌಂಡ್ ಇದೆಯಾ?
They may not, they filed, of course, I did not produce it before this honorable court. On 4/11/2023, please, madam. On 4/11/2023, they filed an application before the court saying that, my lord, ಈ ಮಧ್ಯೆ ದಿನಾಂಕ 10/4/2023 ಉಲ್ಲೇಖಿತ ಪ್ರಕರಣದ ದೋಷಾರೋಪಣ ಪಟ್ಟಿಯನ್ನು ಅಭಿಯೋಗ ಮಂದಿರ ತ್ಯಾಜಿಸುವ ಕುರಿತು ಇನ್ನೂ ಹೆಚ್ಚಿನ ತನಿಖೆ ಅವಶ್ಯಕತೆ ಇದ್ದು ಮುಂದಿನ ದಿನಗಳಲ್ಲಿ ಹೆಚ್ಚುವರಿ ದೋಷಾರೋಪಣ ಪಟ್ಟಿ ಸಲ್ಲಿಸಲಾಗುವುದು ಗಣನೆಯಾದ ನಿಲ್ಲಿಸಿಕೊಳ್ಳಲಾಗಿತ್ತು.
ಅದು ಫಸ್ಟ್ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕುವಾಗ
ಈಗ ಸರ್,
ಈಗ ಮತ್ತೆ
4/11/23 ಪ್ರಸ್ತುತ ಈ ಪ್ರಕರಣದ ತನಿಖೆಯನ್ನು ಮುಕ್ತಾಯಗೊಳಿಸಿದ್ದು CRPC ಕಲಂ 173(8) ಅಲ್ಲಿ ರೀತಿಯ ಗಣನೆಯಾಗಿ ಸಲ್ಲಿಸಲು ಯಾವುದೇ ಹೆಚ್ಚುವರಿ ಸಾಕ್ಷ್ಯಗಳು ಇರುವುದಿಲ್ಲ. ಸದರಿ ಮಾಹಿತಿಯನ್ನು ಗಣನೆಯನ್ನು ನಿಲ್ಲಿಸಿಕೊಂಡಿರ್ತಾರೆ. That is what, my lords, he said, saying that, my lord, this is the basis, please, my lords, for the court to hold that, my lord, the earlier sanction order was valid. No, that is wrong, please, my lords. That is my humble submission. Because the very same court, please, my lord, said
earlier sanction is valid subject to the notification ಅಷ್ಟೇ.
ಅಲ್ಲ, subject to notification produce ಮಾಡಬೇಕಲ್ಲ ಸರ್, ಅವ್ರು produce ಮಾಡಿಲ್ಲ ಅದನ್ನ. My lord, kindly see in annexure E, which my lord read, please, my lords, page number 42, page number 42, para 4, sorry.
42 para 4.
Also, the learned counsel appearing on behalf of the accused has submitted that since already an order came to be passed by discharging the accused, whether the court is required to take fresh cognizance has to be decided. He further submitted that in the revision petition issue regarding the validity of sanction order is not conclusive reason with the Honorable High Court. The order passed by this court discharging the accused on the ground of validity of sanction is not decided by the Honorable High Court. The burden is on the prosecution to clarify whether the sanction accorded by the Commissioner of Police is valid and issued by the competent authority. After disposal of the revision petition by the Honorable High Court, the prosecution has not filed fresh or additional sanction. The learned public prosecutor submitted that prosecution is ready to comply any order passed in this regard by the court. But they did not accept, they did not say, my lord, that they have cured the defect They have filed this circular, and on the basis of that, they want to seek further
Notification ಹಾಕಿದ್ರೇನ್ರಿ
Once-
along with.
I'll secure the entire charge, entire index of the charge sheet I'll secure.
ಬೇಕಲ್ಲ ಅದು?
I'll secure Monday.
If
That
you
is
have,
one as-
if you have filed that notification, then,
Please.
once. Innondanದ್ರೆ,
The
one
review
is- kindly
application.
visualize the situation. My lord, this honorable court, the trial court was pleased to discharge the accused. Thereafter, prisoners, they filed before, they came before this honorable court. Thereafter, prisoners, they filed another charge sheet. That is the same charge sheet, according to my information and the charge sheet, the copy I've got. My lord, if the court, my lord, has set aside the order passed by the learned trial judge, as my lord pointed out, prisoners, then the question of, my lord, fresh cognizance would not arise.
Fresh?
Fresh cognizance would not arise. The proceedings would be taken away, would be proceeded with from the stage where it was dropped. My lord, kindly see.
then you consent, let them continue with the evidence of PW2.
No. That is what is held by the learned session judge, please, madam. That is not set aside by the honorable court.
ಯಾವ್ದನ್ನ?
Sanctions
Set
given by
aside ಅಂತ word use
PW2.
ಮಾಡಿಲ್ಲ.
Then you make submission before the court, proceedings has to be continued, subject to
ಅಲ್ಲಲ್ಲ,
the,
ನಾನು ಅದನ್ನ ಹೇಳ್ತೀನಿ sir.
subject to the proving
no.
of sanction ಅಷ್ಟೇನೆ.
My
ನಿಮ್
contention,
contention ಏನು? Sanction is not valid ಅಂತ.
ಹೌದು.
But now they contend that in view of the notification so and so, the sanction is valid ಅಂತ. Allow them to produce the notification and further
Sir,
examine
if they produce it,
further
please,
examine the PW2.
madam, if they
You
produce it,
cannot come in the way in proceeding against you on the ground that no sanction anta.
no.
Because
that is-
this court already comes to the conclusion that even if the said notification issued by the circular, the sanction authority who has already issued sanction order is perfectly valid.
No, if
The
that,
same can be subject matter of fresh charge sheet ಅಂತ ಹಾಕಿದ್ದಾರೆ.
that is what is, my lord, the
ನೋಡ್ರಿ
interpretation.
ಈ ಅಬ್ಸರ್ವೇಶನ್ ಏನ್ ಮಾಡಿದ್ದಾರೆ,
ಹೌದು.
ಅದ್ರ ಮೇಲೆ ಅವ್ರು ಫ್ರೆಶ್ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರೆ.
ಇಲ್ಲ ಸರ್, ಅದನ್ನ ಹೇಳ್ತಾರೆ ನಾನು. That is not complaint ಅಂತ.
ಆ?
My lord, what the
It's
court
not
observed.
permitted ಅಂದ್ರೆ you have to challenge this order before the
No,
appropriate
please, my lord,
court.
I need not challenge it. My lord, kindly see, kindly read this order.
You cannot
The
do hot and
interpretation
cold
of,
counsel.
no, I'm not blaming, I'm not blowing that, please, my lord. I'm not
ಮತ್ತೆ?
blowing. My lord, kindly see, what is the
But that is not
interpretation?
correct ಅಂತ ನೀವ್ ಹೇಳ್ತಾ ಇದ್ರಿ. ಈ ಆರ್ಡರ್
No,
ನಾಟ್ ಕರೆಕ್ಟ್ ಆದ್ರೆ
Correct
not
ಅಲ್ಲ
correct
sir. ನಾನು ಹೇಳ್ತಾ ಇರೋದು ಏನಂತಂದ್ರೆ, my lord, what the court has said is, even if the contention of them saying that the circular issued by competent authority is perfectly valid, then the same can be subject matter of fresh charge sheet or supplementary charge sheet.
ಅಷ್ಟೇ.
My lord, then I would be having, my lords, the liberty is given to me if they file this, my lords, the circular, which they contend that there is a circular. If they file the circular before the trial court, this honorable court has reserved me the liberty to say that, my lord, the same can be subject matter of fresh charge sheet.
Reserving liberty for the Lokayukta to file fresh supplementary charge sheet. This revision petition stand disposed of ಅಂತ
Correct.
ಮಾಡಿದ್ದಾರೆ.
ಅದೇ ನನಗೆ ನಾನು ಅದಕ್ಕೆ
Now
last
they have filed the supplementary charge
last
sheet
time,
also.
this is what, my lord, the interpretation of this order came. But on the first occasion, please, my lord, when the matter was disturbed before this honorable court, my learned friend said that the matter may be placed before the very same judge who has passed this order. However, please, my lord, this honorable court, my lord's learned
Just
clerks in
clarified.
office, rejected that prayer.
The
And
last date it was clarified. Kindly see the last date order.
ಏನಂತಿದೆ?
I was not there.
There is no bar to hear the matter.
ಯಾವಾಗ್ಲೂ ಇಲ್ವಲ್ಲ ಆ ತರ?
First letter is. So they made the prayer for my lord's.
There shall be stay further proceedings ಅಂತಾನೆ ಮಾಡಿದ್ದಾರೆ. Till the next state of hearing.
The detail order is passed.
Detail order has been passed.
The
ಇನ್ನು
court.
4-5 ಪೇಜ್ ಬರ್ದಂಗಿದೆ. ಈಗ ಸ್ಟೇ ಆಗಿದೆ ಕೆಳಗಿನ ಪ್ರೊಸೀಡಿಂಗ್ಸ್. ಆಯ್ತು. ಸೇಮ್ ಜಡ್ಜ್ ಮುಂದೆ ಹೋಗ್ಬೇಕು ಅಂತ ಎಲ್ಲಿದೆ?
ಅಲ್ಲ ಇಲ್ಲ ಸರ್, ನಾನು ಹೇಳಿದ್ದು ಅದು ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ಇದೆಯಲ್ಲ, ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ಆಫ್ ಪ್ಯಾರಾ ನಂಬರ್ 7 is what is, my lords, is the question now. But the contention, my lords, their contention, even if that is said, that is the circular issued by the government, holding that the competent authority, the sanction given by the competent authority is perfectly valid, comma, the same can be subject matter of fresh charge sheet or supplementary charge sheet.
No.
Which means, my lord, if they file it before the court, then I would be having a liberty, or I would have a right to, my lords, challenge that and seek discharge if it is not valid.
ಬಟ್ ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಈಗ ಆರ್ಡರ್ ಆಗಿರೋದು ಯಾವ್ದ್ರ ಮೇಲೆ?
ಅದ್ರ ಮೇಲೆ ಸರ್,
ಈಗ ಇಂಪ್ಯೂಂಡ್ ಆರ್ಡರ್ ಏನ್ರಿ?
impugned order.
Discharge ಹಾಕಿರೋದು.
ಡಿಸ್ಚಾರ್ಜ್ ಅಪ್ಲಿಕೇಶನ್ ಮೇಲೆ.
Correct, sir. No, now the sanction is, my lords, fresh cognizance taken on the basis of the, fresh cognizance is taken on the basis of the very same, my lord, sanction order which has been held to be invalid.
ಫ್ರೆಶ್ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ಮೇಲೆ ಕಾಗ್ನಿಜೆನ್ಸ್ ತಗೋಬೇಕೋ ಬೇಡ?
ಅಲ್ಲ ಸ್ವಾಮಿ,
ಮಾಡಿದಾರೆ ಅವರು.
ಅಲ್ಲಲ್ಲ ಈ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಸ್ವಾಮಿ, if my lords were to find,
ಈಗ ಏನಾಗ್ಬೇಕಿತ್ತು ಅರ್ಲಿಯರ್ ರಿವಿಷನ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ,
ಹೌದು,
if court comes to a conclusion that in view of the notification dated so and so,
ಹೌದು,
the sanction is valid, then the revisional court ought to have given direction to proceed before the trial court by placing the document
ಹೌದು
and marking of document
Please.
PW2 and proceed further ಅಂತ ಮಾಡ್ಬೇಕಿತ್ತು.
ಅದೇ ಅದು
ಹಾಗೆ ಮಾಡಿಲ್ಲ.
ಅಲ್ಲಲ್ಲ
But
ಮಾಡಿಲ್ಲ
anyhow, this court has given
ಮಾಡಿಲ್ಲ
direction
ಅಂದ್ರೆ ಯಾಕೆಂದ್ರೆ ಸ್ವಾಮಿ,
to file supplementary charge sheet ಅಂತ.
ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಯಾಕೆಂತಂದ್ರೆ the order of the learned trial judge granting the allowing the discharge application to the extent of giving liberty to the local police to file fresh charge sheet has been saved.
ಹೌದು.
Which my lord, that order is not set aside by the dishonorable court in the revision
Observation
petition.
ಇದೆಯಲ್ರಿ?
ಸ್ವಾಮಿ
Observation.
ಸ್ವಾಮಿ ಅಬ್ಸರ್ವೇಷನ್ ಇದ್ರೆ ಸ್ವಾಮಿ, why would my lord the
ಆಯ್ತ್ರಿ, now they have filed the supplementary charge sheet.
No,
Based on the supplementary charge sheet, now they have taken the cognizance. Now you have filed an application to 227.
in the supplementary charge sheet, please, my lords, they did not bring it to the notice of the court that, my lord, they have filed this particular circular before the court. That is what is, my lord, I'm submitting. If they are submitted, that is not.
Notification ಹಾಕಿದಾರ
It is
notification.
already the part of record. Review application was filed along with the circular only.
No, that
The
was
part
not
of
the
the
charge sheet.
record.
That was
Review
not the charge sheet.
Review application ಏನ್ ಹೇಳಿದಾರ ಅವರು? Round end.
Order cannot be recalled ಅಂತ ಮಾಡ್ತಾರೆ.
This application dated 227 of CPC is filed on behalf of the accused with a prayer for discharge in respect of offense punishable under section so and so. Whereas the prosecution has not filed objections despite repeated opportunities have been provided. Only on the ground that same would be filed after submitting additional charge sheet by the investigation officer under section 1, same is placed on record. After hearing from both the side with reference to the material on record, the point as hereunder would arise for the consideration. ಈಗ ನೀವೇ supplementary charge sheet ಹಾಕಿದೀರ ಮತ್ತೆ?
Fresh charge sheet along with circular file ಮಾಡಿದ್ರು.
According to,
ಆಯ್ತ್ರಿ, 173(8) ಅಲ್ಲಿ ಏನೋ ಹೇಳಿದಾರಲ್ಲ.
ಇಲ್ಲ sir.
Same would be filed after submitting additional charge sheet by the investigating officer under section 173(8) of CRPC ಅಂತಿದೆ.
Yes.
ನಿಮ್ submission. You have not filed objections to this application. ಹೌದಾ?
Did not file bill.
Same would be filed. But only on the ground that the same would be filed after submitting additional charge sheet by the investigating officer under section 173(8) of CRPC ಅಂತಿದೆ. Paragraph number 2 ಓದಿ, trial court order.
After that, please note, they filed an application before the court saying that ಪ್ರಸ್ತುತ ಈ ಪ್ರಕಾರ ದೋಷಪಟ್ಟ ಮಂಜೂರಾತಿ ಆದೇಶ so ಮುಂದಿನ ಇನ್ನೂ ಹೆಚ್ಚಿನ ತನಿಖೆ ಅವಶ್ಯಕತೆ ಇದ್ದು ಮುಂದಿನ ದಿನಗಳಲ್ಲಿ ಹೆಚ್ಚುವರಿ ದೋಷಗಳ ಪಟ್ಟಿ ಸಲ್ಲಿಸಲು ಘನ ನ್ಯಾಯಾಲಯದ ಅನುಮತಿಯನ್ನು ಕೋರಿದೆ. This is what they submitted.
That is your request to file additional charge sheet under section 173(8). Have you filed any additional charge sheet?
No, my lord, we are not filed any additional charge sheet. We have filed a
additional charge sheet ಇದೆಯಾ ಇಲ್ಲ ನಿಮ್ಮ ಹತ್ರ?
fresh charge, same charge sheet was filed along with circular.
ಫೈಲ್ ಮಾಡಿದ ಮೇಲೆ,
Please,
when they have filed a discharge application,
please.
you filed a memo, now he is reading, stating that you are going to file supplementary charge sheet and reserved your right under section 173(8).
Please.
ಈಗ ಹಾಕಿದಿರಾ?
ಇಲ್ಲ, ಹಾಕಿಲ್ಲ.
ವೆರಿಫೈ ಮಾಡಿ.
Please.
ಒಂದು. ಎರಡನೇದು ನೋಟಿಫಿಕೇಶನ್ ಹಾಕಿದಿರಾ? ಅಡಿಷನಲ್ ಚಾರ್ಜ್ ಹೊಸದಾಗಿ ಫ್ರೆಶ್ ಸಪ್ಲಿಮೆಂಟರಿ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದಿರಲ್ಲ.
Please.
ಯಥಾವತ್ತಾಗಿ ಹಳೇದನ್ನೇ ಹಾಕಿದಿರಾ ಅಥವಾ ಮತ್ತೇನಾದ್ರು ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿದಿರಾ? ಯು ಎಕ್ಸಾಮಿನ್ ಅಂಡ್ ಮೇಕ್ ಸಬ್ಮಿಷನ್ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್.
Lord,
Heard the revision petitioner council and also the council appearing to the state and the state alla idu ಲೋಕಾಯುಕ್ತ ಅಲ್ಲ? ಲೋಕಾಯುಕ್ತ. And ಲೋಕಾಯುಕ್ತ council would submit that he is going to verify whether any additional charge sheet is filed under section 173(8) and also verify and submit with regard to whether any additional documents are produced while filing the supplementary while filing the fresh charge sheet against the petitioner. List this matter on yavat ಬೇಕು ಹೇಳಿ. 21(3).
please.
21(3).
Memo. ಗಲಾಟೆ ಹಾಕಿಲ್ಲ ನೀವು ಹಾಕಿದ್ರಿ. Filed a memo seeking an extension of time, 2 week time to deposit the amount ordered by San Court because his shops have been destroyed due to fire.
ಏನ್ ಹೇಳಿ?
The Lordship was, the San Court was pleased to direct me to deposit 50%.
ಆಯ್ತು, ಮಾಡಿದಿರಿಲ್ಲ?
Already ಮಾಡಿದ್ದೀನಿ, but ಮಾಡಿಲ್ಲ. Another 2 weeks I am seeking because his shop has been destroyed due to fire accident. That is my request for amount.
ಸರ್, ಈಗ ಡೆಪಾಸಿಟ್ ಮಾಡಿದಿರೇ ಇಲ್ಲ ಅಷ್ಟೇ ಪ್ರಶ್ನೆ.
20% ಮಾಡಿದ್ದೀನಿ, ಗ್ಯಾಸ್
20% ಅಲ್ಲ, ದಿಸ್ ಕೋರ್ಟ್ ಡೈರೆಕ್ಟ್
ಅದನ್ನು ಮಾಡಿಲ್ಲ, ಅದಕ್ಕೆ
ಮಾಡಿಲ್ಲ.
2 weeks.
ಮಾಡಿಲ್ಲವ್ರು ಮತ್ತೆ ಟೈಮ್ ಕೊಡೋದಿರಲ್ಲ. ನೀವು ಅಡ್ಮಿಷನ್ ಲಿಸ್ಟ್ ಆಗಿದೆ ಹೇಳಿ.
Reason is that the entire issue, the shop is.
Council, you have not filed any application for extension of order. ಡೆಪಾಸಿಟ್ ಮಾಡಕ್ ಟೈಮ್ ಕೇಳಿದಿರಾ?
To Monday.
ಟೈಮ್ ಕೇಳಿದ್ರೇನ್ರಿ?
But I file
Today
application.
matter is listed for admission, you argue.
Okay.
Don't do all this. You people won't respect the order of the court. And also you have not filed any application for extension of time for depositing the amount. Now when the matter is listed, now you are seeking time. Argue on merits. Admission gate ಏನಿದೆ ನೋಡೋಣ.
For amount you will also turn to the complaint. Complaintly.
Grounds entry.
What is ಹೇಳ್ತಾ ಇದೀನಿ.
What is your
21% ಮೇಲೆ.
What is your defense before the trial court?
21%.
First of all, you have not led any evidence before the trial court.
No evidence.
Have you led any evidence?
Evidence ಮಾಡಿಲ್ಲ, but class exams admitted.
ಆಯ್ತು, ಏನ್ ಅಡ್ಮಿಷನ್ ಆಗಿದೆ?
For amount you will also pay. I am relying on the exhibit P16. Exhibit P16 is the.
PW1 cross examination evidence ಕೊಡ್ರಿ ಮೇಡಮ್. ಇಸ್ಕೊಳ್ಳಿ ಅವ್ರ ಹತ್ರ.
ಇಲ್ಲ, ಮಾರ್ಕ್ ಮಾಡಿದ್ದೀನಿ. Certain persons have been marked. Even authority given is not spent the person who authorized him to file a complaint. That is the admitted fact.
ಚೆಕ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಇಲ್ಲ ಅಷ್ಟು ಹೇಳಿ ಫಸ್ಟ್. ನಮ್ಮ ಫಿರ್ಯಾದರ ಸಂಸ್ಥೆಗೆ ನನಗೆ ಸಂಪೂರ್ಣ ಮಾಹಿತಿ ಇದೆ. ನಮ್ಮ ಸಂಸ್ಥೆ ಹಣ ಲೇವಾದೇವಿ ಮಾಡುವ ಪರವಾನಗಿಯನ್ನು ಸಂಬಂಧಪಟ್ಟ DR ಕಚೇರಿಯಿಂದ ಪಡೆದುಕೊಂಡಿದೆ. ಹಣ ಲೇವಾದೇವಿ ಮಾಡುವ ಪರವಾನಗಿಯನ್ನು 2001ರಲ್ಲಿ ಪಡೆದುಕೊಂಡಿದ್ದೇವೆ. ಹಣ ಲೇವಾದೇವಿ ಪರವಾನಗಿ ಕ್ರಮಬದ್ಧವಾಗಿ ನವೀಕರಿಸುತ್ತಾರೆ. ಸರಿ, ಸಾಕ್ಷಿ ಸ್ವತಃ ನವೀಕರಿಸಿಕೊಂಡಿದ್ದೇವೆ ಎಂದು ಕೇಳುತ್ತಾರೆ. 2018ರಲ್ಲಿ ನಮ್ಮ ಸಂಸ್ಥೆ ಪಡೆದುಕೊಂಡಿದ್ದ ಲೇವಾವಧಿ ಪರವಾನಗಿ ನವೀಕರಿಸಿಕೊಂಡಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಮ್ಮ ಸಂಸ್ಥೆಯ ಇಲ್ಲಿವರೆಗೆ ಹಣ ಲೇವಾದೇವಿ ಮಾಡುವ ಪರವಾನಗಿಯನ್ನು ಸರಿಸಿಕೊಳಿಸಿಕೊಂಡಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಮ್ಮ ಫಿರ್ಯಾದಾರ ಸಂಸ್ಥೆ ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಸಂಸ್ಥೆ, ನಮ್ಮ ಫಿರ್ಯಾದಾರ ಸಂಸ್ಥೆಗೆ 6 ಜನ ಪರದಾರರು ಒಬ್ಬನೇ ಶಿವಲಿಂಗಪ್ಪ ಮಾಡುತ್ತಾರೆ ಎಂದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಅವರು ಬಸವನಗುಡಿಯಲ್ಲಿ ವಾಸ ಇದ್ದಾರೆ. ತಿಮ್ಮೇಗೌಡರು ವೈಯಕ್ತಿಕ ವಿಚಾರ ಗೊತ್ತಿದ್ದರು ಎಂದು ಸುಳ್ಳು ಹೇಳುತ್ತಿದ್ದೇನೆ. ಸ್ವತಃ ತಿಮ್ಮೇಗೌಡರು ನಮ್ಮ ಫಿರ್ಯಾದಾರ ಸಂಸ್ಥೆ ಮಾಡುವ ವ್ಯವಹಾರ ಗೊತ್ತಿದೆ ಎಂದು ಹೇಳುತ್ತಾರೆ. ತಿಮ್ಮೇಗೌಡರು ಆರೋಪಿಗೆ ಹಣ ವಾಪಸ್ ಕೊಡಬೇಕಾಗಿದ್ದುದರಿಂದ ಪಾಲುದಾರಿಕೆ ಸಂಸ್ಥೆ ಮುಖಾಂತರ ಹಣವನ್ನು ತಿಮ್ಮೇಗೌಡರವರು ಆರೋಪಿಗೆ ಕೊಡಿಸಿದ್ದಾರೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಿಮ್ ಡಿಫೆನ್ಸ್ ಅದು. ತಿಮ್ಮೇಗೌಡರು ಆರೋಪಿಗೆ ಹಣ ಕೊಟ್ಟಿರೋ ಬಗ್ಗೆ ಗ್ಯಾರಂಟರ್
ಕೊಟ್ಟಿರೋದು
ಎಂದರೆ ಸರಿ. ನಮ್ಮ ಸಂಸ್ಥೆ ನೀಡಿರುವ ನೋಟಿಸ್ಗೆ ಆರೋಪಿ ನೀಡಿರುವ ಪ್ರತ್ಯುತ್ತರದ ಬಗ್ಗೆ ನನಗೆ ಗೊತ್ತಿದೆ. ತಿಮ್ಮೇಗೌಡರ ವಿರುದ್ಧ ಆರೋಪಿ ಸೋನ್ಸೋ ಎಂದು ಕೇಸಲ್ಲಿ ಸಲ್ಲಿಸಿದಾಗಿದ್ದರೆ ಸರಿ. ಸಾಕ್ಷಿ ಸ್ವತಃ ಅವರು ಪ್ರತ್ಯುತ್ತರದಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ. OS ದಾವೆಯ ಬಗ್ಗೆ ನನಗೆ ಮಾಹಿತಿ ಇಲ್ಲ ಎಂದು ಹೇಳುತ್ತಾರೆ. ನಮ್ಮ ಸಂಸ್ಥೆಯ ಮುಖ್ಯಸ್ಥರಿಗೆ OS ದಾವೆಯ ಬಗ್ಗೆ ಗಮನ ಬಂದಿದೆ. ನಮ್ಮ ಸಂಸ್ಥೆಯವರು ಆರೋಪಿ ಸಲ್ಲಿಸಿರುವ ದಾವೆಗೂ ನಮ್ಮ ಸಂಸ್ಥೆ ಸಂಬಂಧ ಇಲ್ಲ ಎಂದು ಹೇಳಿದರು. ತಿಮ್ಮೇಗೌಡರು ಹಣ ಕೊಡಬೇಕೆಂದು ಬರೆದುಕೊಟ್ಟಿದ್ದಾರೆ ಎಂದರೆ ಸರಿ ಇಲ್ಲ. ತಿಮ್ಮೇಗೌಡರು ಹೊಂದಿರುವ ತ್ಯಾಗರಾಜನಗರದಲ್ಲಿ ಇರುವ ಕಮರ್ಷಿಯಲ್ ಕಟ್ಟಡಕ್ಕೆ ಮುಂಗಡ ಹಣವಾಗಿ 22,50,000 ಹಣವನ್ನು ಆರೋಪಿ ಕೊಟ್ಟಿದ್ದನ್ನು ಮರುಪಾವತಿಗಾಗಿ ಫಿರ್ಯಾದಾರ ಸಂಸ್ಥೆ ತಿಮ್ಮೇಗೌಡರು ಹಣ ವಾಪಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಎಂದು ಸರಿಯಲ್ಲ. ಆರೋಪಿ ನಮ್ಮ ಸಂಸ್ಥೆ ಯಾವತ್ತೂ ಬಂದಿಲ್ಲ ಎಂದರೆ ಸರಿ. ಆರೋಪಿ ನಮ್ಮ ಸಂಸ್ಥೆಯಿಂದ ಸಾಲ ಪಡೆದುಕೊಂಡಿದ್ದಾರೆ ಎಂದು ತೋರಿಸುವ ದಾಖಲೆಯನ್ನು ಇಲ್ಲಿವರೆಗೆ ಕೊಟ್ಟಿಲ್ಲ ಎಂದರೆ ಸರಿ. ಸಾಕ್ಷಿ ದಾಖಲಾತಿ ಕೊಡುತ್ತೇನೆ ಎಂದು ಹೇಳುತ್ತಾರೆ. ನಮ್ಮ ಸಂಸ್ಥೆಯಲ್ಲಿ ಹಣ ಸಾಲ ಕೊಡುವ ವಿಭಾಗದಲ್ಲಿ 5 ಜನ ಕೆಲಸ ಮಾಡುತ್ತಾರೆ. ನಮ್ಮ ಫಿರ್ಯಾದ ಸಂಸ್ಥೆಯಲ್ಲಿ ಮ್ಯಾನೇಜರ್ ಆಗಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದೇನೆ. ನನ್ನ ಕೆಲಸ ಮಾಡಿಕೊಡುವ ಮತ್ತು ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ಮಾಡುವ ಸಾಲದ ಹಣ ಬಾಕಿಯಾದ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪ್ರಕರಣ ದಾಖಲಿಸಿ ವಸೂಲಿ ಮಾಡುವ ಕೆಲಸ ಮಾಡುತ್ತೇನೆ. ಅಧಿಕಾರ ಪತ್ರವನ್ನು B. ಶಿವಲಿಂಗಪ್ಪನು ನಾನು ಬರೆದುಕೊಟ್ಟಿದ್ದಾರೆ. ನಿಶಾನ 7ರ ಸಹಿಯಿಂದ ಶಿವಲಿಂಗಪ್ಪನ ಸಹಿ ಅಲ್ಲ ಅಂದರೆ ಸರಿ. ನಿಶಾನ ಆದ್ದರಿಂದ ಊರ್ಜಿತ ಅಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಾನು ಊರ್ಜಿ ಆರೋಪಿ ಜಾಗಕ್ಕೆ ಪರಿಶೀಲನೆ ಮಾಡಿ ಸಾಲ ಕೊಟ್ಟಿದ್ದೇನೆ ಎಂದು ಸುಳ್ಳು ಹೇಳುತ್ತಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಿಶಾನ P. 8ರಿಂದ 14 ದಾಖಲೆಗಳನ್ನು ಈ ಪ್ರಕರಣಕ್ಕಾಗಿ ನಾವೇ ಸೃಷ್ಟಿ ಮಾಡಿದ್ದೇವೆ ಎಂದರೆ ಸರಿಯಿಲ್ಲ. ಸಾಲವನ್ನು ಸತೀಶ್ ಸ್ಟೋರ್ನ ಪ್ರೊಪ್ರೈಟರ್ ವಿಜಯ್ ಕುಮಾರ್ ಅವರಿಗೆ ಕೊಟ್ಟಿದ್ದೇವೆ. ಸತೀಶ್ ವಿಜಯ್ ಕುಮಾರ್ ಅವರಿಗೆ ಸೇರಿದೆ ಎಂದು ತೋರಿಸುವ ದಾಖಲೆಯನ್ನು ಪಡೆದುಕೊಂಡಿಲ್ಲ ಎಂದರೆ ಸರಿ. ಸಾಕ್ಷಿ ಸ್ವತಃ ಸಾಲದ ಅರ್ಜಿ ದಾಖಲೆ ಇಲ್ಲ ಎಂದು ಹೇಳುತ್ತಾರೆ. ಸತೀಶ್ ಸ್ಟೋರ್ಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ಲ ಎಂದರೆ ಸರಿ. ಸಾಕ್ಷಿ ಸ್ವತಃ ಸತೀಶ್ ಸ್ಟೋರ್ನ ಪ್ರೊಪ್ರೈಟರ್ ವಿಜಯ್ ಕುಮಾರ್ ಎಂದು ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದೇವೆ ಎಂದರೆ ಸರಿ. ಈ ಪ್ರಕರಣದಲ್ಲಿ ಸತೀಶ್ ಸ್ಟೋರ್ ಅನ್ನು ಪಕ್ಷದಾರ ಮಾಡಿಲ್ಲ ಎಂದರೆ ಸರಿ. ವಿಜಯ್ ಕುಮಾರ್ ಅವರು ಮತ್ತು ವೈಯಕ್ತಿಕ ಸಾಲಕ್ಕೂ ಸಂಬಂಧ ಇಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಸೊ ನಮ್ಮ ಸಂಸ್ಥೆ 10 ಕೋಟಿ ವಾರ್ಷಿಕ ವಹಿವಾಟು ನಡೆಸಲು ಪರವಾನಗಿ ಪಡೆದುಕೊಂಡಿದೆ ಮತ್ತು ವೃತ್ತಿವಾರ ಸರ್ಕಾರ ಸಂದೇಹವಾದ ಶುಲ್ಕ ಮತ್ತು ತೆರಿಗೆಗಳನ್ನು ಪಾವತಿ ಮಾಡಿದೆ ತೋರಿಸುವ ಆದರೂ ಪಡಿಸಿಲ್ಲ. ತೊಂದರೆ ಇಲ್ಲ. 10 ಕೋಟಿ ವ್ಯವಹಾರ ನಿಮ್ಗೆ 10 ಕೋಟಿ ವ್ಯವಹಾರದಲ್ಲ ಯಾಕೆ ದಾಖಲೆ ಬೇಕ್ರಿ?
ಅಲ್ಲ, ಅವ್ರಿಗೆ 10 ಕೋಟಿ ವ್ಯವಹಾರ ಮಾಡಕ್ಕೆ ಐತೆ ಅಂತ ಅವ್ರು ಹೇಳೋದು. ಬಟ್ ಇದರಲ್ಲಿ ಎಕ್ಸಿಬಿಟ್ P16 ದೇರ್ ಇಸ್ ಎ ಲಿಮಿಟೇಷನ್ ಫಾರ್ ಇಟ್. ಅವ್ರಿಗೆ ಅಷ್ಟು ಮಾಡಕ್ ಅಡ್ವಾನ್ಸ್ ಮಾಡಕ್ ಇದೇ ಇಲ್ಲ.
ರೆಕಾರ್ಡ್ಸ್
21% ಇನ್ನೂ ಬಂದಿಲ್ಲ ಸರ್.
ಇದು ಅವ್ರಿಗೆ ಕೊಡಿ.
21%
Registry is directed to get the records of both the courts. List this matter on You can proceed against him. They have not complied the order
Please.
of 50% deposit.
I filed an application.
Huh?
Application.
ಏನ್ application?
ಯಾಕಂದ್ರೆ ಅವ್ರ ಅಂಗಡಿ ಸುಟ್ಟೋಗದೆ ಅವ್ರ ಕಡೆಗೆ ಇಲ್ಲ. He is not having money, but application.
List this matter on 21/3.
Petition, please, my lord.
ಏನಾಯ್ತ್ರಿ?
Deposit ಮಾಡಿದೀನಿ.
ಹೇಳಿ. ಮೆರಿಟ್ ಮೇಲೆ ಹೇಳಿ.
Deposit. Assets and liabilities act. Assets and liabilities act. Assets and. Let's assets and liabilities has to be filed, man. Assets and liabilities act matter.
This is an order, only interim order.
Yes.
ಹೌದಲ್ಲ? ಕೋರ್ಟ್ ಬುಕ್ ದರ್ಜನದಡಿ 20D ಪ್ರಕಾರ ಎಜುಕೇಶನಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಯು ಮೀಟ್ ಅಂತ ಮಾಡಿದ ಆರ್ಡರ್. ಯು ಕಂಟಿನ್ಯೂ ಟು ಪೇ ದಿ ಎಜುಕೇಶನಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಆಫ್ ದಿ ಚೈಲ್ಡ್.
ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ ದಿ petitioner has been earlier he was working as a marine engineer, my lord. And after that in 2018 the respondent filed a 498 case. Also LOC issue ಮಾಡಿಸಿ arrest ಮಾಡಿಸಿ and he is unemployed.
ಅದೆಲ್ಲ ಆಯ್ತ್ರಿ.
1 minute.
Being a father,
yes,
you have to meet the educational expenses of a child.
I'm not objecting to pay, my lord.
ನೀವು ಗಂಡ ಹೆಂಡತಿ ಇದ್ರಲ್ಲಿ ಮಗು ಭವಿಷ್ಯ ಹಾಳು ಮಾಡ್ತೀರಿ.
ಅವಾಗಿದ್ದಂತ ಸಂದರ್ಭದಲ್ಲಿ
ಏನೋ ಇರ್ಬೋದು.
ಅವಾಗಿದ್ದಂತ ಸಂದರ್ಭ
ಅಷ್ಟೇ
ಅಲ್ಲ, ಅವಾಗಿದ್ದಂತ ಸಂದರ್ಭದಲ್ಲಿ my lords I was able to pay the fees amount of so much of amount. ಈಗ yearly 2.5 lakhs ಕಟ್ಲಿಕ್ಕೆ ನನ್ನ ಕೈಯಲ್ಲಿ ನನಗೆ ಶಕ್ತಿನೂ ಇಲ್ಲ ಸ್ವಾಮಿ. So as such and also my lords.
ಸ್ಕೂಲ್ ಅಡ್ಮಿಷನ್ ಮಾಡಿದ್ದಾರ ನೀವೇ ತಾನೆ?
ನಾನೇ. ಅವಾಗ ನನ್ನ ಹತ್ರ ಜಾಬ್ ಇತ್ತು my lords. ಅವಾಗ ನನ್ನ ಹತ್ರ ಅಷ್ಟು ಇನ್ಕಮ್ ಇತ್ತು, ನಾನು ಮಾಡ್ತಿದ್ದೆ my lords. And also my lords ಇದರಲ್ಲಿ
ಏನಾಗಿ ಕೆಲಸ ಮಾಡ್ತಿದ್ರಿ ನೀವು?
First I was working as a marine engineer. Marine engineer. ಅವಾಗ.
ಆಯ್ತು.
And now I am not working. Considerably I am not working now.
ಯಾಕೆ ಏನಾಯ್ತು ಕೆಲಸ?
ಇಲ್ಲಿ LOC issue ಮಾಡಿಸಿದ್ರು my lords. I was arrested and after that they took up my employment.
ಆಯ್ತು.
Afterwards I am now currently in India only. And also for the record I have to place some documents, my lords, wherein the petitioner has made so much of properties for the respondent initially, and also where she is staying now also it has considerably has 10 units in the whole building. 10 units ಇದೆ ಇವಾಗ ಅವರು ಇರುವಂತ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇರುವಂತ ಪ್ರಾಪರ್ಟಿನೂ ನಂದೇನೆ. ಅದರಲ್ಲಿ 10 units ಬಾಡಿಗೆಗೂ ಬಿಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಅದರಲ್ಲಿ 10 units ನನ್ಗೆ ಬಾಡಿಗೆಗೆ ಬಿಡ್ತೀನಿ ಅಂದ್ರೆ ಅದಕ್ಕೂ ಬಿಡೋದಿಲ್ಲ. ಅದ್ರಲ್ಲಾರು ಅರ್ನಿಂಗ್ ತಗೊಂಡು ಮಗು ಕಟ್ತೀನಿ ಅಂತಂದ್ರೆ ಅದನ್ನು ಮಾಡಕ್ ಬಿಡಲ್ಲ. Nothing she will allow. And also 6 to 7 properties wherein we have made in the name of the respondent. When
where she is staying now?
Who, my lords? Respondent is residing separately, my lords. And petitioner, respondent and child is residing separately. Petitioner is residing separately.
ಹೌದ್ರಿ, ಎಲ್ಲಿ ಈಗ ಅವರೆಲ್ಲಿ ವಾಸ ಇದ್ದಾರೆ?
ಅವರು ನನ್ನ ಮನೆಯಲ್ಲೇ ವಾಸ ಇದ್ದಾರೆ.
ನಿಮ್ಮ ಮನೆ ಎಲ್ಲಿದೆ?
It is in Gokulam, my lords. Now Gokulam.
ಏನು ಎಷ್ಟು ಯೂನಿಟ್ ಇದೆ?
It considerably has 9 units, my lords.
9 units. ಅವ್ರು ಎಷ್ಟು ಯೂನಿಟ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ?
Our the ground unit, she is living there.
Living.
Yes.
What about other units?
She is not allowing anyone to go for the rent also, and she is not allowing anyone.
But ಅವರೆಲ್ಲ ಟೆನೆಂಟ್ಸ್ ಯಾರಿಗೆ ರೆಂಟ್ ಕೊಡ್ತಾ ಇದ್ದಾರೆ?
ಟೆನೆಂಟ್ಸ್ ನಮ್ಗೆ ಗೊತ್ತಿಲ್ದೇನೆ ಒಂದ್ ಇಬ್ಬರಿಗೆ ಕೊಡ್ಸಿ ಅವ್ರಿಗೆ ಕೊಡ್ತಾ ಇದಾರೆ. ಅಂಡ್ ಅವರಿಗೆ ರೆಂಟ್ ಗೆ ಒಂದ್ ಇಬ್ಬರಿಗೆ ಕೊಟ್ಟು ರೆಂಟ್ ನ ಇದ್ ಮಾಡ್ತಾ ಇದಾರೆ. ಇನ್ ಮಿಕ್ಕಿದ್ ಯಾರನ್ನಾರು ಟೆನೆಂಟ್ ನ ಕಳಿಸ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರೆ ಹೋಗಿ ಪೊಲೀಸ್.
ಈಗ ಖಾಲಿ ಇದೆಯಾ ಪ್ರಿಮೈಸಸ್?
ಹೌದು. ನಾವು ಹೋಗಿ ಕೊಡ್ತೀವಿ ಅಂತಂದ್ರೆ ನಮ್ಮ ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಡೋದು, ಇಲ್ಲ ಟೆನೆಂಟ್ ಯಾರನ್ನ ಕೊಟ್ಟರು ವಾಪಸ್ ಕಳ್ಸೋದು.
ಎಲ್ಲ ಗ್ರೌಂಡ್ ಫ್ಲೋರ್ ಬಿಟ್ರೆ ಸ್ವಾಮಿ ಎಲ್ಲ ಆಲ್ ಅದರ್ ಯೂನಿಟ್ಸ್ ಆರ್ ಇಟ್ಸ್ ಎ ರೂಮ್ ವಿಚ್ ಇಸ್ ಬಿನ್ ವೇಕೆಂಟ್. ಅರ್ಲಿಯರ್ he used to come and make a menace. That has also been, this property is also attached by the bank. Allu ದುಡ್ಡು ಕೊಟ್ಟಿಲ್ಲ. So he has left everything.
Property is attached with bank.
Yes, so we can't give it also.
That is only one property he is speaking about, my lord. And also another property which we have.
ಅದೆಲ್ಲ ಆಮೇಲೆ ನೋಡ್ಕೊಳ್ಳಿ ನೀವು. ಈಗ ಓನ್ಲಿ ನಾವು the issue before this court is with regard to the meeting of
kindly the financial, my lord, the financial
child ಏನು ಓದ್ತಾ ಇರೋದೇನು?
ಈಗ 7ನೇ ಕ್ಲಾಸ್, 7ರಿಂದ 8th
7th.
deposit ಮಾಡಿದ್ದೇನೆ my lords, and also I have to produce such an documents. And also ಇವಾಗ recently she has sold one property which ನಾನೇ ಮಾಡ್ಕೊಟ್ಟದಂತ ಒಂದು 67 lakhs ಗೆ ಮಾರಿದ್ದಾರೆ ಬ್ಯಾಂಗ್ಳೂರಲ್ಲಿ. I have to place all the documents.
ಯಾವ ಪ್ರಾಪರ್ಟಿ ಅದು?
ನಾನ್ ತಗೊಂಡಂತ ಪ್ರಾಪರ್ಟಿ my lords. ಅವ್ರ ಹೆಸರಲ್ಲಿ ನಾನು ಏನ್ ಮಾಡಿದೆ ಅಂದ್ರೆ ಎಲ್ಲ ತಗೊಂಡು ಅವ್ರ ಹೆಸರಲ್ಲಿ ಮಾಡಿದೆ. And also she is a shareholder of 20% of the hotel which is in the highway, that is the Vaishali hotel, ಅದರಲ್ಲಿ 20% ಅವ್ರ shares ಇದೆ. ಸೊ ಅದರಲ್ಲೂ ಅವ್ರಿಗೆ ಅರ್ನಿಂಗ್ ಬರ್ತಾ ಇದೆ. ಐ ವಿಲ್ ಪ್ಲೇಸ್ ದ ಡಾಕ್ಯುಮೆಂಟ್ಸ್.
ಏನ್ರಿ ಸೇಲ್ ಮಾಡಿದಿರಂತಲ್ಲ?
ಸೇಲ್ ಯಾವುದು ಮಾಡಿಲ್ಲ. ಲೆಟ್ ಹಿಮ್ ಫರ್ನಿಶ್. ಅವ್ರು ಸೇಲ್ ಮಾಡಿರೋದು 48 ಲಕ್ಷಕ್ಕೆ. ಐ ಆಮ್ ಪ್ರೊಡ್ಯೂಸಿಂಗ್ ದ EC which he sells, and he has 12 properties. We have filed a partition suit with regarding to them. ಇವ್ರು ದುಡ್ಡಿಲ್ಲ ಅಂತಾರೆ. He is having all the ಇದು and he is staying separately so that he doesn't buy documents.
You have also sold the property ಅಂತಲ್ಲ?
That is ನನ್ನ ಒಂದು ಸಾಲ ಬಾಧ ಇದ್ ಮಾಡ್ಕೊಳ್ಳೋಕೋಸ್ಕರ ನಾನು ಸೇಲ್ ಮಾಡಿ ಅದನ್ನ
ಮಾಡಿದಿರಲ್ಲ?
my lords, that is
ಆ ದುಡ್ಡಲ್ಲೇ ಕಟ್ಟಿ ಮೆಡಿಕಲ್
my lords, that attached ಆದಾಗ ಮಾಡಿರೋದು ಅವರು ಮಾಡಿದ್ದಾರೆ. I will place the document.
ಮಾಡಿದಾರೆ, ನೀವು ಮಾಡಿದ್ರಿ, ಇಬ್ರು ಮಾಡಿ.
6 to 7 properties I have.
ಇಬ್ರು ಮಾರ್ಕೊಂಡು ನಿಂತ್ಬಿಡಿ, ಆ ಮಗುನ್ ಬೀದಿಗೆ ತಂದ್ಬಿಡಿ.
ಇಲ್ಲ I have done it my lords, I have done it. And also I subject to condition deposit ಮಾಡಿದ್ದೇನೆ. I will place records.
ಡೆಪಾಸಿಟ್ ಮಾಡಿದಿರಿ, ಈಗ ಆಯ್ತು.
I will place the documents before this court kindly.
ಅದನ್ನೆಲ್ಲ ಅಲ್ಲಿ ಇದ್ರ ಕೋರ್ಟ್ ಇನ್ನು ಪೆಂಡಿಂಗ್ ಇದೆಯಲ್ಲ ಮ್ಯಾಟ್ರ್, ಅಲ್ಲಿ ಇತ್ಯರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ.
The main major thing is that my lords, that nothing has been considered. And also
only the issue is with regard to the payment of educational expenses of a child. ಹೌದಾ?
We both are earning my lords. Both the petition respondent is well earning. Nothing has been considered of the respondent's earning capacity.
ಆಯ್ತ್ರಿ, ಡಿಸೈಡ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಇನ್ನು CMS 90 of 2018 ಇನ್ನು ಪೆಂಡಿಂಗ್ ಇದೆ. ಪೆಂಡಿಂಗ್ ಇದೆ.
Pending ಇದೆ.
This is only an interim order.
That is only my lord.
For non-payment of educational expenses of a child.
Yes. My lords, nothing has been placed on record as
ಯಾಕೆ 2018 ಇಂದ ಇನ್ನು ಪೆಂಡಿಂಗ್ ಇದೆ CMS? ಏನ್ ಸ್ಟೇಜ್ ಏನು?
I think it might be in the evidence stage. Evidence stage. ಇದು ಅಪ್ಲಿಕೇಶನ್ ಮೇಲೆ ಸುಮಾರು ಟೈಮ್.
Whatever the property sold by
they can will produce,
and also the whatever property sold by you, all you place before the trial court and let the trial court decide the matter on merits. That's all.
Lords, for
now you have to meet the educational expenses of a child.
For the interim stay, my lord, for the interim thing, and also the court has not come into control of any records by the respondent. ಏನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೇನೆ ತಗೊಂಡ್ರು ಅಂದ್ರೆ ಆರ್ಡರ್ ನೋಡಬಹುದು ಸ್ವಾಮಿ.
ಇಲ್ಲೇ ರೆಸಿಟ್ಸ್ ಅಲ್ಲಿ ಹಾಕಿದಾರೆ ನೋಡಿ.
ಇಲ್ಲ ಹಾಕಿಲ್ಲ ಮತ್ತೆ.
ಸ್ಕೂಲ್ ರೆಸಿಟ್ಸ್ ಇನ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 2 ಅಲ್ಲಿ ಇದೆ ನೋಡ್ರಿ. ಸದರಿ ಅರ್ಜಿಯ ಜೊತೆಗೆ ಅರ್ಜಿದಾರರು ಪ್ರಮಾಣ ಪತ್ರವನ್ನು ಸಲ್ಲಿಸಿಕೊಂಡಿದ್ದು, ಅರ್ಜಿದಾರರ ಮಗಳು 4ನೇ ತರಗತಿಯಲ್ಲಿ ವ್ಯಾಸಂಗ ಮಾಡುತ್ತಿರುವ ಐಕ್ಯಾನ್ ಲರ್ನಿಂಗ್ ಸೆಂಟರ್ ಶಾಲೆ ಮೈಸೂರವರಿಗೆ ಅರ್ಜಿದಾರರ ಗಂಡ ಚೆಕ್ ಅನ್ನು 25/7/18 50,000 ರೂಪಾಯಿ ಮೊತ್ತಕ್ಕೆ ನೀಡಿದ್ದು ಇರುತ್ತದೆ. ತದನಂತರ ಸದರಿ ಶಾಲೆಯವರು ಅರ್ಜಿದಾರರ ಗಂಡ ನೀಡಿದಂತ ಚೆಕ್ ಅಮಾನ್ಯಗೊಂಡಿರುತ್ತದೆ ಹಾಗೂ ನಿಮ್ಮ ಮಗಳನ್ನು ನೀವು ದಿನಾಂಕ 21/3 ಪ್ರಾರಂಭವಾಗುವ ಪರೀಕ್ಷೆಗೆ ಕುಳಿತುಕೊಳ್ಳಲು ಅವಕಾಶ ನೀಡುವುದಿಲ್ಲ ಎಂದು ತಿಳಿಸಿದ್ದು ಹಾಗೂ ನೀಡಬೇಕಾಗಿರುವ ಶಾಲೆಯ ಶುಲ್ಕ 1,40,000 ಹಣವನ್ನು ನೀಡುವವರೆಗೆ ಅರ್ಜಿದಾರರ ಮಗಳನ್ನು ಶಾಲೆಗೆ ಕಳಿಸಬೇಡಿ ಎಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. ಎದುರುದಾರರು ಅರ್ಜಿದಾರರಿಗೆ ಮತ್ತು ಆಕೆಯ ಮಗಳಿಗೆ ಅವಮಾನ ಮಾಡಬೇಕೆಂಬ ದುರುದ್ದೇಶದಿಂದ ತಮ್ಮ ಖಾತೆಯಲ್ಲಿ ಸಾಕಷ್ಟು ಹಣ ಇಲ್ಲದಿದ್ದರೂ ಸದರಿ ಚೆಕ್ ಅನ್ನು ಸದರಿ ಶಾಲೆಗೆ ನೀಡುತ್ತಾರೆ. ಸದರಿ ಶಾಲೆಗೆ ನೀಡಬೇಕಾದ ಪ್ರವೇಶ ಶುಲ್ಕ 2,25,000 ರೂಪಾಯಿಗಳನ್ನು ನೀಡಿದ್ದಲ್ಲಿ ಅರ್ಜಿದಾರರ ಮಗಳ ವಿದ್ಯಾಭ್ಯಾಸಕ್ಕೆ ವ್ಯತಿರಿಕ್ತ ಪರಿಣಾಮ ಉಂಟಾಗುವ ಸಾಧ್ಯತೆ ಇರುತ್ತದೆ. ಆದ್ದರಿಂದ ಶಾಲೆಯನ್ನು ಪಾವತಿಸಲು ಹೊಂದಿರುತ್ತಾನೆ. ಹಾಗಾಗಿ ಸದರಿ ಅರ್ಜಿ ಪುರಸ್ಕರಿಸುವ ನಷ್ಟವಾಗುವುದಿಲ್ಲ ಎಂದು ಶಾಲಾ ಮಕ್ಕಳನ್ನು ನೀಡುವುದು ಆತನ ಕರ್ತವ್ಯವಾಗಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಅರ್ಜಿಯನ್ನು ಪುರಸ್ಕರಿಸಲು ವಿನಂತಿಸಿಕೊಂಡಿರುತ್ತಾರೆ. ಚೆಕ್ ಕೊಟ್ಟಿದ್ದು ಚೆಕ್ ಬೌನ್ಸ್ ಆಗಿದೆ.
ಕೊಟ್ಟಿದ್ದೀನಿ. I have produced it before the court. I have paid the amount also.
ಈಗ ಕಟ್ಟಿದಿರ್ರಿ?
ಇಲ್ಲ ಅವಾಗ್ಲೇ ಕಟ್ಟಿದ್ದೀನಿ. I have produced the document.
ಅವಾಗ್ಲೇ ಕಟ್ಟಿದ್ರಿ? ಇಲ್ಲ ನಿಮ್ ಡೈರೆಕ್ಷನ್.
Nothing has been brought on record, my lord. That's what, nothing has been brought on record. I have paid. I have produced the copy of the bill.
ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರೆ ಅಲ್ಲಿ ಮಾಡ್ಬೇಕಿತ್ರಿ, ನೀವು ಅಲ್ಲಿ ಮಾಡಿದ್ರೆ ಇಲ್ಲ.
My lord, there also I have produced. Nothing has been taken on record. Record ಇದ್ರಲ್ಲೂ ಹೇಳ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ. And
ಕೊಡಿ, ದಾಖಲೆ ಏನ್ ಹಾಕಿದ್ರಿ ಕೊಡಿ ಅದ್ ನೋಡಿ.
ಇವತ್ತು ಕೊಟ್ಟನಲ್ಲ.
ಈ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನೀವು ಕೆಳಗಡೆ ಹಾಕಿದ್ರಿ. ಇದು ಇವಾಗ ಡೆಪಾಸಿಟ್ ಚಲನ್ ರೀ.
Second document which I have posted. 2018 I have paid that 50,000 rupees also I have paid. The amount ಏನು ಬೌನ್ಸ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ ಅದನ್ನು ಕಟ್ಟಿದ್ದೇನೆ.
ಇಲ್ಲಿ ಯಾವ್ದು ಇಲ್ವಲ್ಲ 50,000
ಇದಲ್ಲ. Paid 50,000 rupees for the daughter's school fees and also in ಕೆಳಗಡೆ ICAN learning school 50,000 rupees I have paid.
1,35,000 minus 85 ಮೊದಲು ಕಟ್ಟಿರೋದು
ಅದು ಕಟ್ಟಿದ್ದೀನಿ.
ಆಮೇಲೆ 50,000 ಕಟ್ಟಿದಿರಿ.
ಹೌದು.
ಇದು ಯಾವಾಗ ಕಟ್ಟಿದ್ದೀರು?
2018 ಆಗಸ್ಟ್ ಅಲ್ಲಿ ಆಗಿದೆ.
ಈ ಆರ್ಡರ್ ಹಾಕಿದ್ದೆ ಅವಾಗ? ನೀವು ಈ ದಾಖಲೆ ಕೆಳಗಿನ ಕೋರ್ಟಲ್ಲಿ ಹಾಕಿದ್ರಿ, ಎಲ್ಲಿದೆ ದಾಖಲೆ? ನೀವೇನೋ ಹಾಕಿ ಅಲ್ಲ ನೋಡಿ, ಅರ್ಜಿದಾರ ನಿಮ್ಮ ಅರ್ಜಿ ಕೊಡಿ, ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕೊಡಿ, ಕೆಳಗಡೆ ಕೋರ್ಟಲ್ಲಿ ಹಾಕಿರೋದು ಈ ಅಪ್ಲಿಕೇಶನ್ಗೆ.
That's objection is in page number 31 minutes.
ಹಾಕಿದ್ರ ಅಪ್ಲಿಕೇಶನ್
Objection ಹಾಕಿದೀನಿ.
ಹಾಕಿದ್ರಿ
ಹಾಕಿದೀನಿ. Page number
ಕೋರ್ಟಲ್ಲಿ
31 ಅಲ್ಲಿ ಇದೆ.
ಎಲ್ಲಿ ಹೇಳಿದಿರಿ ನೀವು?
Page number 8. The first respondent has paid a sum of 15 towards school fees of his daughter by cash on 10/8/2018.
ಯಾವಾಗ?
10/8/2018, as the check given by him was dishonored.
ಡಿಸೈನರ್ದಲ್ಲಿ ಕತೆ ಇದೆ ರೀ, ನೀವು ಕೊಟ್ಟಿದ್ದ ದುಡ್ಡು ಆಮೇಲೆ.
ಹೌದೌದು ಮೇಡಮ್, ನಾನು ಅಬ್ಜೆಕ್ಷನ್ ಹೇಳಿ
ಕಟ್ಟಿದ್ರ ಬಗ್ಗೆ ಎಲ್ಲಿ ಹೇಳಿದಿರಿ ಅಂತ ಕೇಳ್ತಾ
page number 40.
40 ಅಲ್ಲಿ.
The first respondent has paid a sum of rupees 50,000 towards school fees of his daughter by cash on rupees 10/8/2018 as a check given by him and also
as the check given by the dishonored. Believing the words of the petitioner and for the sake of his daughter, the first respondent also cleared a loan of rupees 13,80,000.
IDBI by borrowing it from second respondent in the
But the
2008.
petitioner, instead of withdrawing the above petition and leading a happy life with him, lodged 3 false complaint against so and so. ಎಲ್ಲ ಸ್ಟೋರಿ ಆಯ್ತು. ಸ್ಕೂಲ್ ಫೀಸ್ ಕಟ್ಟಿದ ಬಗ್ಗೆ ಎಲ್ಲಿದ್ದಾರೆ? ಅಲ್ಲಿ
ಅದೇ
50,000 has been.
ಅದೇ ಅವಾಗ ಕಟ್ಟಿರೋದು ಮೇಲೆ.
ಈಗ ಆರ್ಡರ್ ನಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ? ಅರ್ಜಿಯನ್ನು ಪುರಸ್ಕರಿಸಿದೆ, ಅರ್ಜಿದಾರರು ತಮ್ಮ ಅರ್ಜಿಯಲ್ಲಿ ಕೋರಿರುವ ಮಗುವಿನ ಶಾಲಾ ಶುಲ್ಕವನ್ನು ಈ ಆದೇಶದ ದಿನಾಂಕದಿಂದ ಅರ್ಜಿನಲ್ಲಿ ಎಷ್ಟು ಕೇಳಿದ್ದಾರೆ ಇವರು?
2,25,000. 2,25,000. At paragraph. They have paid only 50 as on.
ಅಲ್ಲ ಸರ್, 2,25,000 has been
Application.
the affidavit ಇವ
ವರ್ಷದ ಫೀಸ್ ಎಷ್ಟ್ರಿ?
2.5 ಅಂತ ಅವ್ರು ಈಗ ತಾನೇ ಹೇಳಿದ್ರು. I can't pay 2.5 lakhs. We have asked 2,20,000.
ಮಗು ಫೀಸ್ ಎಷ್ಟು?
2.5 lakhs ಬರ್ತದೆ.
2.5 lakh. ಆಯ್ತು, ಇದಾದ್ಮೇಲೆ ಮತ್ತೆ ಬೇರೆ ವರ್ಷದ್ದೆಲ್ಲ ಕಟ್ಟಿದಿರ ಈಗ?
ಏನು
ಬೇರೆ ವರ್ಷದ ಇಲ್ಲ.
ಇದು ಆ ವರ್ಷಕ್ಕಾಯ್ತು. ಇದು 2019-20 ಕಂಟಿನ್ಯೂಸ್. ಇದು
ಅವಾಗ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಇತ್ತು
ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಇತ್ರಿ, ಅದು ಬಿಟ್ಬಿಡಿ. ಈಗ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಇಲ್ದವ್ರೇನು? ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಇಲ್ಲ ಅಂತ ಮಗು ಶಾಲೆ ಕಳಿಸ್ತಲೇ ಇರಕ್ಕಾಗಲ್ಲ. Continue to pay.
Even from the, my lords, 1 minute. I'll produce documents kindly.
ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್?
Short documents, I'll produce it. Even the respondent is having sufficient source of income, my lord. Please, nothing has been taken on record. Sufficient source of income is there.
Need the evidence before the trial court.
Allala, my lords, for this consideration, my lords, consideration of these documents and also this
Take
REA.
consideration, no?
This order has not been considered by both of taking any of the assets of both of parties, my lord. Kindly, I'll produce the documents, my lords, please.
Assets and liabilities ನೀವು ಅಲ್ಲಿ ಡಿಕ್ಲೇರ್ ಮಾಡ್ಕೋಬೇಕು.
ಅಲ್ಲ, ಇದರಲ್ಲಿ and also earlier the court has directed to produce the assets and liabilities of both the parties, my lords.
Heard the petitioner, counsel and also the counsel appearing for the respondent.
Let's kindly, my lords.
This revision petition is only with regard to the payment of educational fee of the child. And the trial court having taken note of non-payment of amount and also the bouncing of check given by the petitioner herein. A claim was made before the trial court to pay the school fee of the child belongs to the petitioner. And hence, application filed under section 20D of Domestic Violence Act was considered. The trial court also
We permitted to. We permitted to.
and no dispute with regard to the marriage, and also no dispute with regard to the fact that child is admitted to the school. And also trial court taken note of non-payment of school fee. The school authority directed to pay the amount. And trial court also appellate court taking into note of the duty of the father to meet the educational expenses of the child. And in view of non-payment of educational fee, the future of the child should not be affected. And hence order to pay the amount by allowing the application. And now council submits that he has paid the entire amount madidira, entire amount is deposited. Now the council would submit that the respondent is also having some of the properties and those properties are purchased by the revision petitioner in the name of the respondent. And respondent also sold one of the property. And also council appearing with respondent also would submit that even the petitioner also sold the property. And all this question has to be considered while considering the matter on merits, and still same is 90 of 2018 is pending before the trial court, and this court given liberty to both parties to urge their grounds with regard to the capability of payment of the school fee by the respective parties. And this is with regard to payment was made earlier. Check was given on 25/7/2018, which was bounced and not filed and not paid the school fee. And the said fact is also considered by the trial court and also the appellate court while considering the appeal. And the trial court while considering the application allowed the application directing to pay the amount within 15 days. Having considered the reasoning given by the trial court and also the appellate court, and the same is with regard to the payment of school fee of the child. And when such being the case, I do not find any error committed by the trial court in passing an order to directing to pay the school fee of the child.
Guidelines has not been followed.
Huh?
Rajesh versus Neha guidelines also not been followed.
ಅದನ್ನಲ್ಲಿ ಹೇಳ್ರಿ ನೀವು ಅಲ್ಲಿ ಹೋಗಿ
ಇಂಟ್ರಿಮ್ ಅಪ್ಲಿಕೇಶನ್ ತಿರ್ಗಾ ನಾನು ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಮುಂದೆ ತಿರ್ಗಾ ನಾನು ಇಂಟ್ರಿಮ್ ಅಪ್ಲಿಕೇಶನ್ ಮೇಲೆ ಹೋಗ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ ಮೈಲಾರ್ಸ್. ಅದಕ್ಕೆ
ಯಾವ ಇಂಟ್ರಿಮ್ ಅಪ್ಲಿಕೇಶನ್
ದಿಸ್ 20 days ಇಂಟ್ರಿಮ್ ಅಪ್ಲಿಕೇಶನ್
ಅಲ್ಲ ರೀ ನಿಮ್ ಮ್ಯಾಟರ್ ಪೆಂಡಿಂಗ್ ಇದೆಯಲ್ಲ ಅದನ್ನ
ದಟ್ ಇಸ್
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಗೈಡ್ಲೈನ್ಸ್ ಏನಿದೆಯೋ ಅದನ್ನ ಯು
ದಟ್ ಇಸ್
ಇನ್ವೋಕ್ ದಿ ಸೇಮ್
ದಟ್ ಇಸ್ ಎ ಮ್ಯಾಟರ್ ಆಫ್ ದ ಫೈನಲ್ ಮ್ಯಾಟರ್ ಮೈಲಾರ್ಸ್. ಹಿಯರ್ ಮೈಲಾರ್ಸ್ ಇಂಟ್ರಿಮ್ ಅಪ್ಲಿಕೇಶನ್ ಮೇಲೆ
ಸರಿ ರೀ ಇಂಟ್ರಿಮ್ ಅಪ್ಲಿಕೇಶನ್ ಇದು ನೀವು ಇಂಟ್ರಿಮ್ ಅಪ್ಲಿಕೇಶನ್ ಸ್ಕೂಲ್ ಫೀ ಕೊಡಿ ಅಂತ ಮಾಡಿದಾರೆ.
ಅಲ್ಲ ಮೈಲಾರ್ಸ್, ದ ಇಂಟ್ರಿಮ್ ಅಪ್ಲಿಕೇಶನ್ ಆಲ್ಸೋ ದ ಗೈಡ್ಲೈನ್ಸ್ has not been guided.
I do not find any error in the order of the trial court in directing the revision petitioner to meet the school fee of the child, and whatever the grounds which the petitioner intend to urge the same before the matter which is pending before the trial court. In view of the same, revision petition is disposed of.
Respondent may be permitted to withdraw the next.
You make an application and withdraw.
But there is a typographical error. The connected matter 29.1.
TCR avoided ಅಂತಿದೆ ಅದರಲ್ಲಿ.
ಅಲ್ಲ ಅದೇ ಅದು 502/2021 ಇರ್ಬೇಕಾಯ್ತು. 501/2020 ಅಂತ ಆಗೋಗಿದೆ. ಇದಕ್ಕೂ ನಮ್ದಕ್ಕೂ ಸಂಬಂಧ ಇಲ್ಲ.
ಅಂದ್ರೆ ಇದು ಯಾವ್ದೋ ಬೇರೆ ಬೇರೆ ಕೇಸ?
ಬೇರೆ ಕೇಸ್ ಇದು. ಅದು ಕ್ಲಬ್ ಕನೆಕ್ಟ್ ಆಗ್ಬೇಕಾಗಿದ್ದು 502/2021. ರಾಂಗ್ಲಿ ಕನೆಕ್ಟೆಡ್.
ಯಾವ್ದಕ್ಕೆ ಡಿಲೀಟ್ ಆಗ್ಬೇಕು ಹೇಳಿ?
501/2020
should be deleted from the daily. It has to be
501 ಡಿಲೀಟ್ ಆಗ್ಬೇಕಾ?
ಹೌದು, ಅದು 502 ಆಗ್ಬೇಕಾಯ್ತು, 501 ಅಂತ ಟೈಪ್ ಆಗಿದೆ.
ಆಯ್ತು.
You may connect it with 502/2021.
Registry is directed to delete criminal RP number 501 of 2020 and the same is not connected to criminal petition, criminal RP number 135 of 2024. The council appearing for the revision petitioner would submit that the criminal RP number 502 of ಯಾವ year?
2021.
2021. one ನಿಮಿಷ madam. 2021 and the same has to be listed.
Please.
ಹೌದಾ?
Along with this
criminal RP. Yes, madam.
My lords, 502 of 21, my lords, it's already part heard and it is posted for further hearing, my lords. Before coordinate bench of this court.
Coordinate bench.
Please, my lords.
ಆಯ್ತು, ಅಲ್ಲೇ ಹೋಗ್ಲಿ ಇದನ್ನು. That's all. The counsel appearing with the respondent would submit that already in criminal RP number 502 of 2021, matter was heard in part.
Please,
And hence the registry is directed to post the criminal RP number 135 of 2024 before the very same bench.
Much obliged.
Partition suit decreed by the trial court. First appellate court modifies the decree, notional partition ಮೇಲೆ
Last time ಏನೋ settlement ಅಂದ್ರಲ್ಲ, ಏನಾಗ್ಲಿಲ್ವಾ?
ಆಗ್ಲಿ.
No settlement.
No.
ಹೇಳಿ merits ಮೇಲೆ.
Not the judgment of the trial court is at page 30. I will explain the relationship. Sushilamma,
30,
page 30, madam. My appeal.
30.
30. Sushilamma is the wife of Sannalingegowda. They have 3 children. Meenakshi, H.S. Shobha, and one H.S. Ravi. As on the date of filing the suit, H.S. Ravi had expired.
Oh, he
So-
was not alive
Not alive.
at the time of filing the suit.
Filing the suit.
Aye.
In fact, the cause of action arose because
ಈ defendants ಎಲ್ಲ ಯಾರು?
wife and children of H.S. Ravi.
Oh,
2008 ಅಲ್ಲಿ
ಮಗನ ಹೆಂಡತಿ ಮಕ್ಕಳು.
ಹೌದು. 2008 ಅಲ್ಲಿ immediately after H.S. Ravi expired, they got the kata transferred into their name without the knowledge of the plaintiffs. That is the reason they filed this.
Property belongs to whom?
Sannalingegowda.
Property belongs to Sannalingegowda.
Sannalingegowda is also inherited property in the hands of Sannalingegowda also. There is an admission by DW1 which is extracted in the trial court judgment itself. At page 38, my lord. ದಾವಾಸ್ತಿಗಳು ನನ್ನ ಗಂಡ ರವಿ ಅವರಿಗೆ ಪಿತ್ರಾರ್ಜಿತವಾಗಿ ಬಂದ ಆಸ್ತಿ ಎಂದರೆ ಸರಿ. ಒಂದನೇ ವಾದಿ ನನ್ನ ಅತ್ತೆ, ಒಂದನೇ ವಾದಿಗೆ ಸಣ್ಣಲಿಂಗೇಗೌಡನಿಂದ 2 ಮತ್ತು 3ನೇ ವಾದಿಯವರು ಹಾಗೂ ನನ್ನ ಗಂಡ ರವಿ ಮಕ್ಕಳು ಇರುತ್ತಾರೆ. ನನ್ನ ಗಂಡನ ಹೆಸರಿಗೆ ಖಾತೆ ಆಗುವವರೆಗೂ ಸಹ ನನ್ನ ಗಂಡ ಹಾಗೂ ಆತನ ತಂದೆ ಹಾಗೂ ವಾದಿಯರು ದಾವಾ ಆಸ್ತಿಗಳನ್ನು ಒಟ್ಟು ಕುಟುಂಬದ ಆಸ್ತಿಯನ್ನಾಗಿ ಅನುಭವಿಸುತ್ತಿದ್ದರು. ನನ್ನ ಮಾವ ಸಣ್ಣಲಿಂಗೇಗೌಡ ಮರಣ ಹೊಂದಿದ ನಂತರ ಖಾತೆಯನ್ನು ನನ್ನ ಗಂಡನ ಹೆಸರಿಗೆ ಮಾಡಲಾಯಿತು. ನನ್ನ ಗಂಡನೇ ದಾವಾ ಆಸ್ತಿಗಳ ನಿರ್ವಹಣೆ ಮಾಡುತ್ತಿದ್ದ ಎಂದರೆ ಸರಿ. ನನ್ನ ಮಾವ ಸಣ್ಣಲಿಂಗೇಗೌಡ 2 ಮತ್ತು 3ನೇ ವಾದಿಯರ ಮದುವೆ ಮಾಡಿರುತ್ತಾರೆ ಎಂದರೆ ಸರಿ.
ಅಪೀಲಲ್ಲೂ ಕನ್ಫರ್ಮ್ ಆಗಿದೆಯಾ?
ಕನ್ಫರ್ಮ್ ಆಗಿದೆ. ಬಟ್ ಅದು ಶೇರ್ಸ್ ಮಾತ್ರ
ಮಾಡಿಫಿಕೇಶನ್ ಏನ್ ಮಾಡಿದ್ರೆ?
Plaintiff
number 1 is entitled for 70
Page number 12 the
96th share.
Page number
And
12.
plaintiff number 2 and 3 is entitled for 1/8 share in the suit sale properties.
ಇವಾಗ ಇನ್ ವ್ಯೂ ಆಫ್ ದ ಡಿಸಿಷನ್ ಇನ್ ವಿನಿತಾ ಶರ್ಮಾಸ್ ಕೇಸ್ ಈಕ್ವಲ್ 3 ಜನ ಮಕ್ಕಳಿದ್ದಾರೆ. 1/3 because this Sushilamma also has expired now during pendency of this appeal. Now
ಈಗ ಸುಶೀಲಮ್ಮನು ಇಲ್ಲ.
ಇಲ್ಲ 3 ಜನ ಮಕ್ಕಳಲ್ಲಿ 2 ಹೆಣ್ಮಕ್ಳಿದ್ದಾರೆ. The LRs of the son is they are the contesting parties.
ಈಗ ಸಿಸ್ಟರ್ಸ್ ಬಂದವ್ರ?
Sisters they are the appellants.
ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ
Yeah, they are the original plaintiffs, man.
2 and
ಯಾರು ಇಲ್ಲಿ ಯಾರು?
2 and 3.
2 and 3.
2 and 3
Appellant.
ನಾಟ್ ಸಿಸ್ಟರ್ಸ್ ಮಗ ಇದ್ದಾನಲ್ರಿ. ಆರಿ ಹಾಕಿರೋದು ಯಾರು?
ಆರೆ ಹಾಕಿರೋದು ಅವ್ರೆ.
ಈಗಾಗ್ಲೇ ಹಾಗಾದ್ರೆ ಬರೋದು ಒಂದ್ ಈಗ 3 ಜನಕ್ಕೆ ಬರೋದು 1/3 ಶೇರ್ ಅಷ್ಟೇ.
ಅಷ್ಟೇ.
Worship, this property is exclusive in our husband name. Husband. The property was a self-acquired property of the husband of the defendant one Padma.
ಏನಿದೆ ದಾಖಲೆ ಏನಿದೆ?
Document they are not produced by.
ನಿಮ್ ಅಡ್ಮಿಷನ್ ಅವ್ರು ಓದಿದ್ರಲ್ಲ ಈಗ? ನಿಮ್ ಅಡ್ಮಿಷನ್ ಅವ್ರು ಓದಿದ್ರಲ್ರಿ ಈಗ?
More contention worship, the one.
ಅಡ್ಮಿಷನ್ ನೀವು ಓದಿದ್ರಲ್ಲ, ಏನ್ ಹೇಳಿದಾರೆ? ಅಪ್ಪನ ಆಸ್ತಿ ಯಾರಿಗೆ? ಇವನಿಗೆ ಸಣ್ಣಲಿಂಗೇಗೌಡ. ಸಣ್ಣಲಿಂಗೇಗೌಡನ ಆಸ್ತಿ ಅಂತ ಒಪ್ಕೋತಾರೆ.
That is in the.
ಸೊಸೆ ಗಂಡ ಸತ್ತ ತಕ್ಷಣ ಎಲ್ಲಾ ಆಸ್ತಿನ ಆಕೆನ ಹೊಡ್ಕೊಬಿಟ್ರೆ?
But in moreover in second contention worship,
ಎಲ್ಲ ಕಡೆ ಅತ್ತೆ ಸೊಸೆ ಕೊಡ್ತಾರೆ, ಕಾಟ ಕೊಡ್ತಾರೆ ಅಂತ. ಇಲ್ಲಿ ಸೊಸೆನ ಅತ್ತೆ ಕಾಟ ಕೊಡೋದು. There is an admission on the part of you that all the children belongs to the Sannalingegowda and Sarojamma, yes, Savitramma, ಏನದು?
In one contention worship, appeal number 3 is the adopted 1-to-1 Ramalingegowda. At the age of 1 month.
Who is?
Appellant number 3 worship. Appellant number 3 is the.
Adopted ಏನಾದ್ರು ದಾಖಲೆ ಇದೆಯಾ? ರಿಜಿಸ್ಟರ್ಡ್ ಡಾಕ್ಯುಮೆಂಟ್?
Produce any document. Produce only voter list document. Voter list produce ಮಾಡಿದ್ದಾರೆ. Not produce any document to that.
ಏನ್ ಬೇರೆ ಏನಿಲ್ಲಲ್ಲ ಅಡಾಪ್ಷನ್ ಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ?
ಏನ್ ಇಲ್ಲ.
Voter
list ಒಂದು ಮಾಡಿದ್ದಾರೆ. Voter list of the ಶೋಭಾ ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ. Voter list ಹಾಕಿದ್ದಾರೆ. Voter list.
Voter list, voter list ಮೇಲೆ ನಾವು ಡಿಸೈಡ್ ಮಾಡಕ್ಕಲ್ಲ, ಈಸ್ an adopted son ಅಂತ.
ಬಿಟ್ಟು ಬೇರೆ ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್
ಬೇರೆ ಏನಿಲ್ಲ ತೊಗೊಳ್ಳಿ. This matter is listed for admission. I heard the counsel appearing for the appellant, also the respondent. The plaintiffs, the parties are referred in the original ranking ಅಂತ ಹಾಕೋಬಿಡಿ in order to avoid the confusion and for the convenience of the court. The suit is filed by mother-in-law and her two sons.
ಇಲ್ಲ
Daughters.
Ibru daughters,
Ibru
two daughters. Against the daughter-in-law who has been arraigned as defendant number 1, who is the wife of son of the first plaintiff. And also against her two grandchildren for the relief of partition and separate possession of the social property to the extent of their share in the same. The suit scheduled properties are consisting of agricultural lands. It is a specific case of the plaintiffs that suit scheduled properties are the joint family properties of plaintiff and her deceased son H.S. Ravi, and they were enjoying the same jointly. The said H.S. Ravi working as a teacher in government primary school, Vasakoppal, and died on 22/2/2008. The plaintiff submitted that defendant number 1 without notice to the plaintiffs got changed the RTC pertaining to the social properties in her name, stating that she has inherited the social properties from her husband. It is also contended that plaintiffs are also having share in the property. The plaintiffs submit that plaintiff number 1 being the class 1 heir of H.S. Ravi is having share in the properties of H.S. Ravi also. The defendant number 1 has not divided this suit shell properties by meets and bounds and hence entitled for partition. In response to the suit claim, the defendant number 1 appeared and filed a written statement. Contending that plaintiff number 3 is not the member of joint family consisting of plaintiff number 1 and 2 of deceased Ravi. It is contended that plaintiff number 3 was adopted by one Sri H.V. Ramegowda, son of Boregowda, when she was aged about 1 year. First off, as plaintiff number 3 has given in adoption to H.V. Ramegowda, she has lost her right in the properties of the joint family. The defendant number 1 further contend that social properties are the exclusive properties of defendant number 1. And as such, plaintiffs are not having any right, title or interest over the property. The trial court, having considered the pleadings, framed the issues whether the plaintiffs proves that they have got 2/4 share in the suit settled property, and whether the plaintiff proves that suit settled properties is the joint family property of plaintiff and defendant, whether the defendant number 1, 2, 3 prove that suit settled properties are individual properties of late H.S. Ravi. The trial court, having considered the evidence of parties, since the plaintiff number 3 has been examined as PW1 and she has produced 10 documents, and defendant number 1 has been examined as DW1 and examined one witness as DW2 and produced 2 documents. Having considered all this material on record, the trial court partly answered the issue number 1 as affirmative and also comes to the conclusion that issue number 2 in the affirmative and the contention of the defendants were negative, and decreed the suit by granting the partition of 17,190 to share in favor of plaintiff number 1 and plaintiff number 2 and 3 are having 5/16 share. Defendant number 1 is having 192 share. And defendant number 2 and 3 are having 25th 1/192 share, each in the suit shall property. Being agreed by the said judgment and decree and appeal is filed before the appellate court in RA number 17 of 2011. And first appellate court also having reassessed the material available on record, allowed the appeal in part only by modifying the same, in coming to the conclusion that plaintiff number 1 is entitled for 796 share and plaintiff number 2 and 3 each are entitled for 18 share in the suit settled properties. Being agreed by the said judgment and decree of the appellate court also, the present appeal is filed by defendants. Plaintiff file ಮಾಡಿರೋದು ಇದು appeal. ಯಾಕೆ?
Unequal share ಅನ್ಬಿಟ್ಟು. ಇದು
Modification.
modification.
ಸರಿ ಇಲ್ಲ ಅಂತ. ತಗೊಳ್ಳಿ. The present second appeal is filed by the plaintiffs before this court. And during the pendency of this appeal, the first plaintiff passed away. And main contention in this appeal is that lower court has erred in coming to the conclusion that provisions of Hindu Succession Act 2005 has no application to the facts and circumstances of the case on hand in view of the decision of Honorable Supreme Court reported in 2009. And totally erred in deciding the allotment of share to the appellants number 2 and 3, who are the daughters of late Sannalingegoda. The appellate court is totally erred in coming to the conclusion that Sannalingegoda and his son H.S. Ravi were having half share in the suit settled properties. And the very apportionment is erroneous and hence it requires interference. The counsel appearing for the ಯಾವ ವರ್ಷ ಸೂಟ್ ಹಾಕಿರೋದು ಇದು?
2008. 6/6/2008.
That is also subsequent to the amendment. Oh. So, the counsel appearing for the appellant would vehemently contend that suit was filed in 2008 subsequent to the amendment. And when the trial court has given him the reasoning that when the trial court held that issue number 2 as affirmative in coming to the conclusion that property is an ancestral property and ought to have granted equal share to all of them, and instead of them committed an error. The counsel also brought to notice of this court of the admission given by the DW1 admitting that the property belongs to Sannalingegoda and also not disputed the relationship between the parties in her admission. It is also the case of the plaintiff before the trial court that after the death of her son Ravi, the first defendant got it changed the revenue records in her name. And the respondent counsel also not disputes the relationship between the parties. And also though claims that property exclusively belongs to the husband of the first defendant, and in order to substantiate the same, no material is placed before the trial court. And trial court answered the issue number 3 as negative and comes to the conclusion that property belongs to the family. Having perused the material available on record, the dispute is only with regard to the apportionment of share is concerned. Admittedly, the second plaintiff and third plaintiff are the son and daughter,
Yes.
son and daughter of Sannalingegoda.
Yes.
And the first defendant is also
Daughter-in-law.
daughter-in-law of the said Sannalingegoda. That is, she is the wife of his son H.S. Ravi. During the pendency of this appeal, the Sushilamma, who is the first plaintiff, also passed away. ಆಕೆ ಏನಾರು ವಿಲ್ಲು ಆತರ ಏನಾರು ಮಾಡಿಟ್ಟು ಹೋಗಿದ್ದಾಳೆ ಏನಾರು?
ಮಾಡಿದ್ದಾರೆ. ರಿಜಿಸ್ಟರ್ಡ್ ವಿಲ್.
ಯಾರ ಪರವಾಗಿ?
ಥರ್ಡ್ ಪ್ಲೇಂಟಿಫ್ H.S. Shobha.
Huh?
Third
Third
plaintiff.
plaintiff Kumari Shwas.
H.S.
That
Shobha.
This is a dispute, your lordship.
Hmm?
Adopted daughter ಅಂತ ಹೇಳ್ತದಿಲ್ಲ ಅದೇ.
ಹಾ.
This
ಅವ್ರ ಪರವಾಗಿ
ನೀವ್ ಅಲ್ಲಿ ಏನಾರು ಇದ್ರೆ ಅದ್ರ ಮೇಲೆ ಹೋಗಿ ಇದ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಷ್ಟೇ.
There is a dispute.
ಆಯ್ತು.
She adopted by one Ramlingegoda.
The counsel appearing for the appellant would submit that during the lifetime Srimati Sushilamma has executed
a will.
a will in favor of
H.S. Shobha, third plaintiff.
H.S. Shobha, that is third plaintiff. And this court cannot decide the same in this second appeal. And if any will in favor of third plaintiff and the third plaintiff can hesitate the same based on the said will. The only question before this court is with regard to how much share the parties are entitled. In view of admission on the part of defendant number one that property belongs to the Sanna Lingegoda, and when the Sanna Lingegoda died intestate, leaving behind his wife and 3 children, the property devolves upon them as 1/4. And defendant number one is entitled for 1/4. That is the share of her husband, H.S. Ravi. And the first plaintiff, second plaintiff, and third plaintiffs are entitled for remaining 3/4 share as wife and 2 children. And both the courts have lost the fact that they are the class 1 heirs of deceased Sanna Lingegoda, and erroneously proceeded to apportion the property. And the fact that already amendment was brought in 2005 itself, and suit is filed in the year 2008, and ought to have taken note of the said fact into consideration. Now, in view of the judgment of the apex court also, in Vinita Sharma case, when the daughter also entitled for a share equally that of a son, and hence it is appropriate to award 1/4 share each to the plaintiff number 1 to 3, that is 2/3 share, and 3/4 share, and also the defendant number 1 is entitled for 1/4 share. And if any testamentary document executed by the first plaintiff as contended by the appellant counsel in respect of her share is concerned in favor of the third plaintiff, and the same is subject to the proof of the will, and hence this second appeal is disposed of, modifying the judgment and decree of the trial court in above terms.
1/3 share, 1/4 ಅಲ್ಲ 1/3 share. Sushilama is no more.
ಸುಶೀಲಮ್ಮಕ್ಕೇನ ಆಕೆ ಏನ ವಿಲ್ ಬರ್ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಅದ್ರ ಬಗ್ಗೆ ಪ್ರೂವ್ ಮಾಡ್ಬೇಕು, ಅದನ್ನ ಮಾಡಿದ್ವಿ ಅಷ್ಟೇ.
Lordship, in this matter, we have fulfilled all the terms. Only a small amount is due. Today we will pay it, my lord. Requesting for a possible.
You are appearing for whom?
Petitioner. I'm ready to file the application under section 147 of NI Act for compounding of offense and agreeing for settlement. Only a small amount is due. Today she will pay. She is on the way. She will pay to the respondent, hence requesting for a time.
Pass over.
Pass over.
Pass over.
Much over.
Here for the claim. Claimants number 9 and 10, that is response number 9 and 10, my lord. In this case, the subject matter of the appeal is 37, survey number 31/2. Survey number 31/2 measuring 2 acres 13 guntas of land is situated at Ullal village, Yeshwantpura Hobbli, Bangalore North Taluk. The 2 acres 13 guntas of the land is the subject matter of the petition.
2 acres?
2 acres 13 guntas of land. In the judgment, the city civil court has come to the conclusion.
You are appearing for respondent.
Response number 9 and 10, claimants number 9 and 10 in the lower court. Here response number 9 and 10. In the judgment, the trial court granted relief in respect of 2 acres 2 guntas to claimants number 9 and 10. And remaining 11 guntas in respect of the appellants, my lord. Now the appellant addressed that he is entitled for total 2 acres 13 guntas of land for total compensation. Claimants number 9 and 10 are not entitled. It is their arguments. Now I like to invite your lordship is exhibit P16, my lord.
Exhibit P16.
P16 ಅಲ್ಲಿ judgment ಅಂತಿದೆ. OS number 133 of 76. ಅದರಲ್ಲಿ it's a suit for declaration.
OS 133 of 76.
76. It's a suit is filed by the plaintiff for declaration and for consequential relief and for mean profits anta ide. Now in this case
declaration and possession.
Declaration possession ella kelidare. In this
is
case,
a suit filed by whom? Y Nagaraj.
One Nagaraj, he was a minor on the date of filing the suit. He was
16-year-old.
16 years old. He was represented by his maternal grandfather as guardian in this case. And your lordship may candidate.
Whether this defendant Irappa and
Irappa is one that is the appellants. Irappa is sold to one Irappa is sold to one.
Originally property belongs to
ಅದು ಹೇಳ್ತೀವಿ ಸರ್. Originally property belongs to one Kuntaya. That is the exhibit P12, my lord.
Synopsis ಕೊಟ್ಟಿದ್ದೀನಿ.
Synopsis
belongs to Kuntaya.
Kuntaya ಅಂತಾನೆ ಇರುದೇ 21/4/1962.
21/4/1962
ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ
ಪರ್ಚೇಸ್ ಮಾಡಿರೋದ
ಇವರು ಕುಂಟಯ್ಯ ಅನ್ನೋರು ಯಲ್ಲಪ್ಪ ಅನ್ನೋರಿಗೆ ಸೇಲ್ ಮಾಡ್ತಾರೆ. ಸೇಲ್ ಮಾಡ್ತಾರೆ. ಎಕ್ಸಿಬಿಟ್ P12.
Kuntaya sold agara.
So Kuntaya and others are alienated the land bearing numbers 31/2 and 29/4 in favor of Sri Yellappa alias Mariappa.
ಯಾವ್ದು ಸರ್ವೆ ನಂಬರ್?
Survey number 31/2 and 29/4.
ಎಷ್ಟು ಎಕ್ಸ್ಟೆಂಟ್?
31/2 ಅಲ್ಲಿ 2 acres 13 guntas of land. 29/4 ಅಲ್ಲಿ 1 acre 31 guntas of land. ಆಮೇಲೆ
ಅವನ ಹೆಸರೇನು? ಯಲ್ಲಪ್ಪನ.
ಯಲ್ಲಪ್ಪ ಪರ್ಚೇಸರ್. ಅಗೇನ್ ಎಕ್ಸಿಬಿಟ್ P13, my lord.
ಇದು ಎಕ್ಸಿಬಿಟ್ P12 ಸೇಲ್ ಡೀಡ್.
12 ಇದು. ಯಲ್ಲಪ್ಪ ಅಗೇನ್ ಎಕ್ಸಿಬಿಟ್ P13 is sale deed dated 21/4/1966.
ಡೇಟ್
21/4/66. 66
Synopsis ಅಲ್ಲಿ ಡೀಟೇಲ್ ಆಗಿ ಹೇಳಿದ್ದೀನಿ.
ಕೊಟ್ರೆ ಡಿಸ್ಕೌಂಟ್
ಕೊಟ್ಟಿದ್ದೀನಿ. ಈಗ ಫೈಲ್ ಅಲ್ಲಿ ಲಾಸ್ಟ್ ಟೈಮ್ ರೆಫರ್ ಮಾಡಿದ್ವಿ. ತಾವು ನೋಟ್ಸ್ ಮಾಡ್ಕೊಂಡು.
ಹೇಳ್ತಾ ಇರಿ ನೀವು. ಯಲ್ಲಪ್ಪ ಎಕ್ಸಿಬಿಟ್ P13 ಪ್ರಕಾರ
21/4/66
he sold to whom?
ಈ ಯಲ್ಲಪ್ಪ alias ಮರಿಯಪ್ಪ sold to ಯರ್ರಪ್ಪ son of ರಾಮಯ್ಯ. ಅಂದ್ರೆ 31/2 and 29/4 ಟೋಟಲ್ ಆಗಿ ಸೇಲ್ ಮಾಡ್ತಾರೆ.
ಬೋತ್
ಎರಡನ್ನು ಮಾಡ್ತಾರೆ.
ಇದೇನೋ ಲಾಸ್ಟ್ ಟೈಮ್ ತುಂಬಾ ಬಹಳ
ಹೇಳಿದೆ ಅದು. ಬಟ್ ಒನ್ಸ್ ಅಗೇನ್ ರೀಡ್ ಅಷ್ಟೇ, ಇನ್ನೇನಿಲ್ಲ.
ಸಮ್ ಕನ್ಫ್ಯೂಷನ್ ಏನೈತಿ ಸ್ವಲ್ಪ.
ಅದಕ್ಕೋಸ್ಕರ ಆಮೇಲೆ
ಯರ್ರಪ್ಪನಿಗೆ ಮಾರಾಟ ಮಾಡೋರು
ಮಾಡಿದ್ರು ಫುಲ್. ಈ ಆಮೇಲೆ ಏನಾಗುತ್ತೆ,
sale deed dated 9/5/1967. Exhibit P1.
Exhibit P1 ಪ್ರಕಾರ.
P1 9/5/67 ಇಸ್ವಿ ಸೇಲ್ ಡೀಡು. ಇದರಲ್ಲಿ ದಿ ಸೆಡ್ ಯರ್ರಪ್ಪ who has purchased from Yellappa, Yerrappa son of Ramayadi sold the property in favor of Srimati Muniyamma. ಇದರಲ್ಲಿ
ಎಲ್ಲ ಎಕ್ಸ್ಟೆಂಟ್
ಇಲ್ಲ ಅದನ್ನೇ the survey number 31/2 measuring 2 acres 2 guntas of land. ಇದರಲ್ಲಿ 13 guntas of land was retained by him.
Not 13 guntas, 11 guntas.
11 guntas, sorry man. 2 acres 2 guntas ಅಲ್ಲಿ ಸೇಲ್ ಮಾಡಿದ್ಮೇಲೆ ಉಳ್ಕೆ 11 ಗುಂಟೆನ ಉಳಿಸ್ಕೋತಾರೆ.
ಅದ್ರಲ್ಲಿ
ಉಳಿಸ್ಕೋತಾರೆ ಯರ್ರಪ್ಪ ಅನ್ನೋರು. ಆಸ್ ಪರ್ ಎಕ್ಸಿಬಿಟ್ P1 9/5/1967.
ಸರ್ವೆ ನಂಬರ್ 29 ಮಾರಾಟ ಮಾಡ್ಲಿಲ್ಲ.
ಇಲ್ಲ ಓನ್ಲಿ 31/2.
ಆಯ್ತು,
ಅದು ಹೇಳ್ತೀನಿ ಸ್ವಾಮಿ, ಅದನ್ನು ಹೇಳ್ತೀನಿ. 2 acres 2 guntas was sold in favor of Srimati Muniyamma. Again, in exhibit P2, your sale deed dated 26/6/1967. ಅಂದ್ರೆ ಒಂದು 21 ತಿಂಗಳು ಒಳಗಡೆನೆ 9/5/1967 ಮತ್ತೆ exhibit P2 26/6/1967. Same this said Muniyamma
within 1 month ಅಲ್ಲಿ
who has purchased survey number 31/2 measuring 2 acres 2 guntas of land, sold to Srimati Sanna Yellamma and Nagaraj. Nagaraj. This is exhibit P2, my lord.
ಪೂರ್ತಿ ಎಕ್ಸ್ಟೆಂಟ್
2 ಎಕರೆ 2 ಗುಂಟೆ ಪೂರ್ತಿ ಸೇಲ್ ಮಾಡ್ತಾರೆ.
ಆಯ್ತು.
ಇದರಲ್ಲಿ ನಾವು ಈ ಎಕ್ಸಿಬಿಟ್ P2 ಆದ್ಮೇಲೆ ದಿ ಶ್ರೀಮತಿ ಸಣ್ಣ ಯಲ್ಲಮ್ಮ and Sri Nagaraj has sold the property in favor of claimants respondents number 9 and 10, sale deed dated 31/8/94 as per exhibit P6. 31/8/94. 94ರಲ್ಲಿ
ಸೇಮ್ ಎಕ್ಸ್ಟೆಂಟ್.
ಇವರು ಸಣ್ಣ ಯಲ್ಲಮ್ಮ
ಸೇಮ್ ಎಕ್ಸ್ಟೆಂಟ್
2 acres 2 guntas of land.
ಆಯ್ತು.
This property has been claiming as my property.
ನೀವು ಕ್ಲೈಮ್ ಮಾಡಿ
9 and 10 ಅವರೇನೆ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದು 31/8/1994. Now your lordship may kindly come to exhibit P14, my lord. ಇದರಲ್ಲಿ exhibit P14 sale deed dated 21/4/1974.
21/4/1974.
As earlier I stated that in 31/2 ಅಲ್ಲಿ 2 acres 2 guntas ಸೇಲ್ ಮಾಡಿ 11 ಗುಂಟೆ ಉಳಿಸ್ಕೊಂಡ್ರು.
ಹೌದು.
ಅದನ್ನ ಮತ್ತೆ 29/4
11 ಗುಂಟೆ ಮತ್ತೆ 29/4
1 ಎಕರೆ 31 ಗುಂಟೆ ಮತ್ತೆ 11 ಗುಂಟೆ ಸೇರಿದ್ರೆ 2 ಎಕರೆ 2 ಗುಂಟೆನ ಈ ಯರ್ರಪ್ಪನವರು ಮಲ್ಲಯ್ಯನವ್ರಿಗೆ ಸೇಲ್ ಮಾಡ್ತಾರೆ. ಎಕ್ಸಿಬಿಟ್ P14 ಅಲ್ಲಿ
2 ಎಕರೆ 2 ಗುಂಟೆ
2 ಎಕರೆ 2 ಗುಂಟೆ ಆಗುತ್ತೆ ಟೋಟಲ್ ಆಗಿ. 1 ಎಕರೆ 31 ಗುಂಟೆ
11 guntas in survey number 31/2
and 1 acre 31 guntas in survey number 29/4. Total 2 acres 2 guntas of land.
This was sold by whom?
Yerrappa. That is your exhibit P13 ಅಲ್ಲಿ ಯರ್ಲಪ್ಪ ಅನ್ನೋರು ಮಾರಿರ್ತಾರೆ.
ಯರ್ರಪ್ಪ ಮಾರಾಟ ಮಾಡಿರ್ತಾರೆ.
ಇವರು 2 ಎಕರೆ 2 ಗುಂಟೆ ಯರ್ರಪ್ಪ ಬಂದ್ಬಿಟ್ಟು ಮುನಿಯಮ್ಮನಿಗೆ ಮಾರ್ತಾರೆ 11 ಗುಂಟೆ ಉಳಿಸ್ಕೊಂಡು. ಅದೇ ಸೇಮ್ 11 guntas which was retained by ಯರ್ರಪ್ಪ he sold to Mallaya on 21/4/1974. So 2 acres 2 guntas ಇಲ್ಲಿ ಬಂತು. ಇಲ್ಲಿ 11 guntas in 31/2 and 2 acres 2 guntas sold to claimant number 9 and 10. So the subject matter of the acquisition proceeding is 2 acres 13 guntas in survey number 31/2 only.
Acquisition only 2 acres 13 guntas.
13 guntas of survey number 31/2. That is the only subject matter of this. Why I like lordship invited your lordship attention to exhibit P16 is this Nagaraju was a minor. He filed a suit for declaration, possession and injunction in respect of these two survey numbers. Your lordship will find it in decree copy.
ಜಡ್ಜ್ಮೆಂಟ್ ಅಂಡ್ ಡಿಕ್ರಿ ಅಲ್ಲಿ
ಡಿಕ್ರಿ ನಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ.
ಇವನು ನಾಗರಾಜು ಯಾರ ಮಗ?
ನಾಗರಾಜ್ ಅದನ್ನೇ ಹೇಳ್ತೀನಿ ಸ್ವಾಮಿ. ಇದರಲ್ಲಿ 29/4 1 acre 31 guntahs, 31/2 2 acres 31 guntahs of land, 2 acres 13 guntahs of land, and other survey numbers he sought. He was represented by maternal grandfather. ಈ ನಾಗರಾಜ ಅಂದ್ರೆ
ನಾಗರಾಜ ಯಾರ ಬೇಸಿಸ್ ಮೇಲೆ ಕ್ಲೇಮ್ ಮಾಡ್ತಾರೆ?
ಅದರಲ್ಲಿ ಎಕ್ಸಿಬಿಟ್ ಅದನ್ನ ಹೇಳ್ತೀನಿ ಸರ್. ಎಕ್ಸಿಬಿಟ್ P6 ಅಲ್ಲಿ ದಿಸ್ ಇನ್ ಎಕ್ಸಿಬಿಟ್ P2 ನಲ್ಲಿ ಮುನಿಯಮ್ಮ ಡಾಟರ್ ಆಫ್ ಹರ್ಸಪ್ಪ ಸೋಲ್ಡ್ ಸರ್ವೆ ನಂಬರ್ 31/2 ಮೆಜರಿಂಗ್ ಇನ್ ಫೇವರ್ ಆಫ್ ಶ್ರೀಮತಿ ಸಣ್ಣ ಯಲ್ಲಮ್ಮ ಡಾಟರ್ ಆಫ್ ಗಿರಿಯಣ್ಣ ಅಂಡ್ ನಾಗರಾಜ್.
ಈ ನಾಗರಾಜ್ ಅವನೇ ಅವಾಗ ಮೈನರ್.
He was a minor. The same Nagaraj.
But they have jointly purchased.
ಇದರಲ್ಲಿ ಜಾಯಿಂಟ್ಲಿ ಪರ್ಚೇಸ್.
Sanna Yellamma and Nagaraj, both of them have jointly purchased the property.
Jointly purchased. He was a minor represented by his own mother. Sanna
Yellamma is mother. Nagaraj is
mother and son. Mother and son represented by his own mother.
ಇದರಲ್ಲಿ ಈ ಸೂಟ್ ಹಾಕುವಾಗ ಮದರ್ ಇರ್ಲಿಲ್ಲ.
ಮದರ್ ಇದ್ರು, ಅದನ್ನೇ ಅವು ಟೆಕ್ನಿಕಲ್ ಗ್ರೌಂಡ್ಸ್ ಅಲ್ಲಿ ಜಡ್ಜ್ಮೆಂಟ್ ಆಸ್ ರೆಂಡರ್ಡ್. ದಟ್ ಐ ಲೈಕ್ ಟು ಇನ್ವೈಟ್ ಯುವರ್ ಆನರ್ಸ್ ಅಟೆನ್ಷನ್. ಇನ್ P16 ಅಲ್ಲಿ
ಆ ಸೂಟ್ ಏನಾಯ್ತು?
ಆ ಸೂಟ್ ಡಿಸ್ಮಿಸ್ ಆಗುತ್ತದು. ವೈ ಇದರಲ್ಲಿ ವೆದರ್ ದಿ
in the joint name of
whether the plaintiff is entitled to declaration possession of social property ಅಂತ ಇದೆ. Same two survey numbers were included. 29/4 measuring 1 acre 31 guntahs of land and 31/2 measuring 2 acres 13 guntahs of land was the subject matter of this suit. Now I lordship I like to invite your lordship to ಪರ್ಚೇಸ್ ಆದ್ಮೇಲೆ
ಯಾರು
ಇವರೇನೆ. ಇದು 76 ಸೂಟ್. ಇದು
ಸೂಟ್ 76 ಆಗ್ಲಿ.
ಇವರು 67 ಅಲ್ಲೇ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದು 2 acres 2 guntahs 31/2.
ಹೌದು,
ಇದನ್ನು ಸೇರಿಸ್ಬಿಡ್ತಾರೆ ಇದರಲ್ಲಿ.
ಬೇರೆ
ಡಿಕ್ಲರೇಷನ್ ಸೂಟ್ ಅಲ್ಲಿ
ಅದಕ್ಕೆ ಡಿಸ್ಮಿಸ್ ಆಯ್ತು.
ಅದು ಬೇರೆ ಗ್ರೌಂಡ್ ಅಲ್ಲಿ ಕೊಡ್ತಾರೆ. ಅದನ್ನೇ ಲೈಕ್ ಟು
ಆಯ್ತು
ಬ್ರಿಂಗ್ ಇಟ್ ಟು ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಕೈಂಡ್ ಅಟೆನ್ಷನ್ ಇಸ್ ಇನ್ ಜಡ್ಜ್ಮೆಂಟ್ ನಲ್ಲಿ ಈ ಪೇಜ್ 8 ಅಲ್ಲಿ ಸ್ವಾಮಿ. Page 8 ಅಲ್ಲಿ issue number 5 ಅಲ್ಲಿ ಇದೆ. Whether the plaintiff is entitled to declaration and possession of substantial properties. Now coming to the para 8 of the judgment in page number 16, your lordship by kind. Page 16, para 8 of the judgment. A detail ಒಂದೇ ಒಂದು ಇದರಲ್ಲಿ ಹೇಳಿದ್ರು. ಈ para 8 ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ. Under these circumstances, now I cannot understand as to why the maternal grandfather has come forward as next friend to the minor in this suit. No doubt a minor can be represented by any person acting as next friend, and he can file a suit under Order 32 rule of the Civil Procedure Code. But in this case, when the mother is still alive, I am of the opinion this Giriyamma, Giriyanna, the maternal grandfather cannot act as next friend of the minor. Because under Exhibit D1, it is the mother Sanna Yellamma who took the custody of the property and also the custody of the minors and the present plaintiff. The plaintiff has not explained under what circumstances he is not represented by his mother natural guardian next to his father. In my opinion, because she has executed Exhibit D1 for and on behalf of the plaintiff just to keep her away from the court, the plaintiff has approached the court through his maternal grandfather Giriyanna, which is improper.
ಮದರ್ ಇದ್ದಾಗಲೇನೆ maternal grandfather ಮೂಲಕ ಬಂದಿದ್ದಾರೆ ಅಂತ.
So ಅದೆಲ್ಲ ಆದ್ಮೇಲೆ ಏನಾಯ್ತು?
That is one thing, and another thing is only they have purchased the property only survey number 31/2 to the extent of 2 acres 2 guntahs.
2 guntahs and survey number 29/4 1 acre 31
No, my lord. What happens is this property on an earlier occasion was purchased by the father of plaintiff Nagaraj. The entire extent what the schedules which were read together, that was purchased by Nagaraj's father.
Nagaraj father ಯಾವಾಗ?
Nagaraj father is purchased under Exhibit P13.
ಅವರೇನೆ ಸ್ವಾಮಿ
P13 ಅಲ್ಲಿ ಕೊಂಡ್ಕೋತಾರೆ ಯಲ್ಲಪ್ಪ.
P12 ಬರ್ತಾರೆ.
ಯಲ್ಲಪ್ಪನ ಹತ್ರ ಯರ್ರಪ್ಪ ಕೊಂಡ್ಕೋತಾರೆ. ಅದಕ್ಕೆ ಯರ್ರಪ್ಪ ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 1 ಅಲ್ಲಿ.
ಆಯ್ತ್ರಿ. ಈಗ
ಯರ್ರಪ್ಪ is the father of Nagaraj.
ನಾಗರಾಜನ್ ತಂದೆ ಹೆಸರೇನು?
Yerrappa. He who is defendant Yerrappa who is defendant number 1 in the suit.
Oh, he is the father of Nagaraj.
Yes, he is father of Nagaraj.
He has already sold this property.
ಯರಪ್ಪನಿಗೆ ಪೂರ್ತಿ ಬಂದಿದೆಯಲ್ಲ ಎರಡು ಸರ್ವೆ ನಂಬರ್.
ಎರಡು ಬರುತ್ತೆ. ಆಮೇಲೆ ಏನ್ ಮಾಡ್ತಾರೆ, ಯರ್ರಪ್ಪ ಏಳ್ನೇಸ್ ಇನ್ ಫೇವರ್ ಆಫ್ ಮುನಿಯಮ್ಮ. The interesting aspect to be noted, my lords.
ಯರಪ್ಪ sold in favor of
Munyamma.
Munyamma.
Now, what happens, my lords, in my synopsis?
That was on 9/1867.
I will complete my arguments. Categorically explain everything. I will categorically everything. ಇದರಲ್ಲಿ ಈ ಸ್ವಾಮಿ ಇದ್ರಲ್ಲಿ ನೋಡಿ ಸ್ವಾಮಿ, ಇದರಲ್ಲಿ ಎಕ್ಸಿಬಿಟ್ P12 ಅಲ್ಲಿ ಎಕ್ಸಿಬಿಟ್ P1 ಅಲ್ಲಿ ಯರ್ರಪ್ಪ ಸನ್ ಆಫ್ ರಾಮಯ್ಯ ಇನ್ ಫೇವರ್ ಆಫ್ ಮುನಿಯಮ್ಮ ಅಂತ
ಮುನಿಯಮ್ಮನಿಗೆ ಸೇಲ್ ಮಾಡಿದಾನೆ ಎಂಟೈರ್ ಲ್ಯಾಂಡ್.
ಮುನಿಯಮ್ಮ ಏನ್ ಮಾಡ್ತಾರೆ, ಈ ಸಣ್ಣ ಯಲ್ಲಮ್ಮಗೆ ದಟ್ ಈಸ್ ದಿ ಪ್ಲೇಂಟಿಫ್ ಇನ್ OS 136 ಮದರ್ ಅಂಡ್ ಸನ್ ಗೆ 2 acres 2 guntahs ಆಫ್ ಲ್ಯಾಂಡ್ ಮಾರ್ತಾರೆ. ಈ 1967 ಅಲ್ಲಿ ಮುನಿಯಮ್ಮ ಮುನಿಯಮ್ಮ ಇನ್ ಫೇವರ್ ಆಫ್ ಸಣ್ಣ ಯಲ್ಲಮ್ಮ ನಾಗರಾಜ್.
ಯರ್ರಪ್ಪ ಏನ್ ಇಟ್ಕೊಂಡಿಲ್ಲ, ಎಲ್ಲಾನು ಸೇಲ್ ಮಾಡಿದ್ದಾರೆ.
ಅವರೆಲ್ಲ ಸೇಲ್ ಮಾಡ್ಬಿಡ್ತಾರ ಅವ್ರು ಪೂರ್ತಿ. ಇಲ್ಲೇ ಬರ್ತಾರೆ ಯಲ್ಲಪ್ಪ ಬಂದ್ಬಿಟ್ಟು ಅವ್ರ ತಂದೆ ಇರ್ಬೋದು, ಬಟ್ ಈ ಹಾಸ್ ಆಲ್ರೆಡಿ ಸೋಲ್ಡ್ ದಿ ಪ್ರಾಪರ್ಟಿ. ಮುನಿಯಮ್ಮನಿಂದ ನಾವು ತಗೊಂಡಿರೋದು, ನಾಟ್ ಫಾರ್ ಮೈ ಫಾದರ್.
ಬಟ್ ಯರ್ರಪ್ಪ ಸೋಲ್ಡ್ ಓನ್ಲಿ 2 acres 2 guntahs.
ಹೌದು, 2 acres 2 guntahs ನಾನು ಕ್ಲೈಮ್ ಮಾಡ್ತಿರೋದು ಅಷ್ಟೇ. ಯಲ್ಲಪ್ಪ ಮುನಿಯಮ್ಮಗ್ ಸೇಲ್ ಮಾಡ್ತಾರೆ, ಮುನಿಯಮ್ಮ ಬಂದು ಸಣ್ಣ ಯಲ್ಲಮ್ಮಗ್ ಮಾರ್ತಾರೆ, ಮತ್ತೆ ನಾಗರಾಜ್ಗೆ. I have become the owner of 2 acres 2 guntahs. Now he is alleging he is entirely total, he is owner of total extent 2 acres 13 guntahs of the acquired land.
ನೀವು ಕ್ಲೈಮೆಂಟ್ಸ್ ನಂಬರ್ ಯಾರ್ಯಾರು ನೀವು?
9 and 10.
9 and 10 ಯಾರು ಇವ್ರು ನೀವು?
ಶ್ರೀನಿವಾಸ ಅಯ್ಯಂಗಾರ್ ಅಂಡ್ ಬಸಪ್ಪ ಅಂತ.
ಅವ್ರಿಗೆ ಹೇಗ್ ಬಂತ ಪ್ರಾಪರ್ಟಿ?
ಇಬ್ರು ಜಾಯಿಂಟ್ ಅಲ್ಲಿ ತಗೋತಾರೆ. ಇವ್ರ ಹತ್ರನೇ ಸಣ್ಣ ಯಲ್ಲಮ್ಮ ನಾಗರಾಜ್ sold the property under exhibit P6, that is sale deed dated
Exhibit P6.
P6 31/8/94.
In favor of whom ಹೇಳಿ?
In favor of ಸಣ್ಣ ಯಲ್ಲಮ್ಮ ಗಿರಿಯಣ್ಣ and wife of ಯಲ್ಲಪ್ಪ and Nagaraj as alienated land bearing survey number 31/2 in favor of Srinivas Iyengar and R Basappa, that is 31/2 measuring 2 acres 2 guntahs of land.
ಅದೇನೆ 31/8/94ರಲ್ಲಿ.
31/8/94ರಲ್ಲಿ as per exhibit P6. Now
ಶ್ರೀನಿವಾಸ ಅಯ್ಯಂಗಾರ್ and ಇನ್ನೊಬ್ಬ ಯಾರು?
ಬಸಪ್ಪ 9 and 10. Now 9 claimant number 9 Srinivas Iyengar is no more, is dead. LRs are brought on record. LRs of ಈಗ ಇದರಲ್ಲಿ ಇವ್ರು ಏನ್ ಮಾಡಿದ್ರು, OS 136 ಅಲ್ಲಿ the last para I like to note lordship, the last page of the judgment para 10. Under such circumstances, I am clearly of the opinion the suit filed by the plaintiff exposing a maternal grandfather as guardian is not maintainable. He cannot claim also challenge the alienation made by his father, so after becoming separate from the family. Now para 10 Swami, para 10 of the judgment in page number 17. Having regard to the provisions under order 20 rule 5 CPC, I am clearly of the opinion that the finding on the above issues is sufficient to the decision of the suit itself, and there is no necessity to consider the other issues. So other issues, they are not given any finding except on this technical ground, because those things will coming to picture depending upon the findings on the above said issues, and also answered against the plaintiff. In the result, I pass the following order. Suit of the plaintiff and the same is dismissed in view of the peculiar circumstances.
Judgment ಏನಾದ್ರು ಚಾಲೆಂಜ್ ಆಯ್ತಾ?
ಇಲ್ಲ. He was a minor.
He was minor on 1976.
No findings were given in
Dismissal in 1987.
Now, in fact, this minor son was not at all aware regarding the purchase of the said property 2 acres 2 guntahs, which is the subject matter of the suit in the year 1967 itself by his own mother and himself. He was represented by his own mother as a guardian. Now, in my learned friend is
maternal grandfather. Represented through maternal
grandfather. When mother was alive, a technical ground aduk matra is madadu. No issues were regarding other issues, no findings were given. Idar mele madadu. Now, this 1967 ಅಲ್ಲಿ ಇವರು ಆಗ್ಲೇ he was the owner of the property in respect of 2 acres guntahs, though it is a subject matter of the suit. 2 acres 13 guntahs total ಆಗಿರುತ್ತೆ. ಇದರಲ್ಲಿ already he was a owner of the property in respect of 2 acres 2 guntahs. He and his mother. He was not aware because he was a minor, represented by a wrong person. So on that technical ground, suit was dismissed. Does it mean that I have lost my right over the property 2 acres 2 guntahs which was purchased earlier in 1967? Now, my learned friend is agitating as per exhibit P14, my lord. 21/4/1974. This Yerrappa who was retained 11 guntas of land in 31/2, survey number 31/2. And remaining property 29.
1 acre 31 guntas.
30 ಎರಡು ಸೇರಿಸಿ 21/474 ನಲ್ಲಿ
Yerrappa
sold to one Mallaya.
Mallaya.
This Mallaya was also a party to the said suit in OSL. Now, your lordship, I kindly like to your lordship attention to exhibit P14, my lord. Exhibit P14 ಅಲ್ಲಿ typed copy of the sale agreement.
ಈ ಶ್ರೀನಿವಾಸ ಅಯ್ಯಂಗಾರು ಮತ್ತೆ ಬಸಪ್ಪ ಬಂದಂತ ಡಾಕ್ಯುಮೆಂಟ್ ಯಾವ್ದು ಎಕ್ಸಿಬಿಟ್
P6.
P6.
ಅದನ್ನು ಓದ್ತೀನಿ ಸರ್, ಅದನ್ನು ಓದ್ತೀನಿ. ಫಸ್ಟ್ 21/4/74 ಅಲ್ಲಿ ಈ ಸೇಲ್ ಡೀಡ್ ಟೈಪಡ್ ಕಾಪಿ ಆಫ್ ದಿ ಜಡ್ಜ್ ಸೇಲ್ ಡೀಡ್.
ಅದು ದಟ್ ಈಸ್ ವಿತ್ ರಿಗಾರ್ಡ್ ಟು ದಿ 11 ಗುಂಟಾಸ್ ಅಂಡ್ 1 acre 31.
ಇವ್ರು ಹೇಳೋದು ಎರಡು ಸೇರಿಸಿ ನಮಗೆ ಬಂದಿದೆ ಅಂತ ಇವ್ರು ಹೇಳೋದು. ಅದನ್ನೇ ಇದರಲ್ಲಿ ಓದ್ಬಿಡ್ತೀನಿ ಸ್ವಾಮಿ. ಶೆಡ್ಯೂಲ್ ವಿವರ ಅಂತ ಇದೆ ಇದರಲ್ಲಿ. ರಾಮಾಯಣ
mostly they are based on this exhibit P14.
They are claiming 2 acres
claiming
13
to the extent
guntas.
of 2 acre 13 guntas.
ಹೌದು.
Originally survey number 31/2.
ಅದೇ ಅದ್ರಲ್ಲಿ ಅದನ್ನೇ ನಾನು ಓದಕ್ಕೆ ಹೇಳಿದೆ. ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಇದೆ ಅದು. ಈ ಶೆಡ್ಯೂಲ್
But actually the sale in favor of Mallaya.
ಮಲ್ಲಯ್ಯ ಆಯ್ತು. ಈ ಮಲ್ಲಯ್ಯ ಏನು ಬಂದಿರೋದು 2 acres 2 guntas ಅಲ್ಲಿ 29/4 1 acre 31 guntas of land and 31/2 ನಲ್ಲಿ 11 guntas of land. That is the sale it discloses here. Schedule ವಿವರ ಬೆಂಗಳೂರು ನಾರ್ತ್ ತಾಲೂಕು ಯಶವಂತಪುರ ಹೋಬಳಿ ತಾಲೂಕು ಗ್ರಾಮಕ್ಕೆ ಸೇರಿದ ಸರ್ವೆ ನಂಬರ್ 24.
It is clear counsel. Remaining 11 guntas.
ಹೌದು.
And also survey number
29/4
ಅಲ್ಲಿ
ಹೌದು
1 acre 31 guntas.
ಇದೆರಡು ಸೇರಿ 2 acres
ಮಲ್ಲಯ್ಯಂಗ್ ಬಂತು.
ಹೌದು.
ಟೈಟ್ಲಿಗೆ ಏನ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ.
ಅದೇನಿಲ್ಲ. ಇವ್ರು ಹೇಳೋದು ಈ ಸೇಲ್ ಡೀಡ್ ಪ್ರಕಾರ ಟೋಟಲ್ ನಮ್ಗೆ ಬರ್ಬೇಕು 31/2 2 acres 13 guntas of land ಅಂತ ಇವ್ರು ಕೇಳೋದು.
ಅವ್ರ
ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಅದು. ಅದಕ್ಕೆ ಇಲ್ಲಿ ಚೆಕ್ ಬಂದು ಇಲ್ಲಿ ಹೇಳಿರ್ತಾರೆ ಸ್ವಾಮಿ. 31
ಸರ್ವೆ ನಂಬರ್ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಮೆನ್ಷನ್ ಮಾಡಿದಾರಲ್ಲ.
ಮಾಡಿದ್ದಾರೆ. ಅದನ್ನೇ ಹೇಳಿದ್ರು
29 ಮತ್ತು 1 acre 31 ಗುಂಟೆ ಅಂತ ಬರ್ದಿದ್ದಾರೆ.
31 ಸಭೆ ಪೂರ್ವ ಜಮೀನು ಚೆಕ್ ಬಂದಿ ಯರ್ರಪ್ಪ ಪೂರ್ವಕ್ಕೆ ನರಸಿಂಹಯ್ಯ ಜಮೀನು, ಪಶ್ಚಿಮಕ್ಕೆ ಮುನಿಯಮ್ಮನಿಂದ ಸಣ್ಣ ಯಲ್ಲಮ್ಮ ಕ್ರಯ ನಮ್ಮ ಇದು ಬರ್ತದೆ ಮಾಡಿಸಿಕೊಂಡಿರುವ ಜಮೀನು, ಉತ್ತರಕ್ಕೆ ದಾಸಪ್ಪನವರ ಜಮೀನು, ದಕ್ಷಿಣಕ್ಕೆ ಈ ಮಧ್ಯ ಇರುವ 2 acre 2 ಗುಂಟೆ 29/4 ಮತ್ತೆ 31/2
ಸೇರಿ
2 ಸೇರಿ 2 acre 2 ಗುಂಟೆ ಬರ್ತದೆ.
2 acre 2 ಗುಂಟೆನಾ?
ಹೌದು, 2 acre 2 ಗುಂಟೆನೆ
ಅಷ್ಟೇ ಆಗೋದು.
ಅಷ್ಟೇ ಇರೋದಿರ್ಲಿ. 2 acre 2 ಗುಂಟೆ
11 + 1 31.
ಈ ಇದರಿಂದ ಏನಾಯ್ತು, ಇವರು ನಾವೇನೆ ಪೂರ್ತಿ ಅದನ್ನ ಈ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಮೇ ಕೈಂಡ್ಲಿ ಎವಿಡೆನ್ಸ್ ಆಫ್ PW2. ಸೊ ಎಕ್ಸಾಮಿನೇಷನ್ ಚೀಫ್ ಐ ಲೈಕ್ ಟು
LIC ನೀವು ಹೇಳ್ತಾ ಇರೋದು LIC ಕೇಸಲ್ಲಿ
LIC ಕೇಸಲ್ಲಿ PW2 evidence of PW2 one Mr. Kumar has given the evidence. He is son of late Shivarama and in para examination chief alli evidence of PW2 Yellavara claimant number 1C by way of affidavit. In examination chief in para 5 of the affidavit, my lord. Para 5, I further submit that Yellappa alias Mariappa, also called as Mari, being absolute owner of survey number 31/2, along with the other survey numbers as sold in favor of Yerrappa under the registered partition, registered sale deed dated 21/4/66. In turn, Yerrappa sold entire survey number 31/2 in favor of my maternal grandfather, Mallaya ಅಂತ ಹೇಳ್ತಾರೆ ಇಲ್ಲಿ. Entire ಅಲ್ಲಿ sale deed discloses only 11 guntas of land. He in the examination chief, he has stated that entire land has been sold. My maternal grandfather under registered sale deed dated 21/4/1974. Just now I brought to your lordship notice that is only 11 guntas in 31/2 and 29/4 1 acre 31 guntas of land, 2 acres 2 guntas of land.
Yes.
So, and he was exercising acts of ownership anta idralli ellunu 29/4 he never whisper regarding the
ಪ್ರಾಪರ್ಟಿ.
ಎವಿಡೆನ್ಸ್ ಎಲ್ಲ ಏನು ಹೇಳೋದೇ ಇಲ್ಲ.
ಹೌದು. ಸೊ your lordship may kindly come to the cross examination.
ಈಗ ಅಕ್ವಿಸಿಷನ್ ಆಗಿರೋ ಪ್ರಾಪರ್ಟಿ ಸರ್ವೆ ನಂಬರ್ 31/2
2 acres 31 ಗುಂಟಾಸ್ 2 acres 13 ಗುಂಟಾಸ್
13 ಗುಂಟಾಸ್.
ಹೌದು. ಇವ್ರದ್ದು 11 ಗುಂಟೆ, ನಮ್ದು 2 ಎಕರೆ 2 ಗುಂಟೆ ಅಷ್ಟೇ ಸ್ವಾಮಿ. In the cross examination you like to see the page number 12 of the cross examination. Cross examination page number 12. Para 6, my lord. Para 6, page number 12 of the cross examination. ಇದರಲ್ಲಿ ಪ್ಯಾರಾ 6 ಅಲ್ಲಿ ಉಳ್ಳಾಳು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 29/4 ಒಟ್ಟು ವಿಸ್ತೀರ್ಣ 1 ಎಕರೆ 31 ಗುಂಟೆ. ಮಲ್ಲಯ್ಯ ನನ್ನ ತಾಯಿಯ ತಂದೆ ಆಗಬೇಕು. ಯರಪ್ಪನಿಂದ ನಮ್ಮ ತಾತ ಮಲ್ಲಯ್ಯ ದಿನಾಂಕ 21/4/74 ಸರ್ವೆ ನಂಬರ್ 29/4 ಮತ್ತು 31/2ಗಳಿಗೆ ಒಟ್ಟು ಚೆಕ್ ಬಂದಿ ಸೇರಿಸಿ 2 ಎಕರೆ 2 ಗುಂಟೆ ಜಮೀನನ್ನು ಕೊಂಡುಕೊಂಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ದಕ್ಕೆ ಸಾಕ್ಷಿ ಪೂರ್ತಿ ಜಮೀನು ಕೊಂಡಿದ್ದರು ಅಂತ ಹೇಳಿದ್ದಾರೆ. ದಿಸ್ ವಾಟ್ ಕ್ರಯಪತ್ರದಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 29/4 1 ಎಕರೆ 31 ಗುಂಟೆ ಹಾಗೂ ಸರ್ವೆ ನಂಬರ್ 31/2 11 ಗುಂಟೆ ಜಮೀನು ಸೇರಿಸಿ ಕರೆಸಿದ್ರು ಅಂತ ಅನ್ನುವುದು ಸರಿಯಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾ 6 ಸರ್ವೆ ನಂಬರ್ 29/4 ಮತ್ತು 31/2 ಪಶ್ಚಿಮ ದಿಕ್ಕಿಗೆ ಸರ್ವೆ ನಂಬರ್ 31/1 ಜಮೀನು ಇದೆ. ಕ್ರಯಪತ್ರದಲ್ಲಿ ಕ್ಲೈಮ್ ನಂಬರ್ 14 ಜಮೀನು ಪಶ್ಚಿಮ ದಿಕ್ಕಿಗೆ ಮುನಿಯಮ್ಮನಿಂದ ಸಣ್ಣ ಯಲ್ಲಮ್ಮ ಕ್ರಯ ಮಾಡಿಕೊಂಡಿರುವ ಜಮೀನು ಅಂತ ಬರೆದಿದ್ದಾರೆ ಅಂತ ಕೇಳಿದಕ್ಕೆ ಸಾಕ್ಷಿ ಅದು ತಪ್ಪಾಗಿ ಬರೆದಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಆ ಬಗೆಗೆ ಕ್ರಯಪತ್ರ ತಿದ್ದುಪಡಿಯಾಗಿಲ್ಲ. ಯರ್ರಪ್ಪನಿಗೆ ಸರ್ವೆ ನಂಬರ್ 31/2 11 ಗುಂಟೆ ಜಮೀನು ಬಿಟ್ಟು ಬೇರೆ ಜಮೀನು ಇರಲಿಲ್ಲ ಅನ್ನೋದು ಸರಿಯಲ್ಲ. ಯರ್ರಪ್ಪ ತಾನು ಇಟ್ಟುಕೊಂಡ ಮೂಲ ಕ್ರಯಪತ್ರವನ್ನು ನಮ್ಮ ತಾತನಿಗೆ ಕೊಟ್ಟಿದ್ದ. ಆಮೇಲೆ ಪ್ಯಾರಾ ನಂಬರ್ 8 ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್. ಪ್ರಮಾಣ ಪತ್ರದಲ್ಲಿ ಹೇಳಿದಂತ ಉಯಿಲನ್ನು ನಾನು ಹಾಜರುಪಡಿಸಿದನೋ ಇಲ್ಲೋ ಅಂತ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಆ ಉಯಿಲಿನನ್ನು ನಾನು ನೋಡಿದ್ದೇನೆ. ಉಯಿಲಿನಲ್ಲಿ 2 ಎಕರೆ 2 ಗುಂಟೆ ಜಮೀನು ಅಂತ ಐಟಮ್ ನಂಬರ್ ಅಲ್ಲಿ ಬರೆದಿದ್ದಾರೆ. ಆ ಜಮೀನು ಪಶ್ಚಿಮಕ್ಕೆ ಸಣ್ಣ ಯಲ್ಲಮ್ಮ ಜಮೀನು ಅಂತ ಉಯಿಲಿನಲ್ಲಿ ಬರೆದಿದ್ದಾರೆ. ಸಾಕ್ಷಿ ತಪ್ಪಾಗಿ ಬರೆದಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಆ ಬಗ್ಗೆ ಉಯಿಲು ಪತ್ರವನ್ನು ಸರಿಪಡಿಸಿಲ್ಲ. ಪಶ್ಚಿಮಕ್ಕೆ ತೋರಿಸಿದಂತ ಜಮೀನು ಸಣ್ಣ ಯಲ್ಲಮ್ಮನೆ ಮುನಿಯಮ್ಮನಿಂದ ಖರೀದಿಸಿದ ಜಮೀನು ಅಂತ ಅನ್ನೋದು ಸರಿಯಲ್ಲ. ಕಮಿಂಗ್ ಟು ಪ್ಯಾರಾ ನಂಬರ್ 10, ಮೈ ಲಾರ್ಡ್. ಸಣ್ಣ ಯಲ್ಲಮ್ಮ, ಮುನಿಯಮ್ಮ ಮತ್ತು ನಾಗರಾಜ್ ಅವಿದ್ಯಾವಂತರು ಅಂತ ಅನ್ನೋದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಅವರೆಲ್ಲ ನಮ್ಮ ತಾತನ ಮನೆಯಲ್ಲಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದರು. ನಮ್ಮ ತಾತ ಮಲ್ಲಯ್ಯ ಅವ್ರನ್ನೆಲ್ಲ ಎತ್ತಿ ಕಟ್ಟಿ ಅವರ ಮೂಲಕ ಗೇಣಿ ಅರ್ಜಿ ಮತ್ತು ವಸೂಲು ಹಾಕಿದ್ದಾರೆ ಸರಿಯಲ್ಲ. ಇದರಿಂದ ಎಸ್ಟಾಬ್ಲಿಷ್ ದಟ್ ಐ ಆಮ್ ದಿ ಓನರ್ ಆಫ್ 2 acres 2 ಗುಂಟಾಸ್ ಆಫ್ ಲ್ಯಾಂಡ್ and he is the owner of 2 acres only 11 guntas of land. Whereas your lordship may kindly turn to the judgment by coming to the judgment, my lord. It has para number 12, my lord. Para number 12 of the judgment. Before that, my lord, I like to know the facts regarding para 10 of the judgment, my lord. Para 10 of the judgment regarding all the sale deeds have been categorically stated. Para 10 of the judgment, page number 9, my lord. Facts admitted need not be proved. That survey number 31/2 measuring 2 acres 13 guntas of land earlier belonged to one Yellappa alias Mariappa, who sold such property in favor of one Yerrappa son of Ramaya under registered sale deed dated 21/4/66. In fact admitted. Consequently, right title interest of Yerrappa in and over survey number 31/2 measuring 2 acres 13 guntas of land being a fact admitted need not be proved. Consequently, sale deed in favor of Yerrappa though not cannot be read as infirmity in creating rights in favor of the parties concerned. So far as good. So far so good. Deviation takes place hereafter. Consequently, by necessity, as already stated, statements of the contesting claimants must be supported by the documents.
Otherwise, their whole evidence would only be a cock and bull story, based on which no judicial orders can be passed. According to PW1 Basappa, that Yerrappa son of Ramaya sold an extent of 2 acres 2 guntas of land in survey number 31 in favor of Srimati Muniamma. Out of that 2 acres 13 guntas of land, and further that Yerrappa had retained balance 11 guntas of land. It was land under, it was sold into mark. It was sold under registered sale deed dated 9 marked as Exhibit P1. A bare reading of the contents of that exhibit, which is certified copy of the sale deed, would reveal unambiguously that the property sold there was in favor of said Muniamma, and that the extent of the property sold was 2 acres 2 guntas out of the 2 acres 13 guntas. In that view of the matter, the oral evidence of PW1 stands substantiated by the documentary evidence marked as Exhibit P1. There is transfer of title to the property in favor of Srimati Muniamma pertaining to that extent of land measuring 2 acres 2 guntas. Hereafter, the flow of title would continue as it being spoken by PW1, and that spoken evidence of PW1 also stands substantiated by the documentary piece of evidence. That PW1 further says that Muniamma in turn sold such property in favor of Srimati Sannayallamma under minor son Nagraj, evidenced by the registered sale deed dated 26/6/67. The certified copy which is marked as Exhibit 2. A bare reading of the contents of this document would substantiate the claim of PW1 in that regard. That Exhibit 2 was acted upon, in pursuance to which the mutation was carried out. The mutation register extract in that regard is marked as Exhibit P3 pertaining to the survey number 31/2 measuring 2 acres 2 guntas of land. Exhibit P3 does make reference to the sale effected by that Muniamma in favor of Sannayallamma and her son Nagraj. Exhibit P4 is the record of rights and so on. So according to PW1, Srimati Sannayallamma and her son in turn sold the property in their favor under a registered sale deed dated 31/8/1994. That is Exhibit P6 by law. The original registered sale deed is that regard is marked as Exhibit P6. A bare reading of the contents of this Exhibit P6 would substantiate such a sale being effected in favor of claimants number 10 in this case Srinivasa Iyengar and Basappa. It was executed by Srimati Sannayallamma and her son Nagraj. Description of the property substantiating the claim share, survey number 31/2 measuring 2 acres 2 guntas. There is also a need to highlight at this stage only the eastern boundary to the property sold under Exhibit P6. It makes reference to the property belonging to Shivamma, wife of Revanna. The aspect so long also go a long way in sanctifying the claim being made by PW1 that Exhibit P6 was also acted upon. Mutation was affected, and the mutation register in that regard is marked as Exhibit P7, P8 in that record of rights. So para numbers 13 my lord. Para number 13 of the judgment. This is the most important. It is the case of PW1 that Yerrappa, who has retained 11 guntas of land subsequent to the sale, he had effected in favor of Muniamma under Exhibit P1 dated 90, has sold it to another Mallaya under registered sale deed dated 21/4/74. The certified copy which is produced got marked in PW1 at PD Exhibit P10. Very same document is also marked as Nitalla Bantarjun. Next page. Continue according page para 14 of the judgment, my lord. 14. According to PW1, an extent of 11 guntas of land was sold under Exhibit P10. This was 21/4/74. While PW2 asserts that the extent of property measuring 2 acres 13 guntas of land belonging to the Yerrappa son of Ramaya was sold in favor of Mallaya along with several properties. There is a need to highlight the date of this Exhibit P14, same as Exhibit P10. It is dated 21/4/74. Obviously, it has come into the existence subsequent to the due execution of Exhibit P1, dated 9/5/1967. This date is 9/5/96. I have vendors of my vendors, Sannayallamma and Nagraj. Saleable interest retained by that Yerrappa in the survey number 31/2 was only to the extent of 11 guntas. An extent of 2 acres 2 guntas of land was already sold under Exhibit P1 in favor of that Muniamma. Consequently, the assertion of PW2 that under Exhibit P14, the entire extent of property sold in favor of Mallaya is falsified. There being no saleable interest, The claim stands not established that Yerrappa could not have sold any such property other than 11 guntas of land. That apart, a bare reading of the contract, contents of the document itself would reveal a degree of ambiguity. There are as many as 5 different properties sold under that exhibit petition, as could be seen from the schedule to that seal. Survey number 31 proceeds to give the boundaries to the entire properties, that is
The set two survey numbers.
to the search 2 survey numbers, and speaks of their entire extent belonging 2 acres 2 guntas sold under exhibit P10 P14. That Yerrappa was the owner of entire 2 acres 13 survey number, which he has purchased from his erstwhile owner Yellappa as Mariappa under the registered sale date 31/4/1966. Since item number 1 referred to is scheduled to exhibit P14 refers to the extent of 2 survey numbers 2 acres 2 guntas, it falsifies the claim of PW2. It must have been anything more than 2 acres 2 guntas. In respect of this schedule only, there is also a need to highlight the boundaries on the western side. It is the property belonging to Sanna Ellamma purchased from the Muniamma exhibit P2. That would in turn sanctify exhibit P1 and P2. That apart, according to PW1, survey number 29/4 measuring 1 acre 31 guntas, and the property retained by Yerrappa in the survey number is being only 11 guntas. The total extent and should sold and referred to at that item number 1 in the schedule 2 acres 2 guntas, 1 acre 11 guntas of 29/4. 11 that line of arguments make the reading of the document exhibit P14 intelligible. Consequently, that Mallaya have derived the interest in respect of 11 guntas of land only in that survey number 31/2 and nothing more than that. Now hereafter the interest of PW2 flows that Mallaya, according to PW2, executed a will in favor of his daughter Shivamma. That PW2 speaks of the very many other aspects connected with the so-called rights. He speaks to the initiation of change of kata. He also speaks the orders reference so and so forth. And the next page al bರ್ತದೆ. Page number 17 ಅಲ್ಲಿ they cannot hope to enlarge the scope of the sales under P14. The rights which the Shivamma could claim in that survey number 31/2 was only in respect of 11 guntas of land, in respect of which no part of it is being claimed by PW1 claimant number. Suffice to say, PW2 can only hope to claim the property in respect of that 11 guntas of land in the survey number 31/2 by virtue of the will, which is not being. So, therefore, this trial court has awarded passed in respect of 2 acres 2 guntas for the claimants number 9 and 10 and 11 guntas for appellants. So that means that the judgment passed by the trial court is correct. Therefore, all the sale deeds itself discloses that I have purchased the property. Merely because the suit has been dismissed, it has been dismissed on technical grounds. No reasoning and explanations are forthcoming in respect of any other issues except our technical ground is dismissed. By that time, I was already owner of 2 acres 2 guntas myself and my mother. Therefore, I pray that this Honorable Court will please to dismiss the appeal.
Let's have raised 2 line arguments, my lord. One is whether boundaries prevail or extend. Boundaries prevail or extend. Now, why I'm raising this line of argument is what necessitated the vendors of respondent 9 and 10 to file.
Are claiming to the extent of 2 acres 13 guntas also.
I'm claiming to an extent of 1 acre 31 guntas. I'll demonstrate how, my lords.
And also
1 acre 31 guntas in 29/4 31/2.
ನಿಮ್ಮ ಅಪೀಲ್ ಅಲ್ಲಿ ಈಗ ನೀವು ಕೇಳ್ತಾ ಇರೋದು ರಿಲೀಫ್
2 acre 2 guntas.
2 acres 2 guntas. ಹೌದಲ್ಲ?
ಹೌದು.
ನಿಮಗೆ 2 acres 2 guntas ಯಾವ ಸರ್ವೆ ನಂಬರ್ ಬಂದಿರೋದು ನಿಮ್ ಸೇಲ್ ಡೀಡ್ ಪ್ರಕಾರ?
31/2 and 29/4 towards the east of the property which is claimed by the respondent 9 and 10. Now, why I am stating so is under the sale deeds which have
ನಿಮಗೆ ಸೇಲ್ ಡೀಡ್ ಎಕ್ಸಿಬಿಟ್ P14 ಪ್ರಕಾರ ಬಂದಿರೋದು 2 acres 2 guntas. One in respect of 11 guntas in survey number 31/2. ಹೌದಾ?
ಹೌದು. ಅಲ್ಲ ಅಲ್ಲಿ ಬ್ರೇಕಪ್ ಇಲ್ಲ.
Another
breakup ಇಲ್ಲ. What happens in this all this breakup ಇಲ್ಲ. He say what happens is the first
2 ಸರ್ವೆ ನಂಬರ್ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ.
2 ಸರ್ವೆ ನಂಬರ್ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ.
2 ಸರ್ವೆ ನಂಬರ್ ಅಂದ್ರೆ 2 ಎಕರೆ 2 ಗುಂಟೆ. ಅದರಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 29/4 ಸರ್ವೆ ನಂಬರ್ 31/2 ಎರಡುವೆ.
ಹೌದು.
ಅದು ಯಾರಿಂದ ನೀವು ಕೊಂಡ್ಕೊಂಡಿದ್ದು?
ನಾವು ಯರ್ರಪ್ಪನ ಕಡೆಯಿಂದ.
ಹೌದಾ?
ಹೌದು.
ಯರ್ರಪ್ಪನ್ಗೆ ಎಷ್ಟು ಪ್ರಾಪರ್ಟಿ ಉಳಿದಿತ್ತು? ಈಗ ನೀವ್ ಹೇಳೋ ಪ್ರಕಾರನೇ ಯರ್ರಪ್ಪನ್ಗೆ ಎಷ್ಟು ಉಳಿಸ್ಕೊಂಡಿದ್ದ?
Yerrappa
31/2
31/2 and 29/4.
acquire ಆಗಿರೋದು ಸರ್ವೆ ನಂಬರ್ only 31/2 ಮಾತ್ರ
ಹೌದು
ಅಲ್ವಾ?
ಹೌದು
2 acres
2 ಗುಂಟ 13 ಗುಂಟ
13 ಗುಂಟಾಸ್.
yes.
ಅವ್ರು ಹೇಳೋದು ಕರೆಕ್ಟ್ ಇದೆಯಲ್ಲ 11 ಗುಂಟಾಸ್.
Now what I'll demonstrate my lords.
ನನ್ ಪ್ರಶ್ನೆಗೆ ಉತ್ತರ ಕೊಡಿ ಕೌನ್ಸಿಲ್ ಅಷ್ಟೇ. ನಿಮ್ಮ ಸೇಲ್ ಡೀಡ್
ಅವರು ಮುನಿಯಮ್ಮನ್ ಮಾರುವಾಗ ಈಸ್ಟ್ ಗೆ 1 ಎಕರೆ 36 ಗುಂಟೆ ಉಳಿಸ್ಕೊಂಡವ್ರೆ.
ಯಾರು?
ಯಲ್ಲಪ್ಪ ಬೌಂಡ್ರೀಸ್ ಅಲ್ಲಿ
ಉಳಿಸ್ಕೊಂಡವ್ರೆ ಅಂತ.
ಯಲ್ಲಪ್ಪ 31/2 ಅಲ್ಲಿ ಟುವರ್ಡ್ಸ್ ದಿ ಈಸ್ಟ್ he retains an extent of 1 acre 31 guntas.
ಯಾವ್ದ್ರಲ್ಲಿ?
31/2 ಅಲ್ಲಿ. Because 31/2 is north ಅಲ್ಲಿ ಬರುತ್ತೆ 29/4
ನಲ್ಲೇ ಅವ್ರು ಕೊಟ್ಟಿರೋದು ಮಾರಾಟ ಮಾಡಿರೋದು 2 ಎಕರೆ 2
ಹೌದು ಸರ್ ಈಸ್ಟ್ ಬೌಂಡ್ರೀಸ್ ಅಲ್ಲಿ
2 ಎಕರೆ 2 ಗುಂಟೆ ಮಾರಾಟ ಮಾಡಿದಾರೆ. ಹೌದಾ?
ಹೌದು 2 ಎಕರೆ 2 ಗುಂಟೆ ಮಾರಾಟ ಮಾಡ್ತಾರೆ. ಹೌದು.
ನಿಮ್ಮ ಪ್ರಕಾರ ಅವ್ನು ಹೆಂಗ್ ಉಳಿಸ್ಕೋತಾನೆ? ನಿಮ್ಮ 1 ಎಕರೆ 31.
ಯಾಕಂದ್ರೆ 29/4 ವೆಸ್ಟ್ ಬರಲ್ಲ, 29/4 ಸೌತ್ ಬರುತ್ತೆ.
ವೆಸ್ಟ್ ಗೋ ಬರ್ಲಿ ಯಾವ್ದೋ ಬರ್ಲಿ
ಬೌಂಡ್ರೀಸ್ ಪ್ರಿವೇಲ್ or extend my lord. This is my case. Why I'm demonstrating.
ಹೇಳಿ ಫಸ್ಟ್ ನೀವು.
My lords, my case is
ಕ್ಲೈಮ್ ಮಾಡ್ಬೇಕಾರೆ
why Nagaraj filed a suit in the year 1976 was for the very same reason.
ಆಯ್ತು ಅದ್ ಬಿಟ್ಬಿಡಿ. ಈಗ ನಿಮಗಿರೋ ಟೈಟ್ಲ್ ಹೇಳಿ ಫಸ್ಟ್.
My lords, my title is I am situate on survey number 31/2 towards the eastern side to an extent of 1 acre 31 guntas. Because on 31/2 towards the eastern side is 31/3, 29 barala. 29/4 comes towards the south of 31/2.
But while Yerrappa was having counsel to sell the property to you.
Yes, madam.
In 1974.
My lords, he has not.
He had already sold the property to the extent of 2 acres 2 guntas in favor of Muniyamma 9/5/1967 itself in respect of survey number 31/2.
Yes, madam. He had held it.
ಅವನಿಗೆ ಇದ್ದಿದೆ 2 ಎಕರೆ 13 ಗುಂಟೆ.
But
2 ಎಕರೆ 13 ಗುಂಟೆಲಿ 2 ಎಕರೆ 11 ಗುಂಟೆ ಮಾರಾಟ ಮಾಡಿದಾನೆ.
2 ಎಕರೆ
11 ಗುಂಟೆ
ಅಷ್ಟು ಪೊಸಿಷನ್ ಅಲ್ಲಿ ಹಾಕಿ.
You can claim that you are entitled for.
ಅವ್ರು ಅಲ್ಲಿ ಪೊಸಿಷನ್ ಹಾಕಿಲ್ಲ, ಅವ್ರ ಪೊಸಿಷನ್ ನನ್ನನ್ನ ಅಲ್ಲಿ ಸೈಡ್
ಬಿಟ್ಬಿಡ್ರಿ. ಟೈಟ್ಲ್ ಏನಿದೆ ಹೇಳಿ ಫಸ್ಟ್.
ಬಿಕಾಸ್ ನನ್ನ ಟೈಟ್ಲ್ ಇರೋದು ಅದೇ ಸ್ವಾಮಿ.
ಪೊಸಿಷನ್ ಮೇಲೆ ನಾವು ಕಂಪನ್ಸೇಷನ್ ಕೊಡಕ್ಕಾಗಲ್ಲ. ಟೈಟ್ಲ್ ಯಾರು ಇರುತ್ತೋ ಅದ್ರ ಮೇಲೆ ಕಂಪನ್ಸೇಷನ್.
I have to demonstrate my title based on the position.
That's all your argument.
And one more argument.
You are in possession ಅಂತ ಅಷ್ಟೇ.
ಅಲ್ಲ not that title is. And one more line of argument before this honorable court is kindly peruse the judgment which is against the title of the claimants here. No, it's not necessary.
ಈಗ ನೀವು ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದಿರೋದು ನೀವು.
ಹೌದು ಸರ್.
you substantiate your case. That's all.
My lords, I am on the eastern side of the under the sale deed which was executed in favor of Muniyamma. Synopsis ಅಲ್ಲಿ ಹೇಳಿದ್ದೀನಿ ಸರ್. I have detailed out in my synopsis.
ಆಯ್ತು ನೋಡಿದೀನಿ ನೋಡಿ. ಅವತ್ತೇ ಕೊಟ್ಟಿದ್ದೀರ ಅದೆಲ್ಲ ಅಂಡರ್ಲೈನ್ ಮಾಡಿದೀನಿ.
ಹೌದು ಸರ್. ಅದರಲ್ಲಿ towards the east under the sale deed what was alienated to Muniyamma, Yerrappa has retained 1 acre 31 guntas of land. So towards the east 29/4 doesn't come.
Yerrappa has retained including the survey number 29/4 and survey number 31/2.
I have produced a map and survey sketch.
Documented in this.
Document ಕೊಟ್ಟಿದ್ದೀನಿ ಸರ್. ಸರ್ವೆ ಸ್ಕೆಚ್ ಕೊಟ್ಟಿದ್ದೀನಿ. ಸರ್ವೆ ಸ್ಕೆಚ್ ಅಲ್ಲಿ ಈಸ್ಟ್ ಗೆ 29/4 ಇಲ್ಲ. ಅಲ್ಲೇ ಅದೇ ಜಮೀನ ಉಳಿಸ್ಕೊಂಡು ಅದೇ ಕಾರಣಕ್ಕೆ ಇವರು.
He is the owner to the extent of 29/4 and 31/2.
Yes, my lords.
Once Yerrappa had sold the property to the extent of 2 acre.
2 guntas.
2 guntas. How you can claim that he was retained the property to the extent of 1 acre 31 guntas?
His documents.
That is survey number 29/4 1 acre 31 guntas.
ಇಲ್ಲ. So 31/2 ಅಲ್ಲಿ 1 acre.
Title ಇರೋದೇ ಹಾಗೆ. That's all.
Not sir, my case is boundaries prevail over extend, my lord. And moreover, this suit, my lord, was filed in the year 1976 and plaintiff was aged 16 years. Suit was dismissed in the year 1987. Plaintiff has not taken any steps and he claims possession. He is not in possession over the land. That is the reason for the boundaries prevail over measurement. I was put in this position. He comes up with that suit in the year 1976 at the age of 16 years and the suit is conducted. And even in the suit, my lords, there is a finding to the effect that Sanna Lamma has already released all the properties in favor of at para 6 of the said judgment, my lords.
ಯಾವ್ದ್ರಲ್ಲಿ original suit?
Original suit 1976 133 of 1976.
Who cannot take the advantage in weakness of the defendant?
No, there is a
first you have to prove your case on your strength. Maybe observation made in the court by misconception.
But there is a decree against the vendor. There is a decree against
your case. You make out your case. Not relying upon the judgment of the other case.
I am making out my case on the basis of boundaries, my lords.
That's all. Only on boundaries.
I am based on the boundaries because towards the east, I have produced documents to that effect.
How do the appellant counsel and also the counsel appearing for the respondent? This miscellaneous first appeal is filed challenging the judgment and decree passed in LAC number 101 of 2004. Wherein when the 30 reference was made before the court, the trial court passed an order that PW1 Basappa, claimant number 10, for himself and also on behalf of that claimant, number 9, K. Srinivasa Iyengar, and that PW2 Kumar, for himself and on behalf of other legal representatives of claimant number 1, comes to the conclusion that proved their title and interest in and over 2 acres 2 guntas of land in that survey number 31/2, situated at Ullal village, Yashwantapura Hobli, Bangalore, North Taluk. Consequently, they are entitled for the corresponding compensation amount awarded in the case. Claims of PW3 G. Nayana Chandra and the persons he represents are rejected. Said PW1 Basappa and PW2 Kumara are also entitled for the statutory benefits, with interest at the rate of 9% per annum from the date of taking possession of the acquired survey number for the initial period of 1 year, and thereafter such rate of interest shall be 15%, till such amount is paid or deposited in the court. Said PW1 Basappa and PW2 Kumara each shall execute an indemnity bond to the extent of the compensation amount they are entitled together with a surety in the like sum each. This impugned order is challenged in this present appeal. The main contention of the appellant who passed away, and the legal representatives are the appellants who are brought on record, mainly contended that the impugned judgment and award passed by the learned trial judge is not sustainable, either under law or on facts, and the same has to be modified to the entire extent of land measuring 2 acres 13 guntas in the land bearing survey number 31/2. Learned judge has failed to appreciate the documents in a proper perspective and does not apply his mind properly. Trial judge has failed to appreciate the documents and evidence adduced and produced in support of the case of the appellant. Full stop. It is very clear, in the case of the appellant that, they have been in settled possession and enjoyment of the land in question since the tenure of his ancestors since 1974, and all revenue documents are standing in the name of the appellant mother, the said aspect has not been considered while rendering the judgment and award. It is also contended that the trial judge has failed to appreciate the fact that, till the land was taken possession from the deceased claimant number 1, all revenue records are standing in her name. First, possession was also taken from her, the said aspect was not considered by the learned trial judge while passing the impugned judgment and award. There was no finding about the document produced at Exhibit P17, that is the decree passed by the Additional Civil Judge, Bangalore District. Therein it is very clear that suit filed claiming possession from the mother of the appellants was dismissed. In that, it is very clear that prior to 1976, the appellant's mother has been in possession and enjoyment of the same, and she was in settled possession. And in view of the fact that she has been in possession and enjoyment of the same since more than 28 years, as on the date of taking possession of the land by the Bangalore Development Authority. The council would vehemently contend that when the possession is with the appellant and the same has not been considered by the trial court and committed an error in passing such an order. Per contra, the council original for the respondent claimant number 9 and 10 would vehemently contend that it is not in dispute that originally property belongs to one Kuntayya. The said Kuntayya sold the property in favor of Yellappa on 21/4/1962 in terms of Exhibit P12. That is in respect of survey number 31/2 to total extent 2 acres 13 guntas. And in respect of survey number 29/4 1 acre 31 guntas. The council also would submit that the said Yellappa sold the property in favor of Yerrappa on 21/4/1966 in terms of Exhibit P13 to the whole extent in survey number 31/2 and 29/4. The council also would submit that the said Yerrappa sold the property on 9/5/1967 in favor of Muniamma in terms of Exhibit P1, that is survey number 31/2 to the extent of 2 acres 2 guntas. And out of 2 acres 13 guntas. The property survey number 31/2 remains with Yerrappa, that is 11 guntas. Next para. The said Muniamma sold the property in favor of Srimati Muniyallamma and Nagaraja in terms of
Sanna Yellama and Nagaraja.
Sanna Yellama and Nagaraja. In terms of Exhibit P2, where it sale deed dated 26/6/1967 to the whole extent of 2 acres 2 guntas in survey number 31/2. They said Sanna Yellamma and Nagaraj have sold the property to Srinivasa Iyengar and Basappa, who are the claimants number 9 and 10 in terms of Exhibit P6, where sale deed dated 31/8/1994. Hence, it is contended that they are owners to the extent of 2 acres 2 guntas in respect of survey number 31/2. The council also would submit that the appellant claims their title to the property to the extent of 2 acre 2 guntas in terms of Exhibit P14. And the same is only remaining extent of 11 guntas in survey number 31/2 and 1 acre 31 guntas in survey number 29/4. From Yerrappa in favor of Mallayya. The council also would submit that the evidence of PW2 is also very clear that in his evidence before the trial court, he deposes with regard to the entire land in survey number 31/2 and not claims in respect of survey number 29/4. And in the cross examination in paragraph number 6, specific suggestions are made with regard to purchasing the property in survey number 29/4 and survey number 31/2 to the remaining extent of 11 guntas and also 1 acre 31 guntas in survey number 29/4. And the trial court, having considered the evidence of this, the PW2 and also considering the entire oral and documentary evidence, rightly comes to the conclusion that the respondents are entitled for claim in respect of to the extent of 2 acre 2 guntas in survey number 31/2 and not committed any error. Having heard the appellant counsel and also the counsel appearing for the respondent, and it is not in dispute that the survey number 31/2 totally measuring 2 acres 13 guntas. And survey number 29/4 is to the extent of 1 acre 31 guntas. The main contention of the appellant counsel that when the Yerrappa sold the property to Muniamma. Court has to take note of the boundaries. And he had retained the property, even though sold the property in survey number 31/2 to the extent of 2 acres 2 guntas. And survey number 31/2 with the possession of Yerrappa and not deliver the possession in favor of Srimati Muniamma. The council also would vehemently contend that when the appellant is in settled possession of the property and the same ought to have been taken note of by the trial court. The council also would vehemently contend that when the earlier appeal suit was filed in OS number 133 of 1976 and the same was dismissed. And exhibit P16 decree is very clear that the same was dismissed. And when searching the factual aspects of the case, when the finding is given in OS number 133 of 1976, as against the mother and no power to alienate the property, and the same has not been considered by the trial court. Having heard the submission of respective counsel and also the counsel appearing for the respondent, I have already pointed out that the property acquired by the BDA is only survey number 31/2 to the extent of 2 acres 13 guntas. And also the property originally belongs to Kuntayya and the same was sold in favor of Yellappa. He is not in dispute, and also Yellappa in turn sold the very extent of 2 acres 13 guntas in survey number 31/2 in favor of Yellappa by Kuntayya is not in dispute, and Kuntayya and Yellappa in turn sold the same in favor of Irappa is not in dispute. Only the dispute according to the appellant that when the Yerrappa sold the property to Muniamma, though it is mentioned survey number 31/2 to the extent of 2 acres 2 guntas, but not deliver the possession in respect of survey number 31/2. And the said submission cannot be accepted. Court has to look into the documentary evidence available on record. The very Muniamma who had sold the very same property to the extent of 2 acres 2 guntas in favor of Sanna Yellamma and Nagaraju, and in turn they have sold the same to the very same extent in favor of Srinivasa Iyengar and Basappa, who are the claimants before the trial court in terms of the sale deed dated 31/8/1994. The court has to look into the document available on record, and oral evidence cannot be considered, and documentary evidence has to be taken note of, and documentary evidence prevails over the oral evidence. The very contention that he has been in possession and based on the possession, compensation has to be decided, cannot be accepted. The court has to look into the documents and the property which has been acquired to the extent of 2 acres 13 guntas. Already title is in favor of Muniamma, and Muniamma in turn sold the property in favor of Sanna Yellamma, and Sanna Yellamma and her son Nagaraja had sold the property in favor of Srinivasa Iyengar and Basappa. And the said material has been taken note of by the trial court, and the very contention that possession ought to have been taken, and the very contention that boundaries has to be prevails and not the title, and the said contention cannot be accepted as contended by the council when the property was acquired, and court has to take note of the property which was acquired and also the title with regard to the said property is concerned, and the title documents are very clear with regard to the particularly the document of exhibit P6 under which Srinivasa Iyengar and Basappa have purchased the property on 31/8/1994 itself. And the very contention that the appellant is in possession of settled possession from the date of purchase 21/4/1974 cannot be accepted. The document of exhibit P14 with regard to purchasing of the property to the extent of 2 acres 2 guntas is in respect of survey number 31/2 and 29/4 to the extent of 2 acres 2 guntas. And when such being the case, the exclusive claim made by the appellant to the extent of 2 acres 2 guntas in survey number 31/2 cannot be accepted, and hence I do not find any error committed by the trial court while appreciating both oral and documentary evidence available on record. And when there is no any title to the extent of 2 acres, 2 kuntas, particularly in respect of survey number 31/2, which was acquired by the BDA, and the very claim of the appellant that trial court ought to have granted relief in favor of the plaintiff based on the settled possession cannot be accepted, and hence I do not find any error, and hence no merit in the appeal. In view of the discussions made up, I pass the following order. Appeal is dismissed. ಏನದ ಎಸ್ ಹೋಯ್ತು ಜೊತೆ ಹೋಯ್ತು ಅದ್ರ ಜೊತೆ ನಾಟ್ ಸರ್ವೈಸ್ ಫಾರ್ ಕನ್ಸಿಡರೇಷನ್ ನೋಡಿ ನೋಟ್ಸ್ ಅದ್ರಲ್ಲಿ ಇಟ್ಬಿಟ್ಟು ಎಸ್ ರಿಮೈನಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಅಟ್ 2:30.
Serial number 29.
Lord, serial number 34.
IO needs to be extended.
ಯಾವುದು
Serial number 29 ಅದರಲ್ಲಿ 3 ಇತ್ತು ಕನ್ಫ್ಯೂಷನ್.
ಏನಾಯ್ತು
135 ಆಗಿದೆ.
Lord, serial number
ಅಡ್ಜರ್ನ್ ಆಗಿದೆಯಾ
35/2024.
ಅದೇ ಅಡ್ಜರ್ನ್ ಆಯ್ತಲ್ಲ ಅದ ಅಯ್ಯೋ ಇದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿ.
Lord, serial number 34 my lord. Kindly have it next week further hearing ಅಂತ ಇದೆ. ಮಧ್ಯಾಹ್ನ ಮೇಲೆ ಸ್ವಲ್ಪ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಇದೆ ಅದಕ್ಕೆ.
13 part 3 part 2 ಮುಗಿಸ್ಬಿಡೋಣ ಹೇಳಿ.
ಅಲ್ಲ kindly my lord. Next week any date ನಾನು ಇವತ್ತು
ಯಾರು ಅದರ್ ಸೈಡ್ ಇದಾರಲ್ಲ
ಅದರ್ ಸೈಡ್ ಸ್ಟೇಟ್ ಇದೆ ಅಷ್ಟೇ.
ಇದು ಏನ್ ಮ್ಯಾಟರ್ ಹೇಳಿ.
ಅಲ್ಲ ಮ್ಯಾಟ್ರು 326 ಗೆ ಇದಾಗಿದೆ ಕನ್ವಿಕ್ಷನ್ ಆಗಿದೆ ಫ್ರಮ್ ದಿ ಬೋತ್ ಕೋರ್ಟ್ಸ್.
ಸರ್ಜನ್ ಲಾಸ್ಟ್ ಅಕೇಶನ್
ನಾನು ಹೇಳಿದೆ ಕೇಸ್ ಕೌಂಟರ್ ಕೇಸು ಐ ಹ್ಯಾವ್ ಟು ಪ್ರೊಡ್ಯೂಸ್ ಮೈ ಲಾರ್ಡ್ ಹಸ್ ಡೈರೆಕ್ಟೆಡ್ ಮೀ ಟು ಪ್ರೊಡ್ಯೂಸ್ ದಿ ಅದರ್ ಜಜ್ಮೆಂಟ್. It was heard and disposed of by another court. It was not so, my lord. It is from the same judge he has heard and he has disposed of the matter.
Same judge.
Same judge. But on merit, I'll do it, my lord, on next week. I have some inconvenience, my lord.
Petitioner counsel 6 time, counsel for the state present, list this matter on her parted or next week. Next week, 14, 15, please. 14/3.
Serial number 45 my lord. For the respondent. ಅದರಲ್ಲಿ PCR ಬಂದಿಲ್ಲ.
PCR ಬಂದಿಲ್ವಾ 2020 ಇನ್ನೂ ಬಂದಿಲ್ವಾ?
ಕೋರ್ಟ್ ಮಾತ್ರ ಇದೆ.
SCR kept below. ಯಾಕೆ ಇವ್ರು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕಳ್ಸಲ್ಲ ಇವರು? Issue reminder to the trial court to get the records. Serial number 45 madam, and list this matter on 21/3.
Serial number 41.
40 40 ಏನಾಗಬೇಕು?
Senior is unwell my lord.
ಅದರ್ ಸೈಡ್ ಇದಾರ
Statement.
ಸ್ಟೇಟ್ ಆದ್ರೇನು ಅವ್ರಿಗೇನು ಅವ್ರ ಲಾಯರ್ಗೇನು ಬೆಲೆ ಇಲ್ವಾ? ಮತ್ತೆ ಏನಾಗಿದೆ ಸೀನಿಯರ್ಗೆ? ಶಿವಶಂಕರ್ ಕೆ ಏನಾಗಿದೆ ರೀ? ಜ್ವರ ಅಡ್ಮಿಟ್ ಆಗೋರ? ಮತ್ತೆ ವೀಕೆಂಡ್ ಅಲ್ಲಿ ಜ್ವರ ಬರುತ್ತೆ ಎಲ್ಲ ಲಾಯರ್ಸ್ಗೂ. ಮತ್ತೆ petitioner counsel 6 time and HCGP is present. This matter on 21/3. ಮತ್ತೆ ಟೈಮ್ ಕೇಳ್ಕೊಡುದು. ಆರ್ಡರ್ ಶೀಟ್ ನೋಡಿಲ್ಲ ನಾನು. ಆರ್ಡರ್ ಶೀಟ್ ನೋಡಿದ್ರೆ ಡೇಟ್ ಕೊಡ್ತಾ ಇರ್ಲಿಲ್ಲ. 2017 ಮ್ಯಾಟರ್ ಇದು.
Serial number 36
36
That's I pay for the appellant.
Heard in part.
Yes, my lord.
ರಿಮೋಟಿಂಗ್ ಸೆಟಲ್ಮೆಂಟ್ ಏನಾಯ್ತು?
Settlement ಅಂತ ಹೇಳಿ.
Yes, my lord.
ಏನಾಯ್ತು ಸೆಟಲ್ಮೆಂಟ್?
ಅಲ್ಲಿ ಮೆಮೊ ಎಲ್ಲ ಇದ್ ಮಾಡಿ ಕಳಿಸಿದ್ವಿ ಸ್ವಾಮಿ.
ಕಳ್ಸಿರ್ಲಿ ನಮ್ಮ ಅಮ್ಮ ಕೊಟ್ರಲ್ಲ ಅದೇನಾಯ್ತು?
ಹೌದು ಅದರಲ್ಲಿ
Memo is ready, my lords. In the GPA, they have some defect. The identification has not done, it seems. Hence, they want time, it seems. But the respondent number 26 consent is also required.
ಇಲ್ಲ ಸ್ಟೇಟ್ ನನಗೆ.
It is going to
ಇಲ್ಲ.
Agate Swami, but direction may be given to the respondent number 26. Direction may be given to the respondent number 26 to be present in the next date of hearing because they
26
yes, my lord.
26 ಯಾರು?
ರಾಧಾನಂದನ್ ಸರ್. ರಾಧಾನಂದನ್.
ಕೌನ್ಸಿಲ್
Because they have filed an undertaking before this honorable court regarding 7 flats, my lords, that needs to be released for the settling the matter to amount to the appellants, my lords.
Sorry, both the counsels are present and submits that there is an element of settlement and presence of counsel appearing for the respondent number 26 is necessary, and hence counsel appearing for the respondent number 26. Mostly ಅವನಿಗೆ ನಾವು ಇದು ಕೊಟ್ಬಿಟ್ವೇನಾ ನೀವು ಗೋ ಹೆಡ್ ವಿತ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಅಂತ ಆ ಕೇಸ ಇದು ಸೆಟಲ್ಮೆಂಟ್ ಗೆ?
ಇದು ಫ್ಲಾಟ್ ರಿಲೀಸ್
ಇಲ್ಲಿ ಯಾರು 26 ಯಾರು ರಾಧಾನಂದನ್ ಅಂತ ಯಾರು ಇಲ್ವೇ ಇಲ್ಲಲ್ರಿ? Yes, Radhanandan for 26 ಇದಾರೆ.
Yes, my lords.
Be present and hence direct counsel for R26 is directed to be present in the next date of hearing.
To give a
Is
consent
this
to
matter
be released.
date ಯಾವಾಗ?
Next.
20ನೇ ತಾರೀಕು. 20ನೇ ತಾರೀಕು.
20 ಬೇಕಾ? 20 ಮಂಡೇ ಟ್ಯೂಸ್ಡೇ ಬರುತ್ತಾ ಮೇಡಮ್?
ನೆಕ್ಸ್ಟ್
ವೆನ್ಸ್ಡೇನಾ? ವೆನ್ಸ್ಡೇ ಯಾರು ಬೇಡ 19th. 19-3. MF ಅಲ್ವಾ ಇದು
35.
19-3. Huh?
35.
35.
Last occasion, your lordship directed me to secure the charge sheet pertaining to the accused.
35 ಹಾ
35.
ಶರಣ ಬಸಪ್ಪ ಅದೇನಾಯ್ತು ಹಾ
ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ ತಂದಿಲ್ಲ.
ಥರ್ಡ್ ಏನ್ ಪಾರ್ಟ್ ಏನಾಯ್ತು ಬಂದಿಲ್ವ ರೆಕಾರ್ಡ್ಸ್
ಬಂದಿಲ್ಲ records.
ಅವ್ರ ಹತ್ರ ಎಲ್ಲ ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೋತೀವಿ ಅಂದ್ರಲ್ಲ
ಅಲ್ಲ ಅವ್ರ ಹತ್ರ ಇದು ಅದೇನೋ ಚಾರ್ಜ್ ಶೀಟ್ ಸ್ಟ್ರಿಪ್ ಬೇಕಾಯ್ತು.
ಹಾ?
ಸ್ಟ್ರಿಪ್ ಬೇಕಾಯ್ತು ಎವಿಡೆನ್ಸ್
ಏನ್ ಬೇಕು
ಡಾಕ್ಯುಮೆಂಟ್ಸ್.
ಅವ್ರ ಹತ್ರ ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡ್ರಿ ಇರುತ್ತಲ್ಲ
ಇಲ್ಲ
ಅವ್ರ ಡಾಕ್ಯುಮೆಂಟ್ ಕೆಳಗಿನ ಕೋರ್ಟಲ್ಲಿ ಏನ್ ಮಾರ್ಕ್ ಆಗಿರುತ್ತೆ ಅದ್ ಕೊಡಿ ಅವರಿಗೆ. ಮಾರ್ಕ್ ಆಗದವ್ರ ರಿವಿಷನ್ ಅಲ್ಲಿ ನಾವ್ ಹೆಂಗ್ ಕನ್ಸಿಡರ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ?
ಮಾತ್ರ ಇದೆ ಮಾರ್ಕ್ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ ಯಾವ್ದು ಕನ್ಸಿಡರ್
ಮಾರ್ಕ್ ಆಗದಿಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ ನಾವು ರಿಲೇ ಮಾಡೋದಿಲ್ಲ. ಓನ್ಲಿ ಇವ್ರ ನೀಡ್ ಆಫ್ ದಿ ಡಿಪೋಸಿಷನ್ ಎಕ್ಸಿಬಿಟ್ಸ್ ಅದನ್ನ ಯಾವ್ದು ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಮಾತ್ರ.
ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ ತರ್ತಾರೆ.
ಅದು ಇಲ್ವಾ ನೋಡಿ HCGP 6 ಟೈಮ್ ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್. ಎಷ್ಟು ದಿವಸ ಬೇಕು? ಮಂಡೇನಾ? ಮಂಡೇ ಆಗಲ್ಲ, ಮಂಡೇ ಟ್ಯೂಸ್ಡೇ RSA ಡೇ. 20 ನೆಕ್ಸ್ಟ್ ವೀಕ್ 21st ಅಲ್ಲ ಯಾವಾಗ ಬರುತ್ತೆ? 15/3 ಅಷ್ಟೇ ಅಲ್ಲ? ನೀರು ಸ್ವಲ್ಪ ಇನ್ನು ಜಾಸ್ತಿ ಇಡ್ಬೇಕು. ಸುಮಾರು ಜಾಸ್ತಿ ಆಯ್ತಲ್ಲ, ನೀರು ಜಾಸ್ತಿ ಕುಡಿಸ್ತಾ ಇದೆ.
ಮೇಡಮ್ 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 ವಾಟ್ ಇಸ್ ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 46. ಯಾರು ಮೇಡಮ್? ಪಟಿಷನ್ ಮೇಡಮ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಹಿಂಗಾಗಿದ್ದು ನಾನು ಹೇಳಿದ್ದೆ ಏನಿಲ್ಲ ತಗೊಂಡು 21/3 3
Petition filed under section 439(2) of CRPC is allowed. The impugned order dated 36/23 passed in criminal miscellaneous number 5631 of 2023 set aside. And the Deputy Commissioner of Police of the concerned jurisdiction is directed to take respond number 2 to custody and subject him for trial. Respond number 2 is directed to pay cost of ₹1 lakh to the Karnataka State Legal Services Authority within a period of 2 weeks. If the cost is not paid within a period of 2 weeks, registry is directed to recover the same in accordance with law. The Director of Prosecution of the state shall instruct the public prosecutor of the state that they are duty bound to supply necessary information to the concerned court regarding pendency or decision of an earlier bail application, as well as the order passed under section 482 of CRPC to the concerned court before exercising the discretion, to avoid polluting the system, polluting the stream of justice by unscrupulous litigants. In view of the direction given by this court in the judgment reported in ILR 2022 Karnataka 3625 by issuing circular or memo, the Registrar General is directed to file a complaint by himself or authorizing a person to file complaint with the Vidhan Saudha Police Station against respond number 2 to investigate the matter with regard to the fraud played by respond number 2 on this court as well as on the trial court in getting the bail order, as well as order in WP number 13787 of 22 as observed in the order. The Registrar General is also directed to send a copy of this order to the concerned presiding officer and keep the order in his service record, since in spite of a reference was made in the bail application about cancellation of bail order, he did not look into the order passed by this court with regard to the cancellation of bail of respondent number 2 and proceeded to grant the bail without referring the same.
That's my next one. Arrest compliance order may be directed. Arrest matter compliance order.
Yan compliance ಮಾಡಿಲ್ವ ಡೈರೆಕ್ಷನ್ಸ್ ಕೊಟ್ಟಿಲ್ವಾ
Arrest
ಡೈರೆಕ್ಟರ್ ಆಫ್ ಟಿಸಿಪಿ ಡೈರೆಕ್ಟ್ ಮಾಡಿದೀನಲ್ರಿ ಇನ್ನೇನ್ ಆಗ್ಬೇಕು
compliance
ಇನ್ನೇನ್ ನನ್ ಮುಂದೆ ತಗೊಬಂದು ನಿಲ್ಸ್ಬೇಕಾ
compliance order.
there must be some limit.
I apply.
Wait for responding. The revision petition is not maintainable and accordingly it is dismissed with liberty to the revision petitioner to file appropriate petition.
Much obliged.
The appeal is allowed. The impugned order dated 8/10/21 in OS number 3944 of 2020 and the file of 27th additional city civil judge at Bangalore City is hereby set aside, and consequently the application filed under order 38 rule 5 of CPC is allowed and the relief as sought in the application is granted in favor of the plaintiffs.
Respondent.
Appeal is allowed. The impugned order passed on IA number 2 granting an order of temporary injunction in favor of the respondent plaintiff is set aside, and consequently IA number 2 is dismissed.
Much obliged.
Respondent. The appeal is dismissed.
Number 59 apply for the appellant.
The appeal is allowed in part. Both the parties are directed to maintain status quo till the disposal of the suit, since there is dispute with regard to identification of the property. In view of the dismissal of the main appeal, IAS, if any, do not survey for consideration and the same stand disposed of. Not decided on merits. The application filed by the appellant before the first appellate court filed under Order 26, Rule 9 and Section 10.A of CPC is allowed. The other two substantive question of law will be considered after getting the report from the commissioner, and hence the learned counsel for the appellant is directed to meet the commissioner fee. The registry is directed to send Exhibit D1 will and Exhibit D37 sale deed for opinion within 2 weeks. And 3 months time is granted to get the report, and registry is also directed to request the report within 3 months from the recognized expert. Since this is the appeal of 2008, and as soon as the report is secured, they list the matter for consideration of other two substantive questions of law. List this matter on 6/6/2024. Already compromise case. Why you both are hesitating?
My lords, in fact, there's an offer, my lords.
ಈಗಲೇ ಮಾಡಿ, ಇನ್ಸ್ಟೆಡ್ ಆಫ್ ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್ ಎಲ್ಲ ವೇಟ್ ಮಾಡೋ ಬದಲು.
2 times we have tried. They flatly refused. They flatly refused.
My clients are there. I ordered an inquiry.
Case of settlement.
In fact,
Flatly refused. 2-3 occasions. My parties came. Bassal bandu. Mengo bandu.
I have gone through the entire papers.
Please.
But instead of going for answering other two substantive question of law, I felt that it is correct anta. Because the signatures irodu thumb impression. Thumb impression court cannot compare. It requires handwriting expert. ಅದಕ್ಕೋಸ್ಕರ ಮಾಡಿದೀನಿ. Let the matter be go there. ಅದು ಇಲ್ಲ ಅಂದ್ರೆ ನೀವು ನೋಡಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೆ ಹೋಗಿ ಅಲ್ಲಿ ದುಡ್ಡು ಖರ್ಚು ಮಾಡ್ಕೊಂಡು ರಿಪೋರ್ಟ್ ತರಿಸೋ ಬದಲು ಇಬ್ರು ಮಾತನಾಡೋದಾರ ಒಂದ್ ಡೇಟ್ ಕೊಡ್ತೀನಿ, ಇಬ್ರು ಮಾತಾಡ್ತೀವಿ ಅಂತಂದ್ರೆ.
Now we are ever.
I am ready, my lords. If my learned friend wants.
It is a matter of the, and also the vast property is left by the deceased.
My lords, 2 property ಇಲ್ಲ ಬೇರೆಯವ್ರದ್ದು. ಶೆಡ್ಯೂಲ್ ನಲ್ಲಿ ಇರೋ ಪ್ರಾಪರ್ಟಿ ಇಲ್ಲ.
ಇಲ್ಲ ಬೇಡ, ಇರೋದ್ರಲ್ಲೇ ಮಾತನಾಡಿ.
ಇರೋದ್ರಲ್ಲೇನೆ.
ಮತ್ತೆ ಎಷ್ಟು ವರ್ಷ ಇಟ್ಕೋತೀರಿ?
2 ಪ್ರಾಪರ್ಟಿ ಸೇರ್ಸಿದ್ದಾರೆ.
ಎಷ್ಟು ವರ್ಷ ಇಟ್ಕೋತೀರಿ? 2008 ಇದು. ಇಬ್ರಿಗೂ ಅವ್ರ ಜೀವಿತ ಕಾಲದಲ್ಲಿ ಏನು ಸಿಗಲ್ಲ, ನೀವ್ ಹಿಂಗೆ ಮಾಡ್ತಾ ಇದ್ರೆ.
ನಂಬರ್ ಆಫ್ ಅಕೇಶನ್ಸ್ ಈವನ್ ದಿಸ್.
ಸರಿ, ಈಗ ಒಂದ್ ನಾನೇ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡ್ತೀನಿ, ಕರೆಸಿ ಮಾಡ್ತೀರಾ ಪಾರ್ಟಿನ?
ಆಗ್ಬೋದು ಸ್ವಾಮಿ. ಈವನ್ ದಿಸ್ ಆನರಬಲ್ ಸಜೆಸ್ಟೆಡ್ ಅರ್ಲಿಯರ್ ಅಕೇಶನ್.
ಡೇಟ್ ಬೇಡ, ಇದನ್ನ ಹಾಕಿದೀವಿ, ಅದನ್ನೇ ಒಂದ್ 2 ವಾರ ಲೇಟ್ ಮಾಡೋಣ, 1 ವಾರ ಕಳ್ಸೋದ್ನ. ಈ ಡಾಕ್ಯುಮೆಂಟ್ ಒರಿಜಿನಲ್ ಇಲ್ಲೇ ಇದೆಯಲ್ಲ?
ಇದೆ ಸ್ವಾಮಿ, ಎಲ್ಲ
ಎಕ್ಸಿಬಿಟ್ D1 ಅಂಡ್ ಎಕ್ಸಿಬಿಟ್
37 ಇದೆಯಾ? ಇದೆ. ಇಟ್ ಇಸ್
ಎರಡು ಇದ್ರೆ ಕಳಿಸ್ಬೇಕು. ಅದಕ್ಕೆ ರಿಜಿಸ್ಟ್ರಿಗೆ ಡೈರೆಕ್ಟ್ ಮಾಡಿಬಿಟ್ಟಿದ್ದೀನಿ. ರಿಜಿಸ್ಟ್ರಿ ಕಡೆಯಿಂದ ಹೋದ್ರೆ ರಿಪೋರ್ಟ್ ಬರುತ್ತೆ, ಇಲ್ಲ ಅಂದ್ರೆ ನಿಮಗೆ ಇವ್ರ ರಿಪೋರ್ಟ್ ಬರೋದಿಲ್ಲ, ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಎಕ್ಸ್ಪರ್ಟ್. ಅದಕ್ಕೋಸ್ಕರ ಐ ಮೇಡ್ ಇಟ್. ಐ ಆರ್ಡರ್ ಟು ಬೇರ್ ದಿ ಮನಿ. ಕಮಿಷನರ್ ಚಾರ್ಜ್ ನೀವೇ ಮೀಟ್ ಮಾಡ್ಬೇಕು.
ಐ ವಿಲ್ ಫರ್ನಿಶ್.
6/6 ಬದಲು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಕೊಡ್ತೀನಿ. ಯಾವತ್ ಕರ್ಸಿ ಮಾತನಾಡ್ತೀರಿ ಇಬ್ರು? ಏನ್ರಿ?
My lords, I am ready even today. My lords, clients are there.
ಮತ್ ಮಾತನಾಡಿ ಈಗ್ಲೇನೆ.
ಅವರು ಕ್ಲೈಂಟ್
ಈಗ್ಲೇ ಮಾತನಾಡಿ.
I am ready.
ನೀವು ನಿಮ್ ಕ್ಲೈಂಟ್ ಇದಾರಾ?
ಬಂದಿಲ್ಲ ಸ್ವಾಮಿ.
ಹೌದಾ?
ಮಾತಾಡ್ತೀನಿ ಸ್ವಾಮಿ, ಸಿಗ್ತಾ ಇರ್ತಾರೆ.
ಮಂಡ್ಯಕ್ಕೆ ಹಾಕಿರಲ್ಲ? ಮಂಡ್ಯಕ್ಕೆ ಹಾಕ್ತೀನಿ, ಕರ್ಸ್ ಮಾತನಾಡಿ. ಆಮೇಲೆ ಸೆಟ್ಲ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಈ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿ.
ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ we will furnish.
This matter on. ಏನ್ ಇಬ್ರು ಸ್ವಲ್ಪ ಹಂಚ್ಕೊಂಡ್ರೆ ಆಯ್ತು ಅಷ್ಟೇನೆ. ಅಪ್ಪ ಬಿಟ್ಟೋಗೋನ ಅವ್ರ ಅಪ್ಪ ಅಲ್ಲ ಅಂತೀರಿ, ಅವ್ರ ಮಗಳಲ್ಲ ಅಂತೀರಿ, ಇದೆ ಅಲ್ವಾ? ಆಕೆ ಮದ್ವೆ ಆಗಿ ಗಂಡನ ಮನೆಯಲ್ಲಿ ಇದ್ದಾಳೆ, ಆಸ್ತಿ ಈ ಕಡೆ ಇದೆ, ಪೊಸಿಷನ್ ಇವ್ರ ಹತ್ರ ಇದೆ, ಎಲ್ಲ ಏನೇನು ಇದೆ ನೋಡಿ. ಒಂದ್ ಕಾನ್ಸೆಪ್ಟ್ ಇಟ್ಕೋಬೇಕ್ರಿ, ಹೋಗೋ ದಿವಸ ಯಾರು ಒತ್ಕೊಂಡು ಹೋಗಲ್ಲ. ಇರೋದ್ರಲ್ಲಿ ಅಟ್ಲೀಸ್ಟ್ ಖುಷಿ ಪಟ್ಕೊಂಡು ಹೋಗ್ಬೇಕು.
Instructed and we have tried level best. From the other side, my lord,
ಏನ್ ಮಾಡ್ತೀರಿ, ನಮ್ ಜನ ಎಲ್ಲ ಹಂಗೇನೆ
flatly refused. Even for a single
ಬರುವಾಗ ಬೆತ್ಲೆ ಹೋಗುವಾಗ ಬೆತ್ಲೆ ಮರ್ತ್ಬಿಟ್ಟಾರ.
even for a single talk. ಮತ್ತೆ
ಕರ್ಸಿ ಮಾತನಾಡಿ. You both sit together and
ಸಿಗ್ತಾರೆ ಇಲ್ಲೇ
it of good office and settle it.
ಪ್ಲೀಸ್.
ಆಮೇಲೆ ಜೊತೆಗೆ ಜಾಸ್ತಿನೂ ಆಸ್ತಿ ಇದೆ, ಇಬ್ರು ಒಂದ್ ಸ್ವಲ್ಪ ಹೆಚ್ಚು ಕಡಿಮೆ ಹಂಚ್ಕೊಂಡ್ರೆ ಆಯ್ತಲ್ಲ. ಒಬ್ರು ಮಗಳು ಅಂತ ಆಗಿದೆ, ಇನ್ನೊಬ್ರು ಸಾಕೊಂಡ್ ವಿಲ್ ಮಾಡಿದೀನಿ ಅಂತ ಹೇಳ್ತಾರ ಅವ್ರು. ರಿಜಿಸ್ಟರ್ಡ್ ವಿಲ್ ಇದೆ, ವಿಲ್ ಲಾಂಗ್ ಬ್ಯಾಕ್ ರಿಜಿಸ್ಟರ್ ಆಗಿರೋದು 1975, ಸತ್ತಿರೋದು ಒಂದು 78. 3 ವರ್ಷ 88 ಲಾಂಗ್ ಬ್ಯಾಕ್ ರಿಜಿಸ್ಟರ್ಡ್. ಅವೆಲ್ಲ ಇದೆ, ಗಮನದಲ್ಲಿ ಇಟ್ಕೊಂಡು ಮಾಡಿ
ಪ್ಲೀಸ್. ಮಂಡೇ
subsequent 438 subsequent petition.
ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ಹೇಳಿದ್ರು. ಜಡ್ಜ್ಮೆಂಟ್ ಅದು ಹೇಳಿದ್ನಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್, ನೀವೇ ಹುಡ್ಕೊಳ್ಳಿ ಅಂತನಾ?
ಇಲ್ಲ, after filing charge sheet 438 is not maintained. After filing charge sheet, the 438 is not maintained.
After filing charge sheet ಅಲ್ಲ, ಒಂದ್ಸರಿ ನಾನು ಹೇಳ್ತಾ subsequent charge petition under section 438 is not maintainable ಅಂತ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ. ತೆಗಿ, ನಮ್ಮ ಹತ್ರ ಇದೆ, ಒಂದು ತಗ್ಸಕ್ಕೆ ಹೇಳ್ರಿ. ನೋಡಿ ಮೇಡಮ್, ನಾವು ಸುಮಾರು ಮಾಡಿದ್ವಿ ಕೆಲವೆಲ್ಲ.
ಆಗಿರ್ಲಿಲ್ಲ, ಸಿಗ್ಲಿಲ್ಲ ನನಗೆ.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ, ನಾನು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಬೇಸಿಸ್ ಮೇಲೆ ನಾವೊಂದು ಬರ್ದು 3-4 ಕೇಸ್ ಮಾಡಿದೀನಿ ನಾನು. ನಾಟ್ ಮೇಂಟೈನಬಲ್ 438
successive petition is not.
ಅದನ್ನ ಹಾಕೊಳ್ಳಿ, ನಮ್ಮಲ್ಲಿ ಇದನ್ನ ಮಾಡಿ ಗೊತ್ತಾಗ್ತದೆ. ತಗೊಳ್ಳಿ. This heard the petitioner counsel and also the counsel appearing for the petitioner. This is the successive bail petition filed under section 438 of CRPC. Earlier nodi madam, and this court earlier
page 34.
This court earlier dismissed the bail petition filed under section 438 of CRPC in criminal petition number 5744 of 22. And present petition is filed after filing of the charge sheet, when this court already formed an opinion that section 438 of CRPC cannot be invoked. And once again, this court cannot invoke the very proviso under section 438 in view of the judgment of the apex court. So and so. And also this court already considered set fact in other criminal petition number so and so. And hence the successive bail petition filed under section 438 of CRPC is not maintainable. Hence petition is dismissed.
Yes. Matter is settled between the parties. Filing a joint memo application.
Why it was deferred earlier?
So settlement part payment was made. So part payment was pending. Today entire amount.
ಏನ ಪೇಮೆಂಟ್ ಮಾಡ್ತಾರೆ ಅಂತ ಹೇಳಿದ್ರು.
ಅದೇ ಮಾಡಿದ್ವಿ, ಇವತ್ತೆಲ್ಲ ಆಗಿದೆ. ಅವ್ರು ಸೈನ್ ಮಾಡಿದ್ದಾರೆ application.
ಏನ್ ಮಾಡ್ಬೇಕು?
So it may be
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತಾ ಇದ್ದೀರಾ?
ಹೌದು,
ಕೊಡಿ.
by compounding the
ಎರಡರಲ್ಲೂ ಆಗಿದೆಯಾ?
ಎರಡರಲ್ಲೂ ಆಗಿದೆ.
ಎರಡರಲ್ಲೂ ಪೇಮೆಂಟ್ ಬಂದಿದ್ಯಾ? ಯಾರು ರಿಸೀವ್ ಮಾಡಿದ್ರು?
ಕಂಪ್ಲೇಂಟ್
ನಿಮ್ ಪಾರ್ಟಿ ಇದಾರಾ? ಪಾರ್ಟಿ ಸೈನ್ ಮಾಡಿದಾರಾ? ಇಲ್ಲಿ ಸಿಗ್ನೇಚರ್ ತಗೊಳ್ಳಿ.
ಲೋಯರ್ ಕೋರ್ಟ್ ಡೆಪಾಸಿಟ್
ಲೋಯರ್ ಕೋರ್ಟ್ ಡೆಪಾಸಿಟ್ ಅಲ್ದಲೆ ಈಗ ಎಷ್ಟು ರಿಸೀವ್ ಮಾಡಿದ್ರಿ ಹೇಳ್ಬೇಕಲ್ರಿ?
ಇವತ್ತು 25,000. ಸೊ ಅರ್ಲಿಯರ್ ಹಿ ಹ್ಯಾಸ್ ರಿಸೀವ್ಡ್ 1 lakh plus 1 lakh, ಟೋಟಲ್ 2 lakhs ತಗೊಂಡಿದ್ದಾರೆ ಈಗ. ಸೊ ಕೇಸ್
ಡೆಪಾಸಿಟ್ ಎಷ್ಟು ಮಾಡಿದ್ದಾರೆ?
1.5 ಡೆಪಾಸಿಟ್.
ಅಲ್ಲಿ ಟೋಟಲ್ ಎಷ್ಟು?
ಟೋಟಲ್ 2.5.
ಟೋಟಲ್ 2.5
6 ಲಕ್ಷ ಇಲ್ಲ.
ಕಂಪ್ಲೇನೆಂಟ್
ಟೋಟಲ್ 6 lakhs.
ಕಂಪ್ಲೇನೆಂಟ್ ಯಾರು? ನೀವಾ? ಈ ಫಸ್ಟ್ ಕೇಸಲ್ಲಿ ಎಷ್ಟು ಅವಾರ್ಡ್ ಆಗಿತ್ತು?
3 ಲಕ್ಷ ಚೆಕ್ ಅಮೌಂಟ್. ಫೈನ್ ಅಮೌಂಟ್ ವಾಸ್ 10,000.
ಫೈನ್ ಅಮೌಂಟ್ ಕಟ್ಟಿದ್ದೀರಾ?
ಇಲ್ಲ, ಕಟ್ಟಿಲ್ಲ.
ಮತ್ತೆ ಫೈನ್ ಅಮೌಂಟ್ ಕಟ್ತಲ್ಲ ಹೆಂಗ್ ನೀವೇ ರಜೆ ಮಾಡ್ಕೋತೀರಿ? ಕೋರ್ಟ್ನವ್ರು ಬಿಟ್ಟಿ ಕೆಲಸ ಮಾಡ್ಬೇಕು ಅಂತನಾ?
10,000 ಕಟ್ಟಿದ್ದೀರಾ? ಕೆಳಗಡೆ ಕುಣಿಗಲ್
ಕೋರ್ಟ್ ಅಲ್ಲ, ಕಟ್ಟಿಸ್ಕೊಂಡಿ
10,000 ಕಟ್ಟಿದ್ದಾರೆ. ಸೊ ಅದು ವೆರಿಫೈ ಮಾಡ್ಬೇಕು ಸ್ವಾಮಿ, ಅವ್ರಿಗೂ
ಈ 10,000 ಕಟ್ಟಿಲ್ಲ
ಅಲ್ಲ, ವೆರಿಫೈ ಮಾಡ್ಬೇಕು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
ಅವ್ರು ಕಟ್ಟಬೇಕು 10,000.
ಕಟ್ಟಿಸ್ತೀನಿ.
ನಮ್ಮ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಎಷ್ಟು ಪೇಮೆಂಟ್ ಮಾಡಿದಾರೆ? ಒಂದ್ 2 ಕೇಸಲ್ಲಿ 3 ಲಕ್ಷ 3 ಲಕ್ಷ. ನಿಮ್ಗೆ ಎಷ್ಟು ಬಂತ್ರಿ ದುಡ್ಡು ಈಗ?
ಈಗ ಕ್ಯಾಶ್ ಆಗಿ 3 ಲಕ್ಷ ಬಂದಿದೆ. 3 ಲಕ್ಷ ಬಂದಿದೆ
ಕ್ಯಾಶಾ?
ಕುಣಿಗಲ್ ಕೋರ್ಟ್ ನಲ್ಲಿ 1.5 ಲಕ್ಷ ಚೆಕ್ ಕೊಟ್ಟಿದ್ರು.
75 ಅಲ್ಲಿ 4.5 ಆಯ್ತು. ನಿಮ್ ಸೆಟಲ್ಮೆಂಟ್ 4.5ಗೆ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ?
ಇನ್ನೂ 1.5 ಅಲ್ಲಿದೆ ಕೊಡಬೇಕು ಕುಣಿಗಲ್ ಕೋರ್ಟ್.
ಕುಣಗಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನೀವ್ ಹೇಳ್ರಿ ಏನಂತ ಕುಣಗಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕುಣಗಲ್ ಕೋರ್ಟ್ ಬಿಟ್ಬಿಡಿ ನಿಮ್ಗೆ 6 ಲಕ್ಷ ರೂಪಾಯಿ ಇದೆ ಇಲ್ಲಿ ಸೆಟಲ್ಮೆಂಟ್ ಎಷ್ಟಕ್ಕಾಯ್ತು ಈಗ ಇಬ್ರಿಂದ
ಈಗ ಬಟ್ಟಿ 4.5 ಬಂದಿತ್ತು ಇನ್ನು 1.5
ಡೆಪಾಸಿಟ್
deposit amount
ಕೇಳ್ತೀರಿ ನೀವು ಲಾಯರ್ ರೀ ನೀವು
ಡೆಪಾಸಿಟ್ ಅಮೌಂಟ್ ಕುಣಗಲ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ಬರ್ಬೇಕು ಉಳಿದಿರೋದು ಬನ್ನಿ.
ಡೆಪಾಸಿಟ್ ಎಷ್ಟಿದೆ ರೀ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ
1.5 ಲಕ್ಷ
1.5 ಲಕ್ಷ ಡೆಪಾಸಿಟ್ ಇದೆ ಅದ್ ಅಲ್ದಲೆ ಈಗ ನೀವು 4.5 ಲಕ್ಷ ಬಂದಿದೀಯಾ ರಿಸೀವ್ಡ್ ಆಯ್ತು ಎರಡು ಕೇಸಲ್ಲಿ 10,000 ಹಾಕಿದಾರ ಫೈನ್
ಹೌದು
ಫೈನ್ ಅಮೌಂಟ್ ಕಟ್ಬೇಕು
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಪೇ ಮಾಡಿ.
ಕಟ್ತೀರಾ ಒಂದ್ ವಾರ ಟೈಮ್ ಕೊಡ್ತೀನಿ
ಸರಿ.
ಈಗ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ತೀನಿ ಸಬ್ಜೆಕ್ಟ್ ಟು ಪೇಮೆಂಟ್ ಆಫ್ ಫೈನ್ ಅಮೌಂಟ್ ಬಿಫೋರ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಇಲ್ಲ ಅಂದ್ರೆ ರಿವೈವ್ ಆಗುತ್ತೆ ಪಿಟಿಷನ್
2 weeks time maybe.
2 weeks ಆಯ್ತು 2 weeks ಕೊಡ್ತೀನಿ ಬಟ್ ಯು ಹ್ಯಾವ್ ಟು ಪೇ ದಿ ಅಮೌಂಟ್ ತಗೊಳ್ಳಿ
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕಟ್ಟಬೇಕಾಗಿರುತ್ತೆ.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲೇ ಕಟ್ಬೇಕು ನಮ್ಮಲ್ಲಿ ಕಟ್ಟೋದಲ್ಲ ಇದು
ಕೋರ್ಟ್ ಅಲ್ಲೇ ಕಟ್ಟಬೇಕು ಅದನ್ನೇ ಹೇಳ್ತಾ
ಹಾ,
ಇದ್ದೀನಿ.
ತಗೊಳ್ಳಿ. Criminal miscellaneous number 177. The revision petitioner counsel has filed an application under section 147 of Negotiable Instrument Act 1881. Bring this court to compound the offence by disposing the above petition. And petitioner has paid the entire amount and the respondent is fully satisfied with the same and has agreed to compound the offence. Both the counsel for the petitioners and also both the counsel for the petitioner and also the counsel for respondent and respondent counsel have signed this application. And on verification also the complainant says that he has already received an amount of rupees 4 lakh, already received the amount except the amount in deposit. And petitioner respondent may be permitted to withdraw the amount which is in deposit. And counsel and the petitioner also says no.
Will verify the records in a trial court and if it is not paid, I will pay.
ಯಾವುದು
ಅದು 10,000.
10 ಇಂದಲ್ಲ ನಾನು ಹೇಳ್ತಾ ಇರೋದು ದುಡ್ಡುದು ಬೇರೆ ದುಡ್ಡು ಕೊಟ್ಟಿದಾರಲ್ಲ ಡೆಪಾಸಿಟ್ ಮಾಡೋದು. And no objection to release the amount in favor of the respondent. It is noticed by this court that when the trial court passed the judgment imposed fine of rupees 10,000 payable to the state. And the counsel submits that if a fine amount is not deposited before the trial court and the petitioner is going to deposit the amount within 2 weeks.
I will verify the records.
Verify ಮಾಡಿ ಕಟ್ಟಿದ್ರೆ ಕಟ್ಟೋದ್ ಬೇಡ within 2 weeks if amount not paid. And produce the receipt before this court for having deposited the amount of fine within 2 weeks. Having considered the application filed under section 147, the revision petition is allowed in view of payment of fine amount and compounded the case and in view of compounding of the offence, the petitioner need not undergo SI for 3 months as ordered. ಅಂತ ಮಾಡಿ ಅದೇ ಆರ್ಡರ್ ಇನ್ನೊಂದ್ರಲ್ಲೂ ಬೇರೆದ್ರಲ್ಲೂ ಎರಡರಲ್ಲೂ ಸಿಗ್ನೇಚರ್ ತಗೊಳ್ಳಿ. Directed to take the signature of the petitioner ತಗೊಳ್ಳಿ ಯಾಕೆಂದ್ರೆ ಅವ್ರು ಕೊಟ್ಬೇಕಾಗಿರೋ ದುಡ್ಡು. Next. Yes, counsel.
Please. Lord. Concurrent.
ಏನು ಅಫೆನ್ಸ್ ಏನು
138.
138.
Please.
ಏನ್ ನಿಮ್ ಡಿಫೆನ್ಸ್ ಏನು?
Defense, my lord. There was no liability and evidence led by the prosecution itself shows that the liability is not there. And liability as projected by the prosecution is false. Number 1, my lord. Number 2, checks were repeatedly presented just for the purpose of the case, knowing fully well that the account was closed.
Evidence ಕೊಡಿ, DW1 evidence ಕೊಡಿ.
Please. In the, about the liability.
What is your defense counsel?
That's the defense, that was no liability and the.
No liability ಅಂತ.
ಹೌದು.
Trial court case paragraph number 14 ಅಲ್ಲಿ.
Of the judgment.
His cross-examination, DW1 admitted the exhibit P1 to P4.
Please.
Checks pertaining to his account. He admitted his signatures on exhibit P1 to P4.
Please.
He could not depose who has written the contents in check. He gave version as complainant has done many transactions in their shop. Arakanat shop is in the name of his brother. His brother has an account in bank. He does not know whether his brother has checkbook or not. He deposed that. ಅಡಿಕೆ ಅಂಗಡಿ ವ್ಯವಹಾರವನ್ನು ನನ್ನ ಅಣ್ಣನೇ ನೋಡುತ್ತಾರೆ. ಸದರಿ ವ್ಯವಹಾರದಲ್ಲಿ ನಾನು ಭಾಗವಹಿಸುವುದಿಲ್ಲ. ಸದರಿ ಅಂಗಡಿಯಲ್ಲಿ ದುಡ್ಡು ಕೊಡುವ ವ್ಯವಹಾರವನ್ನು ನನ್ನ ಅಣ್ಣನೇ ನೋಡುತ್ತಿದ್ದರು. ನಾನು ಅಣ್ಣನಿಗೆ ನಿಶಾನೆ P1 ರಿಂದ 4 ಚೆಕ್ ಅನ್ನು ಹೊರತುಪಡಿಸಿ 25 ಚೆಕ್ ಹಾಳೆಗಳು ಇರುವ ಪುಸ್ತಕವನ್ನು ನೀಡಿದ್ದು ಅದರಲ್ಲಿ 15 ಹಾಳೆಗೆ ಸಹಿ ಮಾಡಿ ನೀಡಿದ್ದೆನು. ಸದರಿ ನನ್ನ ಅಣ್ಣನಿಗೆ ನೀಡಿದ 15 ಚೆಕ್ಕುಗಳನ್ನು ನಮ್ಮ ಅಣ್ಣ ಯಾರ್ಯಾರಿಗೆ ನೀಡಿರುತ್ತಾರೆ ಎಂದು ಗೊತ್ತಿರುವುದಿಲ್ಲ. ನಾನು ಸಹಿ ಮಾಡಿದ್ದ ಚೆಕ್ಗಳನ್ನು ನಮ್ಮ ಅಣ್ಣನಿಗೆ ಯಾವಾಗ ನೀಡಿದ್ದೇನೆಂದು ಈಗ ನೆನಪಿಲ್ಲ. ಸಾಕ್ಷಿಯು ಮುಂದುವರಿದು ಅಂದಾಜು 2006 ನೀಡಿರಬಹುದು ಎಂದು ನುಡಿಯುತ್ತಾರೆ. He further deposed that complainant demanded him to pay the amount, but he has not repaid the same. It is because that transaction is in between his brother and complainant. He further deposed he was not present while his brother made payment to the complainant. He admitted that he received the notice which is issued by complainant. He has not replied to the notice. He has not inquired the complainant.
Please.
He admitted his signature on exhibit P13, that is on demand promissory note. He admitted his address which is mentioned in exhibit P13, but he doesn't know the contents in exhibit P13. In order to support the defense of accused Gopala Krishna Pujari, who is the brother of accused, gave evidence before the court. He is examined as DW2. He deposed that as he had not money during the alleged transaction, as such he issued the checks which belongs to his brother. He made repayment of the amount, but the complainant has not returned the checks. And complainant submitted that he would return the checks to his brother accused. In his cross-examination, he opposed that they have mentioned date and amount on checks. His brother was not present on the date of issuing and the checks of complainant. He further deposed that he has given the amount of amount on 7/5/2007. And they have not asked a complainant to return the checks.
Please.
On perusal of the entire evidence of DW1 and D2, they were contrary to each other. On behalf of the accused, so Gopala Krishna is the manager of State Bank of like next.
Please. May I submit? My lord, kindly see the evidence of PW1.
PW1.
Out. Para 2.
Put it, madam.
Para 2, please. ಅಡಿಕೆ ಆರೋಪಿ ಅಡಿಕೆ ವ್ಯಾಪಾರಕ್ಕಾಗಿ
ಕ್ರಾಸ ಚೀಫ್ ಚೀಫ್ ಅಲ್ಲೇ
ಹೌದು
ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ
ಹೌದು ಆರೋಪಿ ಅಡಿಕೆ ವ್ಯಾಪಾರಕ್ಕಾಗಿ 2007ನೇ ಇಸ್ವಿ ಜನವರಿ ತಿಂಗಳಲ್ಲಿ ನನ್ನಿಂದ ಪಡೆದುಕೊಂಡಿದ್ದ ಕೈ ಸಾಲದ ಮರುಪಾವತಿ ಮತ್ತು ನನಗೆ ಕೊಡಬೇಕಾದ ಹಣದ ಮೊತ್ತವಾದ ರೂಪಾಯಿ 1,65,000 ಮರುಪಾವತಿ ಸಲುವಾಗಿ 7/5ಕ್ಕೆ ಚೆಕ್ ಕೊಟ್ಟ. ಸೊ ಜನವರಿ 2007 ಕೈ ಸಾಲ ಚೆಕ್ ಈ 7/5 ಅದರ ರೀಪೇಮೆಂಟ್ಗೆ 1,65,000 ಫಾರ್ ಚೆಕ್ಸ್ ಆರ್ 4 ಚೆಕ್ಗಳು ಡ್ಯಾಶ್ ಡ್ಯಾಶ್ ಅಂತ ಕೊಟ್ಟ. ನೆಕ್ಸ್ಟ್ ಮೈ ಲಾರ್ಡ್ಸ್, ದಿಸ್ ಈಸ್ ಹಿಸ್ ಕೇಸ್. ದೆನ್ ಅಟ್ ದಿಸ್ ಮೊಮೆಂಟ್ ಓನ್ಲಿ ಸೇಮ್ ಪೇಜ್ ಲಾಸ್ಟ್ ಆದ್ರೆ ನಗದೀಕರಣಕ್ಕೆ ಸಲ್ಲಿಸಿದನು. ಆರೋಪಿಯ ಬ್ಯಾಂಕಿನವರು 3/7/2007 ಕೊಡ ಮಾಡಿದ ಆರೋಪಿಯ ಖಾತೆಯನ್ನು ಮುಚ್ಚಲಾಗಿದ್ದ ಶೀರ್ಷಿಕೆಯೊಂದಿಗೆ 4/7 ತಿಳಿದು ಬಂತು. ಅಕೌಂಟ್ ಕ್ಲೋಸ್ಡ್. ದಿಸ್ ಈಸ್ ಇಸ್ ಎಕ್ಸಾಮ್ and PW2. Now the checks are dated 7/5/2007. Loan is January, check is 7/5/2007. Exhibit P1 to P4. Now kindly see, my lord, their own case. This is the definite case, my lord, projected before the honorable court. Now the demand promissory note, my lords. Kindly see P13. Kindly pardon me, my lord, I had made a note of the court file, my lords. I don't have the file P13, but I have the date, my lord. P13 demand promissory note. Zeras unta? Please, thank you. I have from my learned friend, my lord. Kindly see 13, which is the marked through the PW1 P13, my lords. ರೂಪಾಯಿ 1,65,000 ಮೇಲ್ಗಡೆ.
One second.
Promissory note, sorry.
P series ಎಲ್ಲಿದೆ ಮೇಡಮ್? ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ? ಇದೆಲ್ಲ D series.
PW2 ಉಂಟಾ? PW2?
ಕಳಿಸ್ಕೊಡ್ತಾರ ಮಾಡೋದೇ ಫಸ್ಟ್ ಎಕ್ಸಿಬಿಟ್ P series.
Please, my lord. So exhibit P13 is 1,65,000. I beg to read this, my lord.
13,
26/2/2006. Now the complainant's case is January 2007. This is 26/2/2006. ಬೆಳ್ತಂಗಡಿ ತಾಲೂಕು ಸ್ವಯಂ ಗ್ರಾಮದ ಪ್ರಭುಗಳ ಮಗ 55 ವರ್ಷ ಸದಾಶಿವ ಪ್ರಭುಗಳಿಗೆ ಇವರ ಅಧಿಕಾರ ಹೊಂದಿ ಡಿಮಾಂಡ್ ಪ್ರಾಮಿಸ್ ತರುವವರಿಗೆ ಸದ್ರಿ ತಾಲೂಕು ಸ್ವಯಂ ಶಿವಪ್ಪ ಪೂಜಾರಿಯ ಮಗ 30 ವರ್ಷ ದಿನೇಶ್ ಆದ ನಾನು ರೂಪಾಯಿ 1,65,000ಕ್ಕೆ 15% ಬಡ್ಡಿ ಸೇರಿಸಿ ನಮ್ಮಿಂದ ಅಧಿಕಾರದ ಕೇಳಿ ವಸೂಲು ಕೊಟ್ಟಿದೆ ಅಂತ ಈ ಮೂಲಕ ವಾಗ್ದಾನ ಮಾಡಿರುತ್ತೇನೆ. ಇದರ ಪ್ರತಿಫಲ ರೂಪಾಯಿ 1,60,000 ನೀವು ಈ ದಿನ ನಗದಿಯಿಂದ ಕೊಟ್ಟಿದ್ದು on the same day. So that is on everything on 26/2. Kindly see two witnesses, Lokesh Acharya and Ramdas Prabhu. Now complainant's case is entirely different, 2007. Now my lord Ramdas Prabhu is examined as PW2. So PW1 does not support this about this case. However, his evidence is different. PW1's evidence is January 2007 transaction. Now PW2, my lord, who is the signatory to this document. PW2, my lord, Ramdas Prabhu. ಅದರೊಳಗೆ ಪ್ಯಾರಾ 2. Now kindly see his case, my lord. ಜನವರಿ 2007ನೇ ಇಸ್ವಿಯ ಪ್ರಾರಂಭದ ಒಂದು ದಿನ, ಜನವರಿ 2007 ಪ್ರಾರಂಭದಲ್ಲಿ ಎಕ್ಸಾಮಿನೇಷನ್ ಚೀಫ್ ಅಲ್ಲಿ ಫಿರ್ಯಾದರನ್ನು ಭೇಟಿಯಾಗಿ ನಾನು ಮರುದಿವಸ ಆರೋಪಿಗೆ ಆತನ ಕೇಳಿಕೆಯಿಂದ ಸ್ವಲ್ಪ ಹಣ ಸಾಲವಾಗಿರಲಿದ್ದು ಆ ಸಂದರ್ಭದಲ್ಲಿ ಹಾಜರಿರುವಂತೆ ಕೇಳಿಕೊಂಡರು. ಅದರಂತೆ ನಾನು ಅವರ ಮನೆಗೆ ಬೆಳಿಗ್ಗೆ 10 ಗಂಟೆಗೆ ಫಿರ್ಯಾದರ ಮನೆಗೆ ಹೋದೆ. ಆ ಸಂದರ್ಭದಲ್ಲಿ ಆರೋಪಿಯಲ್ಲಿ ಹಾಜರಿದ್ದರು. ಹೋದ ಸ್ವಲ್ಪ ಸಮಯದಲ್ಲಿ ಫಿರ್ಯಾದರು ಒಂದು ಹಣದ ಕಟ್ಟು ತಗೊಂಡ್ಬಂದ್ರು, 1 ಲಕ್ಷ ಇದೆ ಅಂತ ಹೇಳಿದರು. ಆರೋಪಿ ನೀಡಿದರು. ಮೊತ್ತ ಎಣಿಸಿ ನೋಡಿ ಸರಿ ಇದೆ ಅಂತ ಹೇಳಿದರು. ಸ್ವಲ್ಪ ಹಣವನ್ನು 8 ದಿನಗಳ ನಂತರ ಹೇಳಿ ಆ ಸಂದರ್ಭ ಇರುವಂತೆ ಹೇಳಿದರು. ಅವರು ಹೇಳಿದ ಹಾಗೆ ನಾನು ಮತ್ತೊಮ್ಮೆ ಹೋದೆ, ಆಗ ಪುನಃ 65,000 ಕೊಟ್ಟರು. ನಾವು ದಿಸ್ 1 lakh on one day, my lord. 8 ದಿವಸಗಳ ನಂತರ ಪುನಃ 65,000. ಸೊ ದಿಸ್ ಇಸ್ ಒನ್ ಈಸ್ ಫಸ್ಟ್ ವೀಕ್ ಆಫ್ ಜನವರಿ, ಮತ್ತೆ 8 ದಿವಸಗಳ ನಂತರ ಹಣವನ್ನು ಮರುಪಾವತಿಸಲುವಾಗಿ 4 ಚೆಕ್ ನೀಡುತ್ತಿದ್ದು. ಸೊ ಆಗ ಹಣ ಕೊಟ್ಟ ಚೆಕ್ ಅದರ ಇವ್ರ ಕೇಸ್ ಪ್ರಕಾರ. ನಮ್ಮ ಲಾರ್ಡ್ the very same witness Ramdas Prabhu, he doesn't say anything about this DP note here, though he's examined after PW1, my lord. Doesn't say anything. Now PW2 is a witness to this exhibit P13, and one and you appears to be that they have to submit, my lord, but appears to be brother Ramdas Prabhu. Complainant is Sadashiva Prabhu. He doesn't say anything about this document. So he has this transaction, according to him, is 1 lakh plus 65,000. Transaction as per exhibit P13 is on the same day, 26/2/2006. This is apparently one discredits the other and one is destructive of the other. So therefore, the entire theory that this check is obtained, etc., my lord, and his case about the issuance of check is also entirely different. Adivasave kotru ant heli. But one's case is different. Now, my lord, the consideration presumption is applicable initially, my lord. Once the evidence is contradictory and discredits one another, my lord, that presumption gets displaced and the prosecution case stands disproved as per this is patently a lie.
Exhibit P13 ಯಾರ ಮೂಲಕ ಮಾರ್ಕ್ ಆಗಿದ್ದು?
PW1 I respectfully submit.
ಇಲ್ವಲ್ಲ? PW12 ನನ್ನ ಸೀಗಳು ನೋಡ್ತಿದ್ದು ನನ್ನೆರಡು ಏನು ಮಾಡಿಲ್ಲ ಅದರ ಕಾರಣದಿಂದ ನಾನು ಫಿರ್ಯಾದಿನಲ್ಲಿ ಕೋರುವ ಕ್ರಮ ಜರುಗಿಸುವಂತೆ ಕೋರುತ್ತೇನೆ. 1 to 12 ಮಾರ್ಕ್ ಥ್ರೂ PW1 ಏನ್ ಕನ್ಫ್ರಂಟ್ ಮಾಡಿದಾರ ಏನು? ಯಾಕೆಂದ್ರೆ ಇಬ್ರು ವಿಟ್ನೆಸಸ್ ಅಲ್ಲೂ ಏನು ನೋ ಕ್ವಶನ್ಸ್ ಆರ್ ಪುಟ್ ಟು ದಿ ವಿಟ್ನೆಸ್
please
ಅಬೌಟ್ PW13.
They have confronted it to the accused.
DW1 ಮಾಡಿದಾರಾ?
The one ಮಾಡಿಬಿಟ್ಟು that case. I feel I get to submit the cross examination.
ಯಾಕೆಂದ್ರೆ ಚೀಫ್ ಅಲ್ಲಿ ಏನಿಲ್ಲ.
Lords, one in the appellate court judgment, my lord, it is clearly said that even the accused, my lords, has not spoken anything about the exhibit P13.
DW1, page number 3, please, my lord.
ಕ್ರಾಸ್ ಮಾಡಿರ್ಬೇಕು.
ಕ್ರಾಸ್ ಮಾಡಿಬಿಟ್ಟು ಪ್ರೊಜೆಕ್ಟ್ ಎ ಕೇಸ್.
ಕ್ರಾಸ್ ಮಾಡೋ ಕನ್ಫ್ರಂಟ್
ಮಾಡಿ ಪೇಜ್ ನಂಬರ್ 3, my lord.
DW4 ಎಷ್ಟು 4 ಜನ ಇದ್ದಾರೆ?
ಅದು ಬ್ಯಾಂಕ್ ಮತ್ತೆ ನಾವು ಬ್ಯಾಂಕ್ ಆಫೀಸರ್ ಮಾಡಿ.
ಆಯ್ತು. ಈಗ ಯಾರಿಗೆ ಕನ್ಫ್ರಂಟ್ ಮಾಡಿದ್ರು?
DW1 ಗೆ ಕನ್ಫ್ರಂಟ್ ಮಾಡಿಬಿಟ್ಟು ನಾವು kindly see
DW1 ಗೆ
that becomes important because after both are examined, now prosecution comes out with the case, my lord. Line number 6. ಈಗ ತೋರಿಸಿದ ದಾಖಲೆಯನ್ನು ಸಹಿ ನನ್ನದಾಗಿತ್ತು. ಸದರಿ ದಾಖಲೆಯನ್ನು P13 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಸಹಿಯನ್ನು P13A ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ದಾಖಲೆ ಬರ ಸಹಿ ನನ್ನದಾಗಿತ್ತು. ಅದರಲ್ಲಿ ಬರೆದಿರುವ ವಿಚಾರಗಳು ಗೊತ್ತಿರುವುದಿಲ್ಲ. ಕುಂಜರಕಟ್ಟೆ ಲೋಕೇಶ್ ಆಚಾರ್ಯ ಮತ್ತು ರಾಮದಾಸ್ ಆಚಾರ್ಯ ಪರಿಚಯ ಇರುತ್ತದೆ. 26/2/2006 ನಾನು ಫಿರ್ಯಾದಿದಾರರಿಂದ 1,65,000 ಸಾಲ ಪಡೆದು ಅದರ ಬಗ್ಗೆ P13 ಬರೆದು ಕೊಟ್ಟು ಸರಿಯಲ್ಲ. ಸದ್ರಿ ಹಣವನ್ನು ಫಿರ್ಯಾದಿದಾರ ಕೇಳಿದಾಗ ಮರುಪಾವತಿ ಮಾಡದಿದ್ದಾಗ 4 ಚೆಕ್ ನೀಡಿರುತ್ತೇನೆ ಸರಿಯಲ್ಲ. So this is the case now, prosecution case. So initial complaints case, what is spoken to through PW1 and PW2 is given a go by. Now this version is projected. Now this becomes the complaints or prosecution case, my lords. So prosecution has no definite case at all. Now this is the case, which is not spoken to by PW2, but now this is their case and they produce a document also. So therefore, my lord, the case itself, on the very face of it, is unbelievable. This important aspect has not been considered by both the material aspect, has not been considered, my lords. So prosecution case is false on the face of it. This is my one submission, my lord. So first of all, prosecution case must be clear and believable version, my lord. Not that just because there is a rebuttable presumption, my lord, a false case can be accepted. No, false cases cannot be accepted, my lord. Therefore, there is illegality committed by both the courts below. Of course, the defense, my one more aspect is, your lord may kindly see. What is the defense? For that purpose, I pray my lord to kindly permit me to refer to the evidence of PW1 who was recalled. Kindly see PW1's evidence after recall, my lord. That's at page number, last page. Recalled on 21/10/2013. Partition. ನನಗೆ ಆರೋಪಿತ ಚೆಕ್ಗಳನ್ನು ಮಡತ್ಯಾರ ಸೊಸೈಟಿ ಬ್ಯಾಂಕ್ ನಗದೀಕರಣಕ್ಕೆ ಸಲ್ಲಿಸಿರುತ್ತೇನೆ. ಸದ್ರಿ 4 ಚೆಕ್ಗಳನ್ನು ಬ್ಯಾಂಕ್ ನಗದೀಕರಣಕ್ಕಾಗಿ 2 ಬಾರಿ ಸಲ್ಲಿಸಿದ್ದೇನೆ. ನಾನು ಮೊದಲನೇ ಬಾರಿ ನಗದೀಕರಣಕ್ಕಾಗಿ ಚೆಕ್ ಅನ್ನು ಬ್ಯಾಂಕ್ಗೆ ಸಲ್ಲಿಸಿದಾಗ ಆರೋಪಿಯ ಖಾತೆ ಮುಕ್ತಾಯಗೊಂಡಿರುತ್ತದೆ ಎಂಬ ಹಿಂಬರದಿಂದ ವಾಪಸ್ ಬಂದಿರುತ್ತದೆ. ಮೊದಲನೇ ಬಾರಿ ಚೆಕ್ ನಗದೀಕರಣ ಸಲ್ಲಿಸಿದ ತಿಂಗಳು ಮತ್ತು ನೆನಪಿರುವುದಿಲ್ಲ. ನಾನು ಮೊದಲನೇ ಬಾರಿ 4 ಚೆಕ್ಗಳನ್ನು 10/5/2007 ಸಲ್ಲಿಸಿದ್ದೇನೆ ಅಂದ್ರೆ ಸರಿ. 10/5. ಎರಡನೇ ಬಾರಿ ಚೆಕ್ಗಳನ್ನು ನಗದೀಕರಣಕ್ಕೆ ಹಾಕಿದಾಗ ಸಲ್ಲಿಸುತ್ತೇನೆ ನೆನಪಿರುವುದಿಲ್ಲ. P1 ಮತ್ತು 2 ಮೇಲೆ 3/7/2007 ದಿನಾಂಕದ ಸೀಲ್ ಇದೆ. 3/7. Now, my lord, as per the complaint case itself, check is 7/5/2007. In the complaint, what is mentioned is checks were returned on 3/7, para 3 of the complaint. There is no reference to the first presentation. What is mentioned in para 3 is checks were dishonored wide memo dated 3/7/2007. Now that is the averment. Now I pray the honorable court to kindly peruse the check return memos. P5. 6/7.
7/5/2007.
ಹೌದು. ಅದ್ರೊಳಗೆ 3/7/2007. Now kindly see the text. Kindly see first check, my lord. P1 ಅದ್ರೊಳಗೆ ಮೇಲ್ಗಡೆ P1 P2 ಎರಡು ಸೇಮ್ ಇದೆ. Kindly see the date 7/5 P1 ಅಂತ ಇದೆ, ಅದ್ರ ಕೆಳಗಡೆ ಅಮೌಂಟ್ ಇದೆ. ಲೆಫ್ಟ್ ಸೈಡ್ kindly see the dates. There are two dates. ಒಂದು ಸೀಲು 10/5/2007 which witness admits. ಇನ್ನೊಂದು 3rd July 2007. In all the cases it is so. They denied it. Therefore the bank officer was also summoned, my lord. And bank officer DW4. Even without the bank officer, my lord, it clearly shows the bank check was presented and PW1 has also admitted, my lord. Check is presented once in May and second is July. DW4 also says the same thing.
Yes.
And my lord, the exhibit D2. This is also important, my lord. Kindly see, my lord, how the exhibit D2 account closed during 2004-2005. As there was zero balance. Account was closed automatically while migrating to core banking system. Automatically. Banking system in 2006. My lord, this was summoned after an application is filed, my lord, on 311 CRPC, page 86 of the case, records of the court below, my lord. Application is filed on 31/2012. Para 2 of the application, my lord, that there is automatic closure of the account. And para 3 is complainant knew about the account closure and he has filed a false complaint, etc. Based on this, witness has been summoned. DW4 was examined on 27/6/2014, my lord. Now, my lord, I do concede in the usual course. In the usual course, my lord, checks can be presented many number of times. But, my lord, kindly take judicial notice of this, my lord. A check is, my lord, returned on the ground, account closed. Need of or requirement of presenting it again or getting the result again after presentation is zero because account is already closed. Therefore, this honorable court has laid down, my lord, the only coordinate benches decision, my lord, so I may, with permission, my lord, pass on to the honorable. Ideya. Only para 4, please, my lords. Dishonor of a check on the ground of account closed may be technically within the meaning of legal phrase of insufficient funds. But in a fact situation, both are not always identical. In the case of literal situation of insufficiency of funds in the account, successive presentation may serve purpose. The drawer could be given opportunity to make good the funds in the account for honoring the check on the second presentation. In the case of account closed, the question of successive presentation makes no sense because the account itself is not in existence, as there is no possibility of having a fruitful result by successive presentation, unlike in the case of insufficient funds. Therefore, whenever the check is dishonored on the account closed, payee cannot resort to successive presentation to save the limitation. So also in the case of the check on the ground of signature so and so. Now, my lord, here is a case. He goes on presenting again by suppressing the earlier, my lord, that to see that there is a limitation, my lord. As the law stood, then, my lord, notice should have been issued, my lord, immediately within the 15 or 30 days, my lord. Now, again, after 2 days, just to save the limitation, once more it's presented, that is suppressed. And he denies it, then he had to summon the witnesses. My lord, case as far as the defense is concerned, my lord, it's the brother who has issued the check, my lord, as a security. Brother has been examined. I also say brother which has issued the check, my lord. And he also says, PW1 in the entire evidence, he says, my lord, the transaction is with the brother. Loan liability is also with the brother. This only added points to disprove the prosecution case, my lord. May I beg to take my lord to PW1 cross-examination. PW1 itself, my lord. PW1, page number. Cross-examination starting portion was 17/11/2009. Line number 4 of the cross, ಕೆಳಗಡೆ ಬಾಟಮ್ ಅಲ್ಲಿ. ನನಗೆ ಕೃಷಿ ಜಮೀನು ಇರ್ತದೆ ಎಕ್ಸೆಟ್ರಾ. ಆದ್ಮೇಲೆ 3ನೇ ಲೈನ್, ನಾನು ಅಡಿಕೆ ವ್ಯಾಪಾರ ಮಾಡುತ್ತೇನೆ ಎಕ್ಸೆಟ್ರಾ. ನಾನು ಅಡಿಕೆ ವ್ಯವಹಾರವನ್ನು ಆರೋಪಿ ಅಣ್ಣನಾದ ಗೋಪಾಲ ಎಂಬಲ್ಲಿ ಮಾಡುತ್ತೇನೆ. ನೆಕ್ಸ್ಟ್, ಮೈ ಲಾರ್ಡ್, ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಕೈಂಡ್ಲಿ ಸಿ, ಮೈ ಲಾರ್ಡ್, ಮಿಡ್ಲ್ ಪೋರ್ಷನ್. ಮೇಲ್ಗಡೆಯಿಂದ 10 ಲೈನ್ ಆದ್ಮೇಲೆ ಆರೋಪಿ ನಮ್ಮ ಮನೆಗೆ ಬಂದು ಅಣ್ಣನಿಗೆ ಹಣ ಬೇಕು ಅಂತ ಕೇಳಿದ್ದನು. ನಾನು ಆರೋಪಿ ಅಣ್ಣನಾದ ಗೋಪಾಲನಿಗೆ ವ್ಯವಹಾರಕ್ಕಾಗಿ ದುಡ್ಡನ್ನು ಕೊಟ್ಟಿರುತ್ತೇನೆ. ದಿಸ್ ಇಸ್ ದಿ ಹಿಸ್ ಓನ್ ಎವಿಡೆನ್ಸ್. ಅಣ್ಣನಿಗೆ ದುಡ್ಡು ಕೊಟ್ಟಿರುತ್ತೇನೆ. ಅದಾದ್ಮೇಲೆ ಪುನಃ 3-4 ಲೈನ್ ಆದ್ಮೇಲೆ ಪುನಃ ಆತನ ಅಣ್ಣನಿಗೆ ಚೆಕ್ಕಿನ ಸಂಬಂಧಪಟ್ಟದ ವ್ಯವಹಾರವನ್ನು ಆರೋಪಿ ಅಣ್ಣನಿಗೆ ನೀಡಿರುತ್ತೇನೆ ಎಂದರೆ ಆರೋಪಿಯ ಕೈಗೆ ನೀಡಿರುತ್ತೇನೆ ಎಕ್ಸೆಟ್ರಾ. ನೆಕ್ಸ್ಟ್ ಮೈ ಲಾರ್ಡ್, ಸೊ ಹಿಸ್ ವ್ಯವಹಾರ ಈಸ್ ವಿತ್ ದಿ ಫೈನಾನ್ಷಿಯಲ್ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ವಿತ್ ದ ಬ್ರದರ್. ಬ್ರದರ್ ನೀಡಿದ್ದೇನೆ. ನಾವು DP note recital is different, dates are different, and transaction which is narrated is entirely different, my lords. So these are inconsistent and highly unbelievable versions clearly show the checks obtained by the brother has been misused by him. So therefore, my lord, the necessary ingredients of the offense are not at all satisfied in the present case. In fact, this is a totally a false complaint that has been filed, my lords, and the evidence on the face of it clearly show that it's a false case, my lords. And what is stated in the DP note is about Baddi, 15% Baddi, which is also not their case now. And what PW 1 says is, my lords, General ಸಾಲ ಕೊಟ್ಟೆ ಮತ್ತೆ ಚೆಕ್ ಕೊಟ್ಟ ಅಂತ ಹೇಳಿ ಇಲ್ಲಿ 2007 ಅಲ್ಲಿ. His witness PW 2 says ಸಾಲ ಕೊಡುವಾಗಲೇ ಚೆಕ್ ತಗೊಂಡ್ವಿ ಅಂತ. And two different, for each aspect there is total contradiction. This shows how 138 has been misused, my lords, by using a stale, very old check and try to be represented again. And this is also legally impermissible, my lords. Therefore, this is a fit case which requires the kind intervention of the Honorable Revisional Court might exercise the revisional powers to stop the illegality and set right the illegality committed by both the courts. Most good.
Yes. That's all.
Please.
Lords, I would like to submit 2 case laws, my lords. One is by your lordship itself, my lords, and the other is by the Supreme Court, my lords. Lords. Lords, in the first case, my lords, which my lordship has written, my lords, which have also dealt with the case law, my lords, which the appellant counsel has given you, my lords. In page number, in paragraph number 4, my lords. This is the same case where my lords, on second attempt, my lords.
Closed.
Yes, my lords. Same account closed, my lords. On that basis, my lords had convicted the accused, my lords, and also it is also confirmed by the Supreme Court, my lords. Lords, if in paragraph number 4, my lords. Per contra, the counsel appearing for the respondent in the arguments contends that the court below, while acquitting the accused, taken note of the facts that when the check was presented at the first time, the same was returned with an endorsement account closed, and the very contention of the complainant that this respondent requested him to represent the check again is nothing but false one, and has no such request made, and this respondent has not given any instruction to present the check again when the account was closed. Counsel also, in his support, he relied upon the judgment of this court in between H. Nanjundappa and Hanumantarayappa, and in this judgment, this honorable court held that notice issued after second presentation in the case account closed. The question of successive presentation makes no sense. Complaint is barred by limitation, and hence acquittal is confirmed and dismissed the appeal. The counsel, relying upon this judgment, brought to my notice para 4 of the judgment and contends that when the account was closed, the question of successive presentation makes no sense because the account in itself is not in existence. There is no possibility of having a fruitful result by successive presentation, unlike in the case of insufficiency of funds. Hence, prayed the court to confirm the acquittal. My lords, if directly we come to paragraph number 11, my lords. For having taken note of the principles laid down in the judgment and also interpretations made in the judgment referred to supra, it is specific in the judgment of the apex court that if the entire purpose of section 138 of the Negotiable Instrument Act is to compel the drawers to honor their commitments made in the course of their business or other affairs. There is no reason why a person who has issued a check, who is dishonored and who fails to make payment despite statutory notice served upon them, should be immune to prosecution simply because the holder of check has not rushed to the court. In the case on hand, no doubt, when the check was presented for the first time, the account was closed. And it is the case of the complainant that the accused has requested him to represent the check, but the accused disputes the same. But it has to be noted that when the check was presented both times, endorsement was given as account closed. And when the apex court in the judgment held that even closure of account attracts 138 of the NI Act. And when the apex court recently held that number of presentation and issuance of notice for the second time will not be a bar to proceed against the accused. In this case, on the hand, also, the accused did not dispute the fact of issuance of check and also did not give any reply to the notice. The apex court in the judgment of Rangappa versus Mohan held that burden lies on the accused to rebut the presumption under section 139. In the case on hand, accused did not choose to enter the witness box and raise the probable defense. This is all the facts of that case, my lords. So, my lords, nowhere, if you come down, my lords, the second ground for acquitting the accused is that complainant has admitted in the cross-examination that in the both occasions notice was issued and the complainant's counsel made an attempt to convince this court by making mistake that by mistake PW1 gave such admission, and he was under confusion and only notice was given on the second time. But on the perusal of the cross-examination of PW1, he categorically admits issuance of notice on the return of check with an endorsement account closed. But now the same is immaterial in view of the judgment of apex court held in the judgment of Sikagan India Limited versus Mahindra Vadi Neni. There is no bar to file a complaint based on the second statutory notice, and when such being the principle laid down in this judgment in the of the apex court, the judgment of the trial court is liable to be set aside. The court below, on the two technical grounds, dismissed the complaint, and on the perusal of evidence of PW1, complainant has reiterated the averments of the check, issuance of check, and the cross-examination. It is elicited that amount was kept in fixed deposit, and others are of that case, my lords, facts of that case. So, my lords, this shows, my lords, my lordship have itself, my lords, went past beyond the judgment which my learned counsel has given, my lords, in Nanjundappa versus Hanmantappa, my lords, and the defense of account closed for the second time, my lords, is not taken, my lords. The same was seen, my lords, but because this is a recent judgment, my lords, the trial court has not considered, my lords. My lords, in the judgment of the trial court, appellate court, my lords, from paragraph number 12, my lords. Lords, now, if I may, my lords, if I can read. 12 paragraph, page number 11. Let us consider the question of legally recoverable debt before entering into the question of closure of accounts. Apart from the oral evidence which is available in record, which has been sufficiently discussed by the trial court in detail, the perusal of Exhibit P13 shows that the accused has demanded a DP note in favor of complainant. The Exhibit P13 is dated to 26/2/2006, and it is clearly mentioned that it was pertaining to a loan of rupees 1,65,000. The DP note, being a negotiable instrument act, it has a presumptive value regarding consideration, and therefore the oral evidence of PW1 is supported by documentary evidence also. It is not the checks at P1 to P4 alone which the complainant relies to prove his case. In entirety, evidence of DW1 and DW2, who are brothers, there is no reference to Exhibit P13. Therefore, the contention of the complainant that the sum of rupees 1,65,000 was advanced by him to the accused as hand loan, and to repay the said loan amount, the accused has issued checks as per Exhibit P1 to P4, having support of presumptive under law, has to be accepted. It is the case of the accused that the DW2, who is the brother of the accused, was doing a reconnect business, and the accused has given the entire checkbook of 15 signed leaves to DW2. It is contended that complainant was dealing with the Arecanut sale with DW2, and therefore, in the respect of such transaction of Arecanut, instead of giving chit to the complainant, DW2 had issued checks towards the security of the transaction. Therefore, the accused contends that he was not knowing the knowledge of the alleged transaction, and therefore he throws on his brother, that is Exhibit D, that is DW2. It is contended that the amount which were due was paid by DW2, and even then the complainant did not return the check to him. The evidence of DW2 also reiterates the above defense, but he states in his cross-examination that he did not demand the complainant to return the check after the payment of money. He says that he left it to the accused to receive the checks. Therefore, it is evident that DW1 and DW2 throws the burden on each other in their effort toward the liability. Very conspicuously, there is no mention of the DP note as per Exhibit P13 in their evidence. Their evidence revolves around the date of check, that is 7/5/2007, but it never touches any transaction that is in 2006 as per Exhibit P13. Therefore, the evidence of DW1 and DW2 insofar as legally recoverable debt is concerned, it is not convincing and falls short of creating any doubt in prosecution version. It do not probabilize in any way that there was no such legally recoverable debt. If there was no such debt, the question arises as to why the accused has executed Exhibit P13. Hence, this court also concurs with the finding of the court below that there was a legally recoverable debt. Lords, one more important thing, my lords, that DW1, my lords, specifically contends that he has given the check in the year 2006, my lords. But during the examination of DW4, my lords, the bank manager, he says, my lords, that in the year 2005, the account was closed because of not maintaining of balance, my lords. Even in that case, my lords, if the contention is accepted, my lords, giving a check of a year of a account, my lords, which is already closed, also amounts to offense under the NI Act, my lords. Lords, in that regard, my lords, the cross-examination of DW1 and DW2 is to be looked, my lords. If my lords are not convinced with the judgment of the appellate court, my lords. Lords, got it?
Evidence
Evidence.
of DW1.
DW1, my lords. ನಾನು ಈ ಕೇಸಿನ ಆರೋಪಿಯಾಗಿದ್ದು ಫಿರ್ಯಾದಾರರು ಗೊತ್ತು. ನನಗೆ ಅಣ್ಣ ಗೋಪಾಲ ಪುಂಜಾರಿ ಅವರು ಮೂಲಕ ಫಿರ್ಯಾದಾರರು ಪರಿಚಯ ಆಗಿದ್ದರು. ನನ್ನ ಅಣ್ಣ ಪುಂಜಲಾಕಟ್ಟೆಯಲ್ಲಿ ಅಡಿಕೆ ವ್ಯಾಪಾರ ಮಾಡುತ್ತಾರೆ. ನನ್ನ ಅಣ್ಣ ಹಾಗೂ ಫಿರ್ಯಾದಾರರ ನಡುವೆ ವ್ಯವಹಾರ ಆಗಿರುತ್ತದೆ. ನನ್ನ ಅಣ್ಣ ಫಿರ್ಯಾದಾರರೊಂದಿಗೆ 2002 ರಿಂದ 2007-8 ರವರೆಗೆ ಅಡಿಕೆ ವ್ಯಾಪಾರ ಮಾಡುತ್ತಾರೆ. 2007 ರಲ್ಲಿ ಅಡಿಕೆ ವ್ಯಾಪಾರ ಮಾಡುವಾಗ ಸಮಯದಲ್ಲಿ ನಾನು ಸಹ ಇದ್ದೆ. ಸದರಿ ಅಡಿಕೆ ವ್ಯವಹಾರದ ಸಂದರ್ಭ ನನ್ನ ಅಣ್ಣ ಫಿರ್ಯಾದಾರರಿಗೆ ರಶೀದು ನೀಡುತ್ತಾರೆ. ಆ ಸಮಯದಲ್ಲಿ ನಾನು ನನ್ನ ಅಣ್ಣನಿಗೆ ಚೆಕ್ ನೀಡುತ್ತೇನೆ. ಸದರಿ ಚೆಕ್ ಅನ್ನು ಫಿರ್ಯಾದಾರರಿಗೆ ವ್ಯವಹಾರ ಸಲುವಾಗಿ ನನ್ನ ಅಣ್ಣ ಫಿರ್ಯಾದಾರರಿಗೆ ಭದ್ರತೆ ದೃಷ್ಟಿಯಲ್ಲಿ ನೀಡಿದ್ದರು. ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್ ಮೈ ಲಾರ್ಡ್ಸ್. ಆಗ ಮಹಾಬಲ ಪೂಜಾರಿ ಮತ್ತು ಯಶೋಧರ ಪೂಜಾರಿ ಎಂಬುವರು ಹಾಜರಿದ್ದರು. ನಾನು ನನ್ನ ಅಣ್ಣ ಖಾಲಿ ಚೆಕ್ ನೀಡುತ್ತೇನೆ, ಅದನ್ನು ಅವರ ಫಿರ್ಯಾದಾರರಿಗೆ ನೀಡಿದ್ದರು. ಫಿರ್ಯಾದಾರರು ನನ್ನ ನಂತರ ನಮ್ಮ ಅಣ್ಣನ ಬಳಿ ಬಂದು ಸದರಿ ವ್ಯವಹಾರ ಸಂಬಂಧ ಹಣ ಪಡೆದು ಹೋಗಿರುತ್ತಾರೆ. ಫಿರ್ಯಾದಾರರು ಸದರಿ ಚೆಕ್ ಅನ್ನು ಹಣ ಸಂದಾಯ ಮಾಡಿದ ನಂತರವೂ ಹಿಂದಿರುಗಿಸುವುದಿಲ್ಲ. ಫಿರ್ಯಾದಾರರು ಸದರಿ ಹಣಕ್ಕೆ ಬಡ್ಡಿ ಕೊಡಬೇಕು ಹೇಳಿದರು. ಸದರಿ ಬಡ್ಡಿ ಹಣವನ್ನು ನೀಡದಿದ್ದರೆ ಚೆಕ್ ಅನ್ನು ಹಾಕುತ್ತೇನೆ ಹೇಳಿದರು. ಫಿರ್ಯಾದಾರರು ಮತ್ತು ನನ್ನ ನಡುವೆ ಯಾವುದೇ ವ್ಯವಹಾರ ಇರುವುದಿಲ್ಲ. ನಾನು ಫಿರ್ಯಾದಾರರೊಂದಿಗೆ ಯಾವುದೇ ಹಣ ನೀಡಲ್ಲ, ಬದ್ಧನಾಗಿರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ತೀರ್ಪು ನೀಡಬೇಕೆಂದು ಕೋರಿರುತ್ತಾರೆ. ನೆಕ್ಸ್ಟ್ ಮೈ ಲಾರ್ಡ್ಸ್, ನಿಪಿ 1 ರಿಂದ 4 ಚೆಕ್ಗಳು ನನ್ನ ಖಾತೆಗೆ ಸಂಬಂಧಿಸಿರುತ್ತದೆ. ಇದು ಸದರಿ ಚೆಕ್ಕಿನಲ್ಲಿ ಇರುವ ಸಹಿ ನನ್ನದಾಗಿರುತ್ತದೆ. ನಿಪಿ 1 ರಿಂದ 4 ಚೆಕ್ಕಿನಲ್ಲಿ ಇರುವ ವಿವರಗಳನ್ನು ಯಾರು ಬರೆದಿರುತ್ತಾರೆಂದು ನನಗೆ ಗೊತ್ತಿರುವುದಿಲ್ಲ. ಯಾವುದೇ ಚೆಕ್ ಅನ್ನು ಒಬ್ಬ ವ್ಯಕ್ತಿಗೆ ನೀಡುವಾಗ ವಿವರಗಳನ್ನು ಬರೆದು ಸಹಿ ಮಾಡಿಕೊಡಬಾರದು ಎಂದು ನನಗೆ ಗೊತ್ತಿರುತ್ತದೆ. ಫಿರ್ಯಾದಾರರು ನಮ್ಮ ಅಣ್ಣ ಅಂಗಡಿಯಲ್ಲಿ ವ್ಯವಹಾರ ಮಾಡುತ್ತಿದ್ದಾಗ ಬಗ್ಗೆ ನಾನು ನನ್ನ ಅಣ್ಣ ಅಂಗಡಿಯಲ್ಲಿ ಇದ್ದ ಕಾರಣ ನನಗೆ ಗೊತ್ತಿರುತ್ತದೆ. ಫಿರ್ಯಾದಾರರು ಬಹಳಷ್ಟು ಬಾರಿ ನಮ್ಮ ಅಂಗಡಿಯಲ್ಲಿ ವ್ಯವಹಾರ ಮಾಡಿರುತ್ತಾರೆ. ಅಡಿಕೆ ಅಂಗಡಿ ನನ್ನ ಅಣ್ಣನ ಹೆಸರಲ್ಲಿ ಇರುತ್ತದೆ. ಅವರಿಗೆ ಬ್ಯಾಂಕಿನಲ್ಲಿ ಖಾತೆ ಇರುತ್ತದೆ. ಆದರೆ ಚೆಕ್ ಪುಸ್ತಕ ಬಗ್ಗೆ ಗೊತ್ತಿರುವುದಿಲ್ಲ. ಅಡಿಕೆ ಅಂಗಡಿಯ ವ್ಯವಹಾರವನ್ನು ನನ್ನ ಅಣ್ಣ ನೋಡುತ್ತಾರೆ. ಸದರಿ ವ್ಯವಹಾರದಲ್ಲಿ ನಾನು ಭಾಗವಹಿಸುವುದಿಲ್ಲ. ಸದರಿ ಅಂಗಡಿಯಲ್ಲಿ ದುಡ್ಡು ಕೊಡುವ ವ್ಯವಹಾರವನ್ನು ನನ್ನ ಅಣ್ಣನೇ ಮಾಡುತ್ತಿದ್ದರು. ನಾನು ನನ್ನ ಅಣ್ಣನಿಗೆ ನಿಪಿ 1 ಚೆಕ್ ಹೊರತುಪಡಿಸಿ ಬೇರೆ ಒಂದು ಚೆಕ್ ನೀಡಿರುತ್ತೇನೆಂದರೆ ಸಾಕ್ಷಿಯು ಚೆಕ್ ಪುಸ್ತಕವನ್ನು ನೀಡಿರುತ್ತೇನೆ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ನಾನು 15 ಚೆಕ್ ಹಾಳೆಗಳನ್ನು ಪುಸ್ತಕವನ್ನು ನೀಡಿದ್ದು ಅದರಲ್ಲಿ 15 ಹಾಳಿ ಸಹಿ ಮಾಡಿ ನೀಡಿದ್ದೆನು. ಸದರಿ ಪುಸ್ತಕ ನೀಡುವ ಸಮಯದಲ್ಲಿ ನನ್ನ ಖಾತೆಯಲ್ಲಿ ಹಣ ಇರಲಿಲ್ಲ. ನನ್ನ ಖಾತೆಯಲ್ಲಿ ಹಣ ಇದ್ದರೂ ಬೇರೆಯವರಿಗೆ ಮೋಸ ಮಾಡುವ ಉದ್ದೇಶದಲ್ಲಿ ಚೆಕ್ಗಳನ್ನು ಸಹಿ ಮಾಡಿಕೊಟ್ಟಿದ್ದೇನೆಂದರೆ ಸರಿಯಲ್ಲ. ಸದರಿ ಚೆಕ್ ನನ್ನ ಅಣ್ಣನಿಗೆ ನೀಡಿದ 15 ಚೆಕ್ಗಳನ್ನು ನಮ್ಮ ಅಣ್ಣ ಯಾರಿಗೆ ನೀಡುತ್ತಾನೆಂದು ಗೊತ್ತಿಲ್ಲ. ಸದರಿ ಚೆಕ್ಕಿನ ಪೈಕಿ ಪ್ರತಿ ಚೆಕ್ಕನ್ನು ಯಾರಿಗೆ ನೀಡಿರುತ್ತಾರೆಂದು ಗೊತ್ತಿಲ್ಲ. ಸದರಿ 15 ಚೆಕ್ಗಳನ್ನು ನಾನು ಇಲ್ಲದ ಸಮಯದಲ್ಲಿ ನನ್ನ ಅಣ್ಣ ನೀಡಿರುತ್ತಾರೆ. ನನ್ನ ಸಹಿ ಮಾಡಿದ ಚೆಕ್ಕು ನಮ್ಮ ಅಣ್ಣನಿಗೆ ಯಾವಾಗ ನೀಡುತ್ತೆ ನೆನಪಿಲ್ಲ. ಸಾಕ್ಷಿಯು ಮುಂದುವರೆದು ಅಂದಾಜು 2006 ನೀಡಬಹುದೆಂದು ನೀಡುತ್ತಾರೆ. ಫಿರ್ಯಾದಾರರು ನಮ್ಮ ಅಣ್ಣನ ಅಂಗಡಿಗೆ ತಂದು ಕೊಡುವ ಸಮಯದಲ್ಲಿ ಒಂದು ಬಾರಿ ನಾನು ಇದ್ದೆನು. ಅದು 2006 ಸದರಿ ಸಮಯದಲ್ಲಿ 5.5 ಕ್ವಿಂಟಲ್ ಅಡಿಕೆ ತಂದಿರಬಹುದು. ಸದರಿ ದಿನ ಅಡಿಕೆ ನಮ್ಮ ಅಣ್ಣ ಪಾವತಿಸಿರುವುದಿಲ್ಲ, ಭೇಟಿ ಮಾತ್ರ ಮಾಡಿಕೊಟ್ಟಿರುತ್ತಾರೆ. ಫಿರ್ಯಾದಾರರು ನನ್ನ ಬಳಿ ಹಣ ವಾಪಸ್ಸು ನೀಡಬೇಕೆಂದು 2-3 ಬಾರಿ ಕೇಳಿದರು, ಆದರೆ ನಾನು ನೀಡಿರುವುದಿಲ್ಲ. ಕಾರಣ ಅಣ್ಣನಿಗೆ ಸಂಬಂಧಿಸಿದ ವ್ಯವಹಾರ ಆಗಿರುತ್ತೆ. ನನ್ನ ಅಣ್ಣ ಫಿರ್ಯಾದಾರರಿಗೆ ಹಣ ನೀಡುವ ಸಮಯದಲ್ಲಿ ನಾನು ಹಾಜರಿರುವುದಿಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಮೇಲೆ ನೋಟ್ಸ್. ಫಿರ್ಯಾದಾರರು ತಿಂಗಳು 2,000 ಬಡ್ಡಿಗೆ 1 ಲಕ್ಷ ನೀಡುವಂತೆ ಕೇಳಿದರು. ನಾನು ಫಿರ್ಯಾದಾರರಿಗೆ ಚೆಕ್ ಅನ್ನು ವಾಪಸ್ಸು ನೀಡುವಂತೆ ಎಂದಿಗೂ ಕೇಳಿರಲಿಲ್ಲ. ಆದರೆ ನನ್ನ ಅಣ್ಣನು ಹೇಳಿದನು, ನನಗೆ ನನ್ನ ಹಾಗೂ ಫಿರ್ಯಾದಾರರ ನಡುವೆ ಚೆಕ್ಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಯಾವುದೇ ಮಾತುಕತೆ ಆಗಿರುವುದಿಲ್ಲ. ಫಿರ್ಯಾದಾರರು ನನಗೆ ನೀಡಿದ ನೋಟಿಸು ನನಗೆ ತಲುಪಿದೆ, ಆದರೆ ನಾನು ಯಾವುದೇ ಉತ್ತರವನ್ನು ನೀಡಿರುವುದಿಲ್ಲ. ನಂತರ ನಾನು ಫಿರ್ಯಾದಾರರನ್ನು ನೋಟಿಸ್ ನೀಡಲು ಕಾರಣವೇನೆಂದು ವಿಚಾರಿಸಿರುವುದಿಲ್ಲ. ಈಗ ತೋರಿಸಿದ ದಾಖಲೆಯಲ್ಲಿರುವ ಸಹಿ ನನ್ನದಾಗಿರುತ್ತದೆ. ಸದರಿ ದಾಖಲೆಯನ್ನು ನಿಪಿ 13 ಗುರುತಿಸಲಾಯಿತು. ನನ್ನ ಸಹಿ ನಿಪಿ 13A ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಸದರಿ ದಾಖಲೆಯಲ್ಲಿ ಬರೆದ ವಿಳಾಸ ನನ್ನದಾದರೂ ಅದರಲ್ಲಿ ಬರೆದಿರುವ ವಿಚಾರಣೆ ಗೊತ್ತಿರುವುದಿಲ್ಲ. ನನಗೆ ಪೂಂಜಲಕಟ್ಟೆ ಲೋಕೇಶ್ ಆಚಾರ್ಯ ಮತ್ತು ರಾಮದಾಸ್ ಆಚಾರ್ಯ ಪರಿಚಯ ಇರುತ್ತದೆ. ದಿನಾಂಕ 26/2/2006 ನಾನು ಫಿರ್ಯಾದಾರರನ್ನು 1 ಲಕ್ಷ ರೂಪಾಯಿ ಸಾಲ ಪಡೆದು ಆ ಬಗ್ಗೆ ನಿಪಿ 13 ದಾಖಲೆ DP ಅನ್ನು ಬರೆದು ಕೊಟ್ಟಿರುತ್ತೇನೆ ಅಂದ್ರೆ ಸರಿಯಲ್ಲ. ಸದರಿ ಹಣವನ್ನು ಫಿರ್ಯಾದಾರರು ಕೇಳಿದಾಗ ಮರುಪಾವತಿ ಮಾಡದೆ ಆ ಬಗ್ಗೆ 4 ಚೆಕ್ಕುಗಳನ್ನು ನೀಡಿದರೆ, ಹಾಗೆ ಸಾಲ ಪಡಿಸಿ ಚೆಕ್ಕು ನೀಡಿದ ನನಗೆ ತಿಳಿಯದೆ ಕಾರಣ ನಾನು ಫಿರ್ಯಾದಾರರು ನೀಡಿದ ನೋಟಿಸಿಗೆ ಉತ್ತರ ನೀಡಿರುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಾನು ಸದರಿ ಹಣ ಕೊಡಬೇಕಾಗಿದ್ದು ಎಂದು ನನ್ನ ಖಾತೆಯಲ್ಲಿ ಮುಚ್ಚಿರುತ್ತೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಾನು ಫಿರ್ಯಾದಾರರಿಂದ ಹಣ ಪಡೆದು ಸದರಿ ಹಣ ಪಾವತಿ ಚೆಕ್ಕು ನೀಡಿದ ಈಗ ಸದರಿ ಹಣವನ್ನು ಮಾಡಬೇಕಾಗುತ್ತದೆ ಎಂಬ ಕಾರಣದಿಂದ ನಾನು ಹಾಗೂ ಫಿರ್ಯಾದಾರರ ನಡುವೆ ಯಾವುದೇ ವ್ಯವಹಾರ ಆಗುವುದಿಲ್ಲ ಎಂದು ಸುಳ್ಳು ಸಾಕ್ಷಿ ಹೇಳುತ್ತಾ, ದಿಸ್ ಇಸ್ ದ ಎವಿಡೆನ್ಸ್ ಆಫ್ DW1 my lords. Now DW2 my lords, the brother of accused my lords. ನನಗೆ ಈ ಕೇಸಿನ ಫಿರ್ಯಾದಾರರು ಹಾಗೂ ಆರೋಪಿಯು ಪರಿಚಯರಾಗಿರುತ್ತದೆ. ಆರೋಪಿ ದಿನೇಶ್ ಪೂಜಾರಿ ನನ್ನ ತಮ್ಮ ಇರುತ್ತದೆ. ನಾನು ಹಾಗೂ ಈ ಕೇಸಿನ ಫಿರ್ಯಾದಾರರ ನಡುವೆ ಅಡಿಕೆ ವ್ಯವಹಾರ ಇತ್ತು. ಕಳೆದ 7-8 ವರ್ಷದಿಂದ ಅವರ ಜೊತೆ ಅಡಿಕೆ ವ್ಯವಹಾರ ಇತ್ತು. 2007 ಅವರು ನನ್ನ ಬಳಿ ಅಡಿಕೆ ವ್ಯವಹಾರವನ್ನು ಮಾಡುತ್ತಿದ್ದರು. ನಾವು ಅಡಿಕೆ ವ್ಯಾಪಾರ ಮಾಡುವ ಚೀಟಿ ಕೊಡುತ್ತೇವೆ, ಹಣ ಇಲ್ಲದೆ ಕಾರಣ ಚೆಕ್ ಅನ್ನು ಕೊಡುತ್ತೇವೆ. ಸದರಿ ಅಡಿಕೆ ಖರೀದಿಸಿದ ಸಮಯದಲ್ಲಿ ಹಣ ಇದ್ದರ ಕಾರಣ ನನ್ನ ತಮ್ಮನ ಚೆಕ್ ಅನ್ನು ನೀಡಿದ್ದೆನು. ಹಣ ಇಲ್ಲದ ಕಾರಣ ಚೆಕ್ ಅನ್ನು ಭದ್ರತೆಗಾಗಿ ನೀಡಿದ್ದೆನು. ನಂತರ ನಾವು ಸದರಿ ಹಣವನ್ನು ನೀಡಿರುತ್ತೇವೆ, ಆದರೆ ನಾವು ನೀಡಿದ ಚೆಕ್ಗಳನ್ನು ವಾಪಸ್ ನೀಡಿರುವುದಿಲ್ಲ. ಸದರಿ ಚೆಕ್ಗಳನ್ನು ನನ್ನ ತಮ್ಮನಲ್ಲಿ ಕೊಡುತ್ತೇನೆ ಎಂದು ಹೇಳಿದರು, ಆದರೆ ಅವರ ಬಳಿ ಸಹಿ ವಾಪಸ್ ನೀಡಿರುವುದಿಲ್ಲ. ಸದರಿ ವ್ಯವಹಾರ ಸಮಯದಲ್ಲಿ ಯಶೋಧರ ಪೂಜಾರ ಮತ್ತು ಮಹಾಬಲ ಪೂಜಾರಿಯವರು ಹಾಜರಿದ್ದರು. ನಾವು ಒಟ್ಟು 4 ಚೆಕ್ಗಳನ್ನು ಭದ್ರತೆಗಾಗಿ ನೀಡಿದ್ದೆನು. ನಾವು ನೀಡಿದ 4 ಚೆಕ್ಕು ದಿನಾಂಕ ಮತ್ತು ಮೊತ್ತವನ್ನು ನಮೂದಿಸಿ ಕೊಟ್ಟಿರುವುದೆವು. ಸದರಿ ಚೆಕ್ಕುಗಳನ್ನು ನೀಡುವಾಗ ನನ್ನ ತಮ್ಮ ಇರಲಿಲ್ಲ, ಅವರು ಮನೆಯಲ್ಲಿದ್ದರು. ಸದರಿ ಫಿರ್ಯಾದಾರರಿಗೆ ನೀಡಿದ 4 ಚೆಕ್ಕುಗಳನ್ನು ನನ್ನ ತಮ್ಮನೇ ನನಗೆ ನೀಡಿದ್ದರು. ಸದರಿ ಚೆಕ್ಕುಗಳನ್ನು ಅಗತ್ಯ ಇದ್ದಾಗ ಉಪಯೋಗಿಸುವ ಸಲುವಾಗಿ ನನ್ನ ತಮ್ಮ ನನಗೆ ನೀಡಿದ್ದರು. ನಾವು ಅಡಿಕೆ ತೆಗೆದುಕೊಳ್ಳುವಾಗ ಬಿಲ್ಲುಗಳನ್ನು ತಯಾರಿಸುತ್ತೇವೆ ಎಂದರೆ ಸರಿ. ನಾವು ಅಡಿಕೆ ಖರೀದಿಸುವವರು ಬಳಿ ಹಣ ನೀಡಿದಾಗ ಬಿಲ್ಲಿನಲ್ಲಿ ನಾನು ಸಹಿ ಪಡೆಯುತ್ತೇವೆ. ಸದಾಶಿವ ಪ್ರಭು ಅವರಿಗೂ ಸಹ ಬಿಲ್ಲನ್ನು ನೀಡಿದ್ದೆವು. ನಾವು ಫಿರ್ಯಾದರಿಗೆ ಮಾಡುವ ದುಡ್ಡು ನೀಡಿದ ನಂತರ ಅವರಿಂದ ಸಹಿ ಪಡೆದಿರುವುದಿಲ್ಲ. ಏಕೆಂದರೆ ಸದರಿ ಹಣವನ್ನು ನಾನು ನೀಡಿರುವುದಿಲ್ಲ, ಅದನ್ನು ಯಶೋಧರವರ ಪೂಜಾರಿ ನೀಡಿದ್ದರು ಎಂದು ಸಾಕ್ಷಿ ನುಡಿಯುತ್ತಾರೆ. ಯಶೋಧ ಪೂಜಾರಿ ಹಣ ನೀಡಿದ ಬಗ್ಗೆ ನನಗೆ ಫೋನ್ ನಲ್ಲಿ ತಿಳಿಸಿದರು. ನಾನು ಫಿರ್ಯಾದರಿಗೆ 7/5/2007 ರಂದು ಹಣವನ್ನು ನೀಡಿರುತ್ತೇನೆ. ಸದರಿ ಹಣ ಕೊಟ್ಟ ನಂತರ ಚೆಕ್ಕುಗಳನ್ನು ನನ್ನ ತಮ್ಮನ ಬಳಿ ನೀಡುತ್ತೇನೆಂದು ಹೇಳಿದರು. ಅದನ್ನು ನೀಡಿರುವುದಿಲ್ಲ. ಸದರಿ ಚೆಕ್ಕುಗಳನ್ನು ನೀಡುತ್ತೇನೆ ಎಂದು ಯಶೋಧರ ಪೂಜಾರು ಮತ್ತು ಮಹಾಬಲ ಪೂಜಾರಿ ಬಳಿ ಫಿರ್ಯಾದರು ತಿಳಿಸುತ್ತಾರೆ ಎಂದು ನನಗೆ ಸದರಿ ಅವರು ಹೇಳಿದರು. ನಂತರ ಚೆಕ್ಕುಗಳನ್ನು ವಾಪಸ್ ನೀಡುವಂತೆ ನನ್ನ ಫಿರ್ಯಾದರರು ಕೇಳಿರುವುದಿಲ್ಲ. ಆದರೆ ನನ್ನ ತಮ್ಮ ಚೆಕ್ಕುಗಳನ್ನು ವಾಪಸ್ ಕೇಳುತ್ತಾರೆ ಎಂದು ನನ್ನ ಬಳಿ ಹೇಳಿದರು. ಆ ನಂತರ ಸದರಿ ಚೆಕ್ಕುಗಳನ್ನು ವಾಪಸ್ ನೀಡುವಂತೆ ನಾನು ಫಿರ್ಯಾದರಿಗೆ ಬರವಣಿಗೆ ಮೂಲಕ ನಾನು ಏನು ಕೇಳಿರುವುದಿಲ್ಲ. ಸದರಿ ಜವಾಬ್ದಾರಿಯನ್ನು ನನ್ನ ತಮ್ಮನಿಗೆ ಬಿಟ್ಟು ಕೊಡಿರುತ್ತೇನೆ. ನಾನು ಫಿರ್ಯಾದಾರರೊಂದಿಗೆ ಯಾವತ್ತೂ ಹಣವನ್ನು ನೀಡಿರುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಾನು ಹೇಳಿದ ಹಾಗೆಯೇ ಯಶೋಧ ಪೂಜಾರಿ ಹಾಗೂ ಮಹಾಬಲ ಪೂಜಾರಿ ಅವರನ್ನು ಹಣ ನೀಡಿರುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಆರೋಪಿ ನನ್ನ ತಮ್ಮ ಇರುತ್ತಾನೆ ಎಂದರೆ ಸರಿ. ನನ್ನ ತಮ್ಮ ನನ್ನ ಜೊತೆ ಅಡಿಕೆ ವ್ಯಾಪಾರ ಮಾಡುತ್ತಿದ್ದರೆಂದರೆ ಸರಿ. ನನ್ನ ತಮ್ಮನಿಗೆ ಸಹಾಯ ಮಾಡುವ ಸಲುವಾಗಿ ನಾನು ಹಣ ಕೊಟ್ಟಿರುತ್ತೇನೆ ಮತ್ತು ತಮ್ಮನ ಚೆಕ್ಕುಗಳನ್ನು ಭದ್ರತೆಗೆ ನೀಡಿರುತ್ತೇನೆ ಎಂದು ಸುಳ್ಳು ಸಾಕ್ಷಿ ಹೇಳುತ್ತಿದ್ದೇನೆ ಎಂದರೂ ಸರಿಯಲ್ಲ. ನಿಜವಾಗಿ ನನ್ನ ಮತ್ತು ನನ್ನ ತಮ್ಮನ ಫಿರ್ಯಾದರರೊಂದಿಗೆ ಅಡಿಕೆ ಖರೀದಿಸುವ ಬಗ್ಗೆ ಸದರಿ 4 ಚೆಕ್ಕುಗಳನ್ನು ಫಿರ್ಯಾದರರಿಗೆ ನನ್ನ ಸಮಕಮ ನನ್ನ ತಮ್ಮ ನೀಡಿದ್ದರು ಎಂದರೆ ಸಾಕ್ಷಿಯು ಅಸಮಾನತದಲ್ಲಿ ನಾನು ಇರಲಿಲ್ಲ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ಸದರಿ ಚೆಕ್ಕುಗಳನ್ನು ನೀಡುವಾಗ ನಾನು ಅಲ್ಲಿ ಇರಲಿಲ್ಲ. Lords, the evidence of DW1 and DW2, my lords, itself is very contradictory in nature, my lords, where DW1 says, my lords, I am not at all involved in the Adike Vyapara, my lords, but DW2 says, my lords, says, even my brother is involved in the Arecanet business, my lords, and also, it is also specifically contained that it is a security check which is given to the brother of accused, my lords, and both are parties of the business, my lords. In that regard, my lords, the appellate court and trial court has rightly convicted the accused, my lords.
That's all.
Yes, my lords. And also regarding, my lords, the exhibit P13, my lords, where the DP note, about DP note, my lords, not even DW1, my lords, not even DW2, my lords, takes any contention and cross-examines regarding exhibit P13, my lords, to the complainant, my lords. The same is held by the appellate court.
That's all. Yes, any reply?
By the petition relied upon by my learned friend, which is read by my lord. Kindly see, para 12. See that. Para 12 in Muddu, page number 2. Page number 2, para 12, continue page number 12. Middle portion. Endorsement account closed and the same was intimated, and thereafter page 12, and thereafter accused requested the complainant 1 month time, further requested him to represent the check again. Same was again presented. These are the facts, and considering those facts, where the request was made by the accused to represent him, this only court noted in para 12. In the case on hand also, no doubt when the check was presented for the first time, account was closed. It is the case of the complainant, the accused has requested him to represent the check. Accused disputes. It has to be noted that the check was presented, both the times endorsement was so and so, so and so. Now this one court considers the question, can there be representation? My lord, as far as the principle of law is concerned, that can be presented any number of times is not in dispute. Kindly see the facts of this case. What this honorable court says is, it can be represented any number of times, and there was a request made by him. As far as this case is concerned, kindly see the complaint for a moment. What is the pleading made in the complaint? In the notice also there is no reference. In the complaint, kindly see para 2. First sentence is, for the repayment of the legally recoverable debt, so and so, issued the check. First page. Next para. Believing the present representation, check was presented. So and so, check was presented, will be complaint, present the said checks. Collection through SCDC Bank Limited, Beltangadi, unfortunately returned dishonored on 3/7. Kindly see para 3. There is no reference of first presentation. No allegation that there was request for representation.
Yes.
That factual foundation is also not laid. This is one aspect. Therefore, each decision in a criminal case, my lord, would differ from fact to fact. This is the factual situation. Moreover, kindly see, my lord, what my learned friend read out, evidence of kindly see PW1 himself, para 2, for first, my lord, back to submit the complaint is stated, para 2, for the repayment of the legally recoverable debt in the complaint, first sentence. What is the business? What nature of transaction is not stated. Now, for the first time in the evidence, he says, he improves it. He says, para 2. Date is also not mentioned. Now introduces the date.
Yes.
Para 2, examiner chief, ROP adike ವ್ಯಾಪಾರಕ್ಕಾಗಿ 2007 PW1. January ತಿಂಗಳಲ್ಲಿ, etc. Next, kindly see the cross examination. Aunde, page number 3. So, PW1, please. Page number 3. ನನಗೆ ಚೆಕ್ ನೀಡುವ 4 ದಿನ ಮುಂಚಿತವಾಗಿ ಆರೋಪಿಗೆ ಹಣ ನೀಡಿದ್ದೇನೆ.
PW1.
ಸಾರಿ, PW1 ನಲ್ಲಿ ಎಕ್ಸಾಮಿನೇಷನ್ ಚೀಫ್ ಅಲ್ಲಿ ಪ್ಯಾರಾ 2 ಆರೋಪಿಯು ಅಡಿಕೆ ವ್ಯಾಪಾರಕ್ಕಾಗಿ ಅಡಿಕೆ ವ್ಯಾಪಾರದ ಬಂತು ಇಲ್ಲಿಗೆ 2007 ಜನವರಿ ಹಣ ಪಡ್ಕೊಂಡ. ನೆಕ್ಸ್ಟ್ ಕೈಂಡ್ಲಿ ಸಿ ಡೈರೆಕ್ಟ್ಲಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಪೇಜ್ ನಂಬರ್ 1, 2 ಇದು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಪೇಜ್ 3 ಅಂತ ಇದೆ. ಅದು ಆಕ್ಚುಲಿ 4, 5 ಆಗಬೇಕು. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ 23/12/2009. ಮುಂದುವರಿದ ಪಾಠ ಸವಾಲು, ನನಗೆ ಚೆಕ್ ನೀಡುವ 4 ದಿನ ಮುಂಚಿತವಾಗಿ ಆರೋಪಿಗೆ ಹಣ ನೀಡಿದ್ದೇನೆ. ಆರೋಪಿ ಹಣವನ್ನು ನನ್ನ ಮನೆಗೆ ಬಂದು ಪಡೆದುಕೊಂಡು ಹೋಗಿರುತ್ತಾನೆ. ಆರೋಪಿ 4 ಚೆಕ್ಗಳನ್ನು ಒಂದೇ ದಿನ ನೀಡಿರುತ್ತಾನೆ. 4 ಚೆಕ್ಗಳನ್ನು ನನಗೆ ಗೋಪಾಲ್ ಟ್ರೇಡರ್ಸ್ ನಲ್ಲಿ ಪಡೆದುಕೊಂಡಿದ್ದೇನೆ ಎಂದರೆ ಸಾಕ್ಷಿಯು ಲೋಕೇಶ್ ಪೂಜಾರಿ ಅವರ ಅಂಗಡಿಯಲ್ಲಿ ನೀಡುತ್ತಾನೆ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ಹಾಗಾದ್ರೆ ಹಣ ಕೊಟ್ಟಿದ್ದು ಮನೆಯಲ್ಲಿ, ಚೆಕ್ಕು ಲೋಕೇಶ್ ಪೂಜಾರಿ ಅಂಗಡಿಯಲ್ಲಿ ಆಯ್ತು. ಸದ್ರಿ ಚೆಕ್ ನನ್ನ ಸಮಕ್ಷಮೇ ಸಹಿ ಮಾಡಿ ಇರುತ್ತಾರೆ. P1 ರಿಂದ 4 ಚೆಕ್ಗಳು ಬರೆದಂತ ಅಕ್ಷರಗಳು ಮತ್ತು ಸಹಿಗಳು ವ್ಯತ್ಯಾಸ ಇರುತ್ತದೆ ಎಂದರೆ ಸಾಕ್ಷಿ ಇರಬಹುದು ಎಂದು ನುಡಿಯುತ್ತಾರೆ. P1 ರಿಂದ 4 ಮತ್ತು P11 ರಲ್ಲಿರುವ ಸಹಿಗಳಿಗೆ ವ್ಯತ್ಯಾಸ ಇರುತ್ತದೆ ಎಂದರೆ ನನಗೆ ಹೇಳಲು ಆಗುವುದಿಲ್ಲ. ನಾನು ಆರೋಪಿಗೆ ಯಾವುದೇ ಹಣ ನೀಡಿರುವುದಿಲ್ಲ. ಫುಲ್ ಸ್ಟಾಪ್. ಅವರ ಅಣ್ಣ ನನ್ನಿಂದ ಹಣ ಪಡೆದಿರುತ್ತಾರೆ. ನನ್ನ ಮತ್ತು ಆರೋಪಿ ನಡುವೆ ಯಾವುದೇ ಹಣದ ವ್ಯವಹಾರ ಇರುವುದಿಲ್ಲ ಎಂದು ಆರೋಪಿ ಚೆಕ್ ನೀಡಿರುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಮೈ ಲಾರ್ಡ್ಸ್, ದಿಸ್ kindly appreciate it in the light of the previous page, middle portion. ನಾನು ಆರೋಪಿ ಅಣ್ಣನಿಗೆ ಆಗ ಹೇಳಿದ್ನ ಓದಿ ಸ್ವಾಮಿ. ಆರೋಪಿ ಅಣ್ಣನಾದ ಗೋಪಾಲ್ನಿಗೆ ವ್ಯವಹಾರಕ್ಕಾಗಿ ದುಡ್ಡನ್ನು ನೀಡಿರುತ್ತೇನೆ. ನಾವು ಈ ಸೇಸ್ ಮೈ ಲಾರ್ಡ್ ಎಂಟೈರ್ ಕೇಸ್ ಇಸ್ ಆರೋಪಿ ಅಣ್ಣನಿಗೆ ನೀಡಿರುತ್ತೇನೆ. ಚೀಫ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆರೋಪಿಗೆ ನೀಡಿರುತ್ತೇನೆ. ನಾವು ಕೈಂಡ್ಲಿ ಸಿ ಮೈ ಲಾರ್ಡ್ the evidence of his own next witness. His version is
already you pointed out reply. Once again you are arguing.
Only one sentence I beg to submit, my lord. Both the courts fail to note about these discrepancies. Simply say there is a DP note dated so and so, that this dates itself given evidence of PW1, PW2 and what is confronted to accused are entirely different. This is never taken note of. And the argument is, I have not cross-examined PW1 or PW2 on the DP note. DP note is confronted for the first time, my lord, through the
PW1.
So there was no occasion. Therefore, appreciation of evidence by the courts will are totally perverse. They presume everything to be true, even the falsity is on the face of it. The my lord, defense evidence can be considered only later. First, prosecution has to prove its case, and defense version, my lord, when 139 presumption gets displaced, then the defense evidence has any other probable version, my lord, that has been led. But prosecution case is false, and it cannot be said to be proved by way of the defense evidence. So this appreciation of evidence is totally legally perverse and impermissible.
Yes.
About
Sorry, madam. Heard the petition of counsel and also the counsel appearing for the respondent. This revision petition is filed. against the conviction order passed under section 138 of Negotiable Instrument Act against the revision petitioner. With regard to the issuance of check in exhibit P1 to P4, which have been bounced with the reason account is closed. The legal notice issued and no reply was given, and hence complaint was filed and complainant was examined as PW1 and also examined one witness as PW2. On the other hand, accused is examined as DW1 and his brother is also examined as DW2. The other two witnesses are DW3 and 4. The complainant relies upon document exhibit P1 to 30. On the other hand, defendant relies upon document exhibit D1 to D4. The trial court, having considered the material on record, in view of admission on the part of DW1 for issuance of check, and also considering both oral and documentary evidence available on record, convicted the accused. Being agreed by the said judgment, an appeal is filed before the appellate court. And appellate court also taking into note of the document exhibit P13 as well as exhibit P1 to 4, which have been admitted by the DW1 in the evidence. Also taking into the note of evidence of DW1 and 2, who are the brothers. There is no reference to exhibit P13. And comes to the conclusion that the evidence of DW1 and 2 throw the burden on each other in their effort to thwart the liability. On appreciation, comes to the conclusion that when there was a transaction between the same and admitted and issuance of check, and also the business of Arakanet is admitted, confirmed the judgment of the trial court. Being agreed by the conviction and confirmation, the present appeal is filed. The counsel appearing for the revision petitioner brought to notice of this court that the material available on the record clearly discloses that it is only a financial transaction with the brother of the accused, not with the brother, not with the accused. The counsel also vehemently contend that checks are presented twice, even after the check was returned with an endorsement account is closed. The counsel in support of his argument also relied upon the judgment reported in the ALR 2007, Karnataka 2706 and brought to notice of this court. Paragraph number 4 of the judgment. And once the check was returned with an endorsement closure of the account and there was no need to present the same, and the same is only with an intention to avoid the limitation. The counsel also brought to notice of this court that exhibit P13, which was confronted to the DW1 in the cross-examination, it discloses that transaction was taken place in 2006 and not in 2007 as contended by PW1 and 2. The counsel also would submit that the PW2 who says the payment was made twice as 1 lakh and also 65,000 and subsequently on different date. But the averment made in the complaint and also in the evidence is contrary, that payment was made at a time. The counsel also vehemently contend that the claim made by the respondent is not a legally recoverable debt and material on record, particularly the contradictions with regard to the transaction itself is concerned and the same is doubtful. Both the court ought not to have invoked the presumption as well as not considered the rebuttal evidence available on record, and hence it requires interference. For contra, the counsel appearing for the respondent would vehemently contend that the very issuance of check is not disputed. The DW1 categorically admits that signature bears on the exhibit P1 to 4 or belongs to him, and also he was having the account in particular bank. The counsel also would submit that evidence of DW1 and 2, it's very clear that both of them are doing business of Arakanet And though DW1 denies that he was not doing any business, but in the cross-examination, DW2 categorically admits that both of them are doing business. The council also would submit that the DW1 and DW2 have not denied the document of exhibit P13. The DW1 himself has admitted the very execution of document exhibit P13. And the same also substantiate with regard to the transaction between the parties. And both the trial court as well as the first appellate court having taken note of the material available on record, particularly the business of Parakanet. And also, though says that he used to give checks in favor of his brother to his business. Now cannot contend that checks are not given in respect of legally recoverable debt, and hence the very contention of revision petitioner counsel cannot be accepted. The counsel, in support of his argument, he relied upon the judgment of this court passed in this court reported in 2019 SEC online Karnataka 3557, and also counsel brought to notice of this court paragraph number 4, wherein also similar circumstances of closure of account and presentation of the same once again, and also given finding in paragraph number 11 and 12. The council also relies upon the judgment of the apex court reported in 1999 within bracket 2 Supreme Court cases 452 with regard to the scope of revisional jurisdiction. The apex court held that the revisional court scope cannot be equated with appellate jurisdiction. Reappreciation of evidence is not permissible unless it has resulted in gross miscarriage of justice. On facts, High Court exceeded its jurisdiction in interfering with the conviction by reappreciating the evidence and by not examining several items of evidence relied upon by session judge in confirming the conviction. In reply to the arguments of the respondent counsel, the revision petitioner counsel submits that when the document was confronted to the DW1 in the cross-examination of DW1 and question of stating a question of cross-examining the witness PW1 and 2 with regard to the document of exhibit P13 doesn't arise. The counsel also vehemently contend that in a case of Shivanand Gurupad Ayyappa Hiremat versus Anil, factual aspect is different. And this court has taken note of in paragraph number 12, specific pleading was made that accused has requested him to represent the check. But not in this case. In this case, the counsel would contend that the very first presentation was suppressed and filed the complaint. Having heard the petitioner counsel and also the counsel appearing for the respondent, whether this court can exercise the revisional powers and whether the order impugned suffers any legality and its correctness. Having heard the petitioner counsel and also the counsel appearing for the respondent, and no dispute with regard to the scope of the revision is concerned, and Supreme Court also in the judgment referred supra by the respondent counsel contend that revisional jurisdiction of High Court cannot be equated with appellate jurisdiction. And while reappreciation of evidence is also not, and reappreciation of evidence not permissible, unless it has resulted in gross miscarriage of justice. In view of the principles laid down in the judgment also, and also it is settled law also, the revisional scope is very limited and only to look into the order impugned, whether suffers from its legality and its correctness. In the case on hand, when the claim complainant makes the claim based on exhibit P1 to 4, that is checks which have been issued by the accused, and also when the same was presented, check account was closed and hence legal notice was issued. admittedly, no reply was given to the notice issued by the complainant. And only defense was taken in the written state and in the cross examination of PW1 that only transaction between the brother of the accused. No doubt it is emerged in the evidence also that the brother of the DW1 was in the reconnect business. And though DW1 contend that he was not doing any business, but in the cross examination of DW2, who is the brother, has been examined before the trial court, he categorically admits that his brother was also doing business along with him, that is reconnect business. And when such being the case, when such admission is given by the DW2, and admittedly checks are issued by the DW1, and the same are in favor of the complainant. And hence it is clear that both DW1 and DW2 are doing business, and in that business connection only the transaction was taken place. And hence the very contention of the revision petitioner that financial transaction only with the brother cannot be accepted. However, other contention of the revision petitioner counsel that check was presented twice. And this court also in the judgment referred Supra also made an observation that any number of times check can be presented. And the very contention of the counsel appearing for the revision petitioner relying upon the judgment reported in the ILR 2007 Karnataka 2706, wherein this court also observed with regard to the return of check as account closed and successive presentation, and an observation is made that makes no sense because the account itself is not in existence and there is no possibility of having a fruitful result by successive presentation, unlike in the case of insufficiency of funds. No doubt, this court has held that closure of account which will not lead to presentation of the check. But when the check was presented once again in the month of July, and the same was returned with an endorsement account is closed. And rightly pointed out by the petitioner counsel that with regard to the earlier presentation is concerned. Complaint only first.
No, my lords. It is only on the second.
First presentation is not stated. But in the cross examination, it is categorically admitted that first time it was presented, at that time also it was closed. And subsequently, when the presentation was made, the same was closed. But when the notice was issued to the petitioner and he has not given any reply to the said notice, in spite of the same is admitted, the other defenses and the defenses are taken only during the course of cross examination of witnesses. It is also important to note that in the cross examination of PW1, he categorically says that amount was obtained for the business of Recanet in the year 2007 in the month of January, and subject matter of checks are issued. And the same is stated in the chief evidence itself. And also, no doubt, PW1 also admits that he does the business with the brother of the complainant. And he used to sell Recanet 4 times. He also categorically says in this evidence that his brother is in need of money and he came to his house. And he gave the money to his brother. And also he further says that he does the business along with him and also the complainant. Subsequently, It is also his evidence that he gave the money prior to 4 days of issuance of the check. And he came and took the money in his house, and also he gave the 4 checks on the same day. And he had collected the checks in the office of Gopala Pujari. And I do not find any discrepancy in with regard to the making of payment is concerned. And he categorically says PW1 that he came to his house and demanded money for his brother, and he gave the money in his house. And no doubt it is stated that the amount was given in the month of January. But the counsel appearing with the revision petitioner content that PW2 says that first time the amount was given 1 lakh and the second time amount was given 65,000. But the evidence of PW1 is very clear that after giving the money, that is after 4 days, before issuance of the check, he gave the money 4 days earlier to that. And nothing is illustrated from the mouth of PW1 with regard to the different payment. And also in the further cross examination, answer illustrated with regard to the presentation of check twice, that is on 10/5/2007 and 3/7/2007. In the cross examination of PW2 also, speaks with regard to the payment made on different dates. In the cross examination of PW2, he says that he is not aware of the date of payment of rupees 1 lakh. And he categorically says that except the said 2 transaction, he is not aware of any other transaction between the accused and PW1. On the other hand, the DW1 though says that he is having acquaintance with the complainant. And he categorically says that the transaction was taken place between his brother and complainant. That is also for a period from 2002 to 2008. And also he categorically says that in 2007 he was very much present when the Arecca transaction was taken place. And also he categorically says that his brother has given the receipt in connection with Arecca transaction. And also he categorically says that his brother has given the check to the complainant. And also those checks are given as security in favor of the complainant by his brother. And at that time, Mahabala Pujari and Yashodhara Pujari both were present. And this evidence is in the chief evidence of the DW1. He categorically admits the transaction and issuance of check and handing over the check. But also content that the amount was repaid, but checks were not returned. But no any actions were taken. When such admission was given for having the transaction between his brother and also the complainant, and also categorically admitted that the complainant made several transactions in the said shop, and hence it is very clear that the said shop belongs to both of them, not exclusively belongs to his brother. But only he says that the said shop is standing in his name of his brother. That answer is illustrated in the cross examination of DW1. But he claims that he will not, he doesn't participate in the said transaction. And all payment, everything, his brother taking care of it. And also he categorically says that he gave 15 checks to his brother and he cannot say to whom his brother has given those checks. When such admission is given that he gave the checks to his brother and his brother has utilized his checks for his business. Now he cannot contend that there are no transaction between him. It is important to note that DW2 also in the cross examination categorically admits that who is none other than the brother of DW1 admits that in the 4 checks, they have mentioned the amount and given the check in favor of the complainant. But he says that when he gave the check, his brother was not there in his house. And also he categorically admits that those checks belongs to his brother only. And in the further cross examination, he categorically admits that his brother is also doing Arakanat business along with him. And when such admission is given, it is very clear that both of them are doing Arakanat business and checks are given. And these are the admissions illustrated from the mouth of DW1 and DW2 takes away the case of the petitioner. And the very contention that the checks are not given in favor of any legal liability cannot be accepted. The transaction is admitted and issuance of check is admitted, and also both of them are doing business together is also admitted. And now cannot contend that only financial transaction between the brother and the complainant. No doubt the checks are presented twice and the endorsement was given, account was closed. And the said endorsement was issued subsequently in the month of July, and check and complaint is filed within the limitation period. And the very contention that the second presentation is made only in order to avoid the limitation cannot be accepted. I have already pointed out that apex court categorically held that any number of times can be presented, and last presentation is the cause of action for filing of complaint. And hence mere closure of account and presentation of second time the check cannot be a ground when there is a clear ample evidence available before the court admitting the transaction, even considering document exhibit P13 also, and the same is also 2006. And the transaction between the parties is categorically admitted, and the same is also evident from the evidence of DW1 and DW2, and both of them have admitted the transaction, issuance of check, and also the transaction of Arakanat, and both of them doing business. And DW1 also categorically says that the shop license stands in name of his brother, but when the transaction was made, both of them and doing business together. And also it is the evidence of DW1, it's clear that the accused only came to his house and requested money for the Areka business and for his brother. And when such material available on record, I do not find any error committed by the trial court and also the first appellate court in appreciation of evidence available on record. There is no any miscarriage of justice in the case on hand for appreciating of evidence available on record. And also the judgment of the apex court is very clear that if any miscarriage of justice, that is ignoring of any evidence available on record, and if any finding is given contrary to the material evidence available on record, and only on that such circumstances, only court can exercise the revisional jurisdiction. And both the orders not suffers from any legality and its correctness. And hence, I do not find any force in the contention of the revision petitioner counsel to reverse the finding of trial court as well as the first appellate court by exercising the revisional jurisdiction. In view of the discussions made above, I pass the following order. Revision petition is dismissed. Please. ಬರೀ ಡೇಟ್ ಮಾತ್ರ ಅಲ್ಲ, ರಿಲೀಸ್ ಮಾಡ್ಬೋದು, ರಿಲೀಸ್ ಮಾಡೋಕೆ ಏನು ತೊಂದರೆ. ಎಷ್ಟು ಅವಾಯ್ಡ್ ರಿಪೋರ್ಟ್ ಅಂತ ಅಲ್ಲ, ಅವಾಯ್ಡ್ ರಿಪೋರ್ಟ್ ಈಗ ಬೇಡ. ಈಗ ಸದ್ಯಕ್ಕೆ ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 11/3 ಅಂತ ಇದೆಯಲ್ಲ, ನೋಡೋಣ ಯಾವ ಸ್ಟೇಜ್ ಅಂದ್ರೆ ಫರ್ದರ್ ಫೈನಲ್ ಇಯರಿಂಗ್ಗೆ ಬರ್ಬೇಕು. ಫೈನಲ್ ಇಯರಿಂಗಲ್ಲೇ ಬರ್ಬೇಕು.
Petitioning for respondent manual. Settlement ಗೆ ಮಾತಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿ.
Settlement, my lord, they are asking for the full amount, my lord, but.
Settlement?
my client is-
ನೀವು ಮಾತಾಡ್ತಾ ಇರೋದು
ಅವ್ರು
ಹೇಳಿ ಏನ.
And now there are two checks, my lord, for one is for 1,75,000, one is for 75,000. My client has deposited 50% of the amount.
ಈಗ ಎಷ್ಟಿದೆ ಬ್ಯಾಲೆನ್ಸ್ ಎಷ್ಟಿದೆ?
1,25,000. And.
ಎರಡು 75,000 75,000
ಅಲ್ಲ, ಒಂದು 175.
ಒಂದು
1,75,000.
ಅಲ್ಲಿ 2.5 ಲಕ್ಷ.
ಹೌದು.
ಹಾ
1,25,000.
50% ಡೆಪಾಸಿಟ್ ಆಗಿದೆ.
Yes. And I am.
ಚೆಕ್ ಅಮೌಂಟ್ ಎಷ್ಟು?
Check amount is 2.5 lakhs total.
2.5.
2.5.
ಅದೇ ಅಷ್ಟೇ ಅಮೌಂಟ್ ಗೆ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ, ಅದಕ್ಕೆ ಆಗ್ದಲ್ಲ ಸಮೀರ್, because there is the petitioner.
ಅಷ್ಟೇ ಅಮೌಂಟ್ ಗೆ ಮಾಡಿದ್ದಾರೆ ಅಂದೆ, ಜಾಸ್ತಿ ಏನ್ ಮಾಡಿಲ್ಲ.
ಜಾಸ್ತಿ
ಡಬಲ್ ದಿ
ಮಾಡಿಲ್ಲ.
ಚೆಕ್ ಅಮೌಂಟ್ ಆತರ ಏನ್ ಮಾಡಿಲ್ಲ.
The checks were obtained from in the police station, sir, by force.
Not by force, my lord.
ಈ ಭಯ ಮೇಲೆ ಏನಾದ್ರು.
ಅಲ್ಲ ಬೇಡ, ನೀವೇನಾದ್ರು ಮಾತನಾಡಿ ಏನೋ ಸೆಟ್ಲ್ಮೆಂಟ್ ಮಾಡಿಸ್ತೀರಾ ನೋಡಿ.
ಸರಿ ಸ್ವಾಮಿ.
ನಮ್ಗೆ ಗೊತ್ತಿರಲಿಲ್ಲ.
ಅಂತ ಹೇಳಿ
ಚೆಕ್ ಬೌನ್ಸ್ ಕೇಸ್ ಇದೆಯಲ್ಲ,
ಅದು ಅವ್ರಿಗೆ ಗೊತ್ತಿಲ್ಲ.
ಒಂಥರ ಮಾಫಿಯಾ. 10,000 ಕೊಟ್ಬಿಟ್ಟು 10 ಲಕ್ಷ ಬರ್ಕೋತಾರ ಆತರ. ನನ್ ರಿಲೇಟಿವ್ ಒಂದ್ ಹೇಳ್ತೀನಿ, ಕೊಟ್ಟಿದ್ 10,000 3.5 ಲಕ್ಷಕ್ಕೆ ಹಾಕಿದ್ದ, ಕೊನೆಗೆ 30,000 ಸೆಟ್ಲ್ ಆಯ್ತು.
ಸೀನಿಯರ್ ಹತ್ರ ಮಾತಾಡ್ತೀನಿ.
ಲಾಂಗ್ ಬ್ಯಾಕ್ ಈ ತರದ್ ಇರುತ್ತೆ. ಅದಕ್ಕೆ ನೋಡಿ, ನಮ್ಗೂ ಏನ್ ದಿವ್ಯ ದೃಷ್ಟಿ ಇಲ್ಲ. ನಿಮ್ಮ ಆತ್ಮಸಾಕ್ಷಿ, ಅವ್ರ ಆತ್ಮಸಾಕ್ಷಿ. ಅವನ್ ಎಷ್ಟ್ ತಗೊಂಡ, ನೀವೆಷ್ಟ್ ಕೊಟ್ರಿ, ನಿಮ್ಮಿಬ್ರಿಗೆ ಗೊತ್ತಿರುತ್ತೆ. ನೀವಿಬ್ರೇ ಕೂತ್ ಮಾತಾಡುದು. ಅದಕ್ಕೆ ಹೇಳಿದ್ ಮಾಫಿಯಾ ಅಂತ. ಇದು ಚೆಕ್ ಕೊಟ್ಬಿಟ್ರೆ ಅವ್ನ್ ಬೇಕಾದ್ ಬರ್ಕೋತಾನ. ಅವ್ನು ಒಂದ್ ರೀಸನ್ ಏನಿರುತ್ತೆ, ಜಾಸ್ತಿ ಯಾಕೆ ಬರ್ಕೊಳ್ಳೋದು ಅಂದ್ರೆ, ಜಾಸ್ತಿ ಬರ್ಕೊಂಡ್ರೆ ಬರ್ತಾನೆ ಸೆಟ್ಲ್ಮೆಂಟ್ಗೆ ಅನ್ನೋ ಒಂದ್ ದೃಷ್ಟಿ ಬರ್ಕೊಂಡಿರ್ತಾರೆ. ಅದೇ ಹೇಳಿದ್ನಲ್ಲ ಈಗ ಎಕ್ಸಾಂಪಲ್, 3.5 ಲಕ್ಷಕ್ಕೆ ಬರ್ಕೊಂಡು 30,000 ಕಾಂಪ್ರಮೈಸ್ ಹಂಗೆ ಆ ತರದ್ ಇರುತ್ತೆ. ನೋಡ್ಕೋಬೇಕು ನೀವು ನೋಡಿ ಏನಂತ. ನಿಮಗ್ ಗೊತ್ತು ನೀವ್ ಎಷ್ಟ್ ಕೊಟ್ಟಿದ್ದೀರಿ ಅಂತ, ಅವ್ರಿಗೆ ಗೊತ್ತು ಎಷ್ಟು ತಗೊಂಡಿದ್ದೀನಿ.
ಆಫೀಸಲ್ಲಿ ಇರೋ ಸ್ಟಾಕ್ ನ ಮತ್ತೆ ಫರ್ನಿಚರ್ಸ್ ನ ಅವ್ರು ಎತ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಅಲ್ಲ ಆಯ್ತು,
ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಾಗ ಅವರು ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಬಂದು 2 ಚೆಕ್ ಇಶ್ಯೂ ಮಾಡ್ತಾರೆ ಅವರು.
ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಅಲ್ಲಿ ಬಲಾತ್ಕಾರ.
ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಅಲ್ಲೇ ಕೊಡ್ಲಿ, ಬಟ್ ನೀವು ಸುಮ್ನೆ ಕೊಡ್ತೀರಾ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಅಲ್ಲಿ?
ಎದುರಿಸ್ಬಿಟ್ಟು ಅವ್ರ ಮನೆಯಿಂದ ಹೋಗಿ ಪೊಲೀಸ್ ಅವರೇ ಚೆಕ್ ತಂದಿದ್ದಾರೆ. ನಮ್ಮ ಕ್ಲೈಂಟ್ ಇದ್ ಮನೆಗೆ ಪೊಲೀಸ್ ಅವರು ಹೋಗ್ಬಿಟ್ಟು ಪೊಲೀಸ್ ಅವರು ಮನೆಯಿಂದ ಚೆಕ್ಸ್ ತಂದ್ಬಿಟ್ಟು ಸೈನ್ ಮಾಡಿ.
ಆಯ್ತು, ನಿಮ್ಮ ಪ್ರಕಾರ ನೀವು ಎಷ್ಟು ಕೊಡ್ಬೇಕಿತ್ತು?
ಅಲ್ಲ, ನನ್ನ ಲೆಕ್ಕ ಪ್ರಕಾರ 1,25,000.
ಅಷ್ಟೇನಾ?
ಹೌದು.
ಅವ್ರು ಕೇಳಿ ನೋಡಿ ಏನು.
ಆಯ್ತು,
ಇಬ್ರು ಮಾತನಾಡಿ ನೋಡಿ, ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಹೇಳಿ. ನಿಮ್ಮವ್ರು ಕೇಳಿ ನೋಡ್ರಿ.
ಕೇಳ್ತೀವಿ.
ಕಾನೂನು ಒಂದೇ ನಾವು ನೋಡಕ್ಕಲ್ಲ, ಧರ್ಮನೂ ಇರುತ್ತೆ.
ಈಗ
ಕಾನೂನು ಧರ್ಮ ಎರಡೂ ಇರ್ಬೇಕು.
ಹೇಳ್ತೀನಿ
ಎರಡೂ ನೋಡಿ. ಧರ್ಮ ಯಾವಾಗ ಬರುತ್ತೆ ಅಂದ್ರೆ ನಿಮ್ಮ ಆತ್ಮಸಾಕ್ಷಿ. ಅವ್ನ ಎಷ್ಟು ಕೊಡ್ಬೇಕು ಅನ್ನೋದು ನಿಮ್ಮ ಆತ್ಮಸಾಕ್ಷಿ. ಆತ್ಮಸಾಕ್ಷಿ ಬಿಟ್ಟು ಬೇರೆ ಇಲ್ಲ. ಯಾಕೆ ಗಾಂಧಿನ ಒಂದ್ ಹೇಳ್ತಾರೆ ಮಾತಲ್ಲಿ, ಎಲ್ಲ ನ್ಯಾಯಾಲಯಗಳಿಗಿಂತ ಒಂದು ಶ್ರೇಷ್ಠವಾದ ಒಂದು ನ್ಯಾಯಾಲಯ ಇದೆ ಅಂತ. ಅದು ಯಾವ್ದು ಅಂದ್ರೆ ಆತ್ಮಸಾಕ್ಷಿ. ಆತ್ಮಸಾಕ್ಷಿ ನೀವ್ ಹೇಳ್ಬೇಕು, ನೀವಿಬ್ರು ನಿಮ್ಮ ಪ್ರಕಾರ ನೀವೆಷ್ಟು ತಗೊಂಡಿದ್ದೀರಿ, ಅವ್ರ ಪ್ರಕಾರ ಅವ್ರು ಎಷ್ಟು ಕೊಟ್ಟಿದೀವಿ ಅಂತ ಅಷ್ಟೇ. ಯಾವಾಗ ಎಷ್ಟು ದಿವಸ ಬೇಕು ಹೇಳಿ? ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಯಾವತ್ತು ಮಾತನಾಡ್ತೀರಾ? ಬರೀ ಇವತ್ ಮಾತ್ರ ಡೇಟ್ ತಗೊಂಡ್ ಮತ್ ನಾಡಿದ್ದು ಬರೋದಿಲ್ಲ. ಏನಾದ್ರು ಪ್ರೋಗ್ರೆಸ್ ಮಾಡಂಗಿದ್ರೆ ಬನ್ನಿ, ಇಲ್ದವ್ರು ಇಲ್ಲ.
19th
ನೆಕ್ಸ್ಟ್ ವೀಕ್ 19th ಬೇಕಾ? 19th ಮೋಸ್ಟ್ಲಿ RS ಇದೆ. 20th ಆಯ್ತು. Both counsel submits that, both counsel petitioner counsel submits that there is an element of settlement. ಎರಡು ಮ್ಯಾಟರ್ ಇದೆಲ್ಲ.
ಹೌದು.
And counsel for the respondent is also present. You talk to your client also.
Yes ma'am, please.
ಅವ್ರಿಗೆ ಹೇಳಿ, ರೀಕನ್ಸಿಡರ್ ಮಾಡಂಗಿದ್ರೆ ಏನಾರು ಆ ತರದಿಲ್ಲ ಅಂದ್ರೆ ಕನ್ಸಿಡರ್ ಮಾಡಿ. This matter on 23.
Much obliged.
ಏನ್ರಿ ಪ್ರಸಾದ್? ಹರೀಶ್ ಕುಮಾರ್ MS ಇದಾರ?
ಎರಡು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ 734. ಎರಡು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಸೇಮ್.
ಇನ್ನೂ ಒಂದಿದೆಯಾ?
ಇನ್ನು ಎರಡಿದೆ, ಅದೆರಡು ಲೋಕ ಅದಾಲತ್ಗೆ ರೆಫರ್ ಆಗುತ್ತೆ.
ಲೋಕ ಅದಾಲತ್ತಲ್ಲಿ
ರೆಫರ್ ಆಗುತ್ತೆ 9th
ಗೆ. ಇದನ್ನು ಕಳ್ಸೋಣ. ಸೇಮ್ ಪಾರ್ಟಿನ?
ಸೇಮ್ ಪಾರ್ಟಿ
ಸೇಮ್.
ಪಾರ್ಟಿ ಸೇಮ್. ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಆಲ್ಸೋ ಸೇಮ್.
The different type, sorry, time.
ಹಾಗಾದ್ರೆ ಇನ್ನು ಕಳ್ಸ್ಬಿಡೋಣ.
Please.
Third, Revision Petitioner Council submit that already two matters are referred to the Lok Adalat. And this matter also can be referred to the Lok Adalat. But respondent ಅವರೇ ಸೇಮ್
Same.
ಅವೆರಡು ಕೇಸಲ್ಲಿ
ಎರಡರಲ್ಲೂ same.
ಯಾಕೆಂದ್ರೆ ಅವ್ರು
ಅಲ್ಲ,
ಬರ್ಬೇಕು
ನಾಲ್ಕು
ಅವತ್ತು.
ಒಟ್ಟಿಗೆ
ಹಾ ಸರಿ. And hence list this matter also before the Lok Adalat on date ಯಾವತ್ತು
19th
Lok
postpone
Adalat?
ಆಗಿದೆ, 16th
ಅಲ್ಲ 16/3. H. Maltesh. Cyril Prasad Payas. ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್ ಈಗ ಪಿಟಿಷನರ್ ಕೌನ್ಸಿಲ್ ಇಲ್ವಾ?
ಇಲ್ಲ.
ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ ಮೇಡಮ್. Await police report in respect of court notice issued to the petitioner ಅಂತ ಆಯ್ತು. ಏನ್ ಮೇಡಮ್? 27/2/73.
The respondent was, appellant was absent, so therefore, my lord, the
ಏನಾಗಿದೆ ಈಗ ಅದು?
notice was issued.
ನೋಟಿಸ್ ಏನಾಯ್ತು? ಅವೈಟ್ ಇದ್ದಿದ್ದು ಏನಾಗಿದೆ ಮೇಡಮ್? ಅವೈಟ್ ಪೊಲೀಸ್ ರಿಪೋರ್ಟ್ ಇವತ್ತೇನು ತೋರ್ಸೇ ಇಲ್ವಲ್ಲ ಅದು? ಏನಾಯ್ತು ಪೊಲೀಸ್ ರಿಪೋರ್ಟ್? ಖುದ್ದಾಗಿ ಜಾರಿ ಮಾಡಿರುತ್ತೇನೆ. ಸಿಗ್ನೇಚರ್ ಅದು ಎಸ್ ಅವನ್ ಸಿಗ್ನೇಚರ್ ಇದೆ ಸೈನ್ ಇಲ್ಲಿದೆ. This court has issued notice against the petitioner in view of the revision petition is not pursued by the petitioner diligently. And notice also served on the petitioner, and in spite of it, he is not pursuing the matter diligently. In view of the same, the order passed by this court suspending the sentence dated 21/9/2017 is vacated. You can proceed with the case, that's all, before the trial court.
Serial number 41.
42.
41.
41 ಈಗ ಆಗಿದ್ದು. H. ಮಾಲ್ತೇಶ್. ನಿಮ್ಗೆ ಏನ್ ಸ್ಟೇ ಕೊಟ್ಟಿದ್ವಿ ಅದು ವೆಕೇಟ್ ಮಾಡಿದೀನಿ. ಯಾಕೆಂದ್ರೆ ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡಿದ್ವಿ, ನೀವು ಬರ್ಲಿಲ್ಲ. ಪಿಟಿಷನರ್ಗೆ ಕೋರ್ಟ್ನವರು ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ, ಅವನಿಗೂ ಸರ್ವ್ ಆಗಿದೆ. ಅವನು ಬರಲ್ಲ, ನೀವು ಬರಲ್ಲ, ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? ಸೆಂಟೆನ್ಸ್ ಸಸ್ಪೆಂಡೆಡ್, ವೆಕೇಟೆಡ್, ದಟ್ಸ್ ಆಲ್. ರಿವಿಷನ್ ಪಿಟಿಷನ್ ಏನ್ ಮಾಡಕ್ಕಲ್ಲ. ಚೆಕ್ ಬೌನ್ಸ್ ಕೇಸ್ಗಳೆಲ್ಲ ಲಕ್ಷಾಂತರಗಳ ಕೇಸ್ ಇದೆ. ನೋ ಅಮಿಕಸ್ ಕ್ಯೂರಿ, ನಥಿಂಗ್. ವೆಕೇಟ್ ಆಗಿದ್ದು ಅವ್ರು ಫರ್ದರ್ ಪ್ರೊಸೀಡ್ ಆಗ್ಲಿ ಅಷ್ಟೇ, ದಟ್ಸ್ ಆಲ್. ಎಮ್ಮಿ ಹಿರೇಮಠ್.
42 appearing for the appellant. Appearing for the petitioner. Amicus curiae.
ಏನ್ ಮ್ಯಾಟರ್ ಅನ್ನ?
Offence is under section 279.
ನೀವು ಅಮಿಕಸ್ ಕ್ಯೂರಿನಾ?
Please, my lord.
ಅಮಿಕಸ್ ಕ್ಯೂರಿ.
Offence is under section 279, 338 and 304A, my lord, sir. Action negligent revenue.
ಎಲ್ಲದಕ್ಕೂ ಕನ್ವಿಕ್ಷನ್ ಮಾಡಿದಾರಾ?
Please, my lord, 6 months, no, my lord, only 279, 800 rupees penalty, my lords. And only sentence has been passed on section 304, my lords, of A for 6 months, my lords, which has been confirmed by the session court, my lords. There are 7 witnesses.
279 ಇದೆಯಲ್ರಿ?
Please, my lord,
378
338.
1 month.
ಹೌದು.
ಫೈನ್ 800.
Default, please, my lord.
279 800 1 month.
1 month.
ಅಲ್ವಾ?
Please, my lord. And 304A, 6 months.
6 months ಅದ್ ಮಿನಿಮಮ್. ಮಿನಿಮಮ್ 6 months 304 ಏನಲ್ಲಿ
Confirmed by the. district court.
ಏನಿದೆ ಗ್ರೌಂಡ್ ಏನಿದೆ ಏನಾದ್ರು ಇದೆಯಾ?
That's only there are two eyewitnesses, my lord.
ಹಾ
PW2 and PW6, my lord.
ಹ್ಮ್
PW2 is the pillion rider of the deceased person, my lord.
ಓ ಪಿಲಿಯನ್ ರೈಡರ್
Pillion rider.
PW2
Please not. And even PW5, my lord, is the pillion rider of the accused, my lord.
accused vehicle.
Please, my lord.
ಹಾ
He has stated that it has been caused due to the rash and negligent driving of the victim vehicle, my lord.
ವಿಕ್ಟಿಮ್ ವೆಹಿಕಲ್ ಅಂತ.
Please, my lord. PW5 has.
ಅವನ್ ಅವ್ರ ಪರವಾಗಿ ಹೇಳ್ತಾನೆ ಇವನ್
Please.
ಪರವಾಗಿ ಹೇಳ್ತಾನೆ.
Please, my lord.
ಹಾ ಕೊಡಿ ಎವಿಡೆನ್ಸ್ ಕೊಡಿ ನೋಡೋಣ. ಬಟ್ ಗ್ರೌಂಡ್ ಏನು ನಿಮಗೆ ರಿವಿಷನ್ ಗ್ರೌಂಡ್ ಏನು ಇಂಟರ್ಫಿಯರ್ ಮಾಡಕ್ಕೆ? ಯು ಹ್ಯಾವ್ ಟು ಅಸಿಸ್ಟ್ ಕೌನ್ಸಿಲ್.
Please, my lord.
ಮತ್ತೆ 5,000 ಕೊಡ್ತೀವಿ ನಿಮ್ಗೆ ಅಮಿಕಸ್ ಕ್ಯೂರಿಗೆ.
Please, my lord.
ಮತ್ತೆ 5,000
PW
ನೀವು ಕೆಲಸ ಮಾಡ್ಬೇಕಲ್ಲ.
PW2, my lord.
ಹಾ PW2 ಈಗ ಐ ವಿಟ್ನೆಸಸ್ ಯಾರು?
PW2, 6 and 5, my lord.
2, 6 and 5.
5, my lord.
4 also.
4 also. PW4 ಸಪೋರ್ಟ್ ಮಾಡಿಲ್ರಿ?
ಮಾಡಿದ್ದಾರೆ.
PW4 ಇಲ್ಲ, ಈಗಾಗಲೇ ಗುರುಸಲಾಗಿದೆ. 9C ನನ್ನ ಸಹಿ ಇರುತ್ತದೆ. ಪೊಲೀಸರು ಅಪಘಾತದ ಸ್ಥಳದಲ್ಲಿ ಮಾಜರ್ ಮಾಡಿರ್ತಾರೆ. ಆ ಸಂದರ್ಭದಲ್ಲಿ ಮಂಜಪ್ಪ ಕೂಡ ನನ್ನೊಂದಿಗೆ ಇದ್ದರು. ಮಾಜರ್ ವಿಟ್ನೆಸ್
ಹೌದು.
ಮತ್ತೆ ಐ ವಿಟ್ನೆಸ್ ಅಲ್ಲ.
PW4 ಹೌದು. 3 and 4 major witness, correct.
ಮಾಜರ್ ವಿಟ್ನೆಸ್.
Major witness.
1 and 2
My lord, one is the my lord brother of the complainant. He is the brother of the deceased.
But he was not at.
He was not brother of the.
PW2
PW2 he is eyewitness, my lord.
2 ಐ ವಿಟ್ನೆಸ್.
Eyewitness.
ಈ ತಿಂಗಳ ಹಿಂದೆ ನಾನು ಗಾಡಿಯಲ್ಲಿ ಹೋಗುತ್ತಿದ್ದಾಗ 24 ಊರಿಗೆ ಹೊನ್ನಾಳಿಯಿಂದ ಮನುಸಾರ್ಗೆ ಹೋಗುತ್ತಿದ್ದಾಗ ಅಣ್ಣಪ್ಪ ಕೂಡ ಬೇರೊಂದು ಬೈಕ್ ನಲ್ಲಿ ನಮ್ಮ ಮುಂದೆ ಹೊರಟಿದ್ದರು. ನನಗೂ ಅಣ್ಣಪ್ಪನ ಬೈಕಿಗೂ ಸುಮಾರು 20 ಅಡಿ ಅಂತರ ಇತ್ತು. ಅಣ್ಣಪ್ಪ ರಸ್ತೆ ಎಡಭಾಗದಲ್ಲಿ ಹೋಗುತ್ತಿದ್ದರು. ಎದುರಿನಿಂದ ಬಂದ ಆಟೋ ಬರುತ್ತಿತ್ತು. ಆರೋಪಿ ಕೂಡ ಒಂದು ಬೈಕ್ ನಲ್ಲಿ ನಮ್ಮ ಎದುರುಗಡೆಯಿಂದ ಬರುತ್ತಿದ್ದು ಆಟೋವನ್ನು ಓವರ್ಟೇಕ್ ಮಾಡಿಕೊಂಡು ಬಂದು ಅಣ್ಣಪ್ಪನ ಬೈಕಿಗೆ ಡಿಕ್ಕಿಪಡಿಸಿರುತ್ತಾರೆ. ಅಣ್ಣಪ್ಪ ಬೈಕಿನಿಂದ ಬಿದ್ದು ತಲೆಗೆ ಪೆಟ್ಟಾಗಿರುತ್ತದೆ. ಶಿವಗೂ ಕೂಡ ಗಾಯಗಳಾಗಿರುತ್ತವೆ. ನಂತರ ಅಣ್ಣಪ್ಪನನ್ನು ಹೊನ್ನಾಳಿ ಆಸ್ಪತ್ರೆಗೆ ಕರೆದುಕೊಂಡು ಬಂದೆವು. ನಂತರ ಶಿವಮೊಗ್ಗ ಆಸ್ಪತ್ರೆಗೆ ಕರೆದುಕೊಂಡು ಹೋದೆವು. ನಂತರ ಬೆಂಗಳೂರು ನಿಮಾನ್ಸ್ ಆಸ್ಪತ್ರೆಗೆ ಕರೆದುಕೊಂಡು ಹೋದೆವು. ನಾನು ಅವರು ಮೃತಪಟ್ಟರು ಎಂದು ಗೊತ್ತಾಯ್ತು.
ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್. ನಾನು ಮತ್ತು ನಾಗೇಶಪ್ಪ ಬೈಕಿನಲ್ಲಿ ಹೋಗುತ್ತಿದ್ದೆವು. ನಾನು ಗಾಡಿಯಲ್ಲಿ ಹಿಂಭಾಗದಲ್ಲಿ ಕುಳಿತಿದ್ದೇನೆ. ಕಾರಣ ನನಗೆ ಎದುರಿನಿಂದ ಬರುತ್ತಿದ್ದ ವಾಹನಗಳು ಕಾಣಿಸುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಾನು ಮತ್ತು ಅಣ್ಣಪ್ಪ ಬೈಕ್ 20 ಅಡಿ ಅಂತರವಿತ್ತು. ಎದುರಿನಿಂದ ಬರುತ್ತಿದ್ದು ಆಟೋ ನಂಬರ್ ಗೊತ್ತಿಲ್ಲ. ಅಣ್ಣಪ್ಪ ಬೈಕಿನ ನಂಬರ್ ಕೂಡ ಗೊತ್ತಿಲ್ಲ. ಅಣ್ಣಪ್ಪ ಬೈಕಿನಲ್ಲಿ ಒಬ್ಬರೇ ಹೋಗುತ್ತಿದ್ದರು. ಆರೋಪಿ ನಿಧಾನವಾಗಿ
ಕ್ಲಿಯರ್ ಆಗಿ ಹೇಳ್ತಾನಲ್ಲಿ, ಆರೋಪಿ ಆಟೋ ತಪ್ಪಿಸಲು ಹೋಗಿ ಅಣ್ಣಪ್ಪನ ಬೈಕಿಗೆ ಡಿಕ್ಕಿಪಡಿಸಿರುತ್ತಾರೆ. ಅಣ್ಣಪ್ಪನೇ ಆಟೋ ತಪ್ಪಿಸಲು ಆರೋಪಿ ಬೈಕಿಗೆ ಡಿಕ್ಕಿಪಡಿಸಿದ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಅಣ್ಣಪ್ಪನೇ ಆರೋಪಿ ಬೈಕನ್ನು ನಿಧಾನವಾಗಿ ಚಲಿಸಿದೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಅಪಘಾತ ಸುಳ್ಳು ಸಾಕ್ಷಿ ಹೇಳುತ್ತಿದೆ ಸರಿಯಲ್ಲ. ಏನು ಎಲ್ಲಿ ಸೀಟ ಮಾಡಿಸಿಲ್ಲ PW2 ನಲ್ಲಿ. ಅಟ್ಲೀಸ್ಟ್ ಏನಾರು ಇದ್ರೆ ಪರವಾಗಿಲ್ಲ. ನೆಕ್ಸ್ಟ್ PW5
PW5 and PW6.
PW5 pillion rider of the yes.
Pillion rider.
Pillion rider.
Pillion rider
accused.
Accused. ದಾಟಿ ಮುಂದೆ ಬರುವಾಗ ಎದುರು ಬರುತ್ತೆ ಬೈಕ್. ಆತ ನಿಯಂತ್ರಣ ತಪ್ಪಿ ನಮ್ಮ ಬೈಕಿಗೆ ಬಂದು ಡಿಕ್ಕಿಪಡಿಸಿರುತ್ತಾನೆ ಅಂತ ಅವನು ಹೇಳ್ತಾನೆ.
ಪ್ಲೀಸ್.
ಆರೋಪಿ ತಪ್ಪಿನಿಂದ ಅಪಘಾತವಾಗಿದ್ದು ಅಪಘಾತದಲ್ಲಿ ನನ್ನ ಸಾಮಾನ್ಯ ಸ್ವರೂಪದ ಗಾಯಗಳಿದ್ದಾವೆ ಎಂದು ಸರಿಯಲ್ಲ. ಇದೇ ವಿಷಯವಾಗಿ ನಾನು ಪೊಲೀಸರಿಗೆ ಓದಿ ಹೇಳಿದ ನಿಜ ನನ್ನೊಂದು ಹೇಳಿಕೆ ಕೊಟ್ಟಿದ್ದೇನೆ ಎಂದು ಸೂಚಿಸುವ ಸರಿಯಲ್ಲ. ಆರೋಪಿ ನನ್ನ ಗೆಳೆಯನಾಗಿದ್ದರಿಂದ ಆತನಿಗೆ ಸಹಾಯ ಮಾಡಲು ಸಾಕ್ಷಿ ಸುಳ್ಳು ಹೇಳುತ್ತಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನೆಕ್ಸ್ಟ್ ವಿಟ್ನೆಸ್ PW6 ಅಣ್ಣಪ್ಪ ಗೊತ್ತು, ಆರೋಪಿ ಕೂಡ ಗೊತ್ತು. ಅಣ್ಣಪ್ಪ ಬೈಕಪ್ಪ ಕಳೆದ ವರ್ಷ ಹೊಂದಿರುತ್ತಾನೆ. ನಾನು ಬೈಕನ್ನು ಓಡಿಸಿಕೊಂಡು ತಮ್ಮಿನ ಕಟ್ಟೆ ರಸ್ತೆ ನಾಗರಾಜನನ್ನು ಕೂಡಿಸಿಕೊಂಡು ಹೋಗುತ್ತಿದ್ದೆ. ಮತ್ತೊಂದು ಬೈಕಿನಲ್ಲಿ ಅಣ್ಣಪ್ಪ ನಮ್ಮ ಮುಂದೆ ಹೋಗುತ್ತಿದ್ದನು. ನನ್ನ ಬೈಕು ಮತ್ತು ಅಣ್ಣಪ್ಪನ ಬೈಕ್ಗೂ ಸುಮಾರು 10 ಮೀಟರ್ ಅಂತರ ಇತ್ತು. ಅಣ್ಣಪ್ಪ ರಸ್ತೆ ಎಡಭಾಗದಲ್ಲಿ ನಿಧಾನವಾಗಿ ಹೋಗುತ್ತಿದ್ದರು. ಹೊನ್ನಾಳಿಗಿಂದ ಮುಂಭಾಗದಲ್ಲಿ ಕಡೆಯಿಂದ ಬೈಕ್ ಮತ್ತೊಂದು ಬೈಕ್ ಅಣ್ಣಪ್ಪನ ಬೈಕ್ಗೆ ಡಿಕ್ಕಿಪಡಿಸಿರುತ್ತಾರೆ. ಎದುರುಗಡೆಯಿಂದ ಬರುತ್ತಿದ್ದ ಮೋಟಾರ್ ಸೈಕಲ್ ಸ್ವಲ್ಪ ವೇಗವಾಗಿ ಬರುತ್ತಿದ್ದು ಆಟೋ ಬರುತ್ತಿದ್ದು ಸದರಿ ಆಟೋವನ್ನು ಓವರ್ಟೇಕ್ ಮಾಡಿ ಬಂದಿದ್ದರಿಂದ ಅಪಘಾತವಾಗಿರುತ್ತದೆ. ಅಣ್ಣಪ್ಪನಿಗೆ ತೀವ್ರ ಸ್ವರೂಪದ ಗಾಯಗಳಾಗಿರುತ್ತವೆ. ಆತನನ್ನು ಆಸ್ಪತ್ರೆಗೆ ಕರೆದುಕೊಂಡು ಹೋದರೂ ಪುನಃ ಸೋನ್ಸೋ ಬೆಂಗಳೂರಿಗೆ ಕಳಿಸಿರುತ್ತೆ. ಸೊ ನೆಕ್ಸ್ಟ್ ಯಾವ ದಿನಾಂಕ, ತಿಂಗಳು, ವರ್ಷ ಅಪಘಾತ ಎಂದು ನಿಖರವಾಗಿ ಹೇಳಲಾಗುವುದಿಲ್ಲ. ಕುಂಬಾರಗುಂಡಿ ಹತ್ತಿರ ಒಂದು ತಿರುವು ಇದೆ ಎಂದರೆ ಸರಿ. ನಾನು ಮೋಟಾರ್ ಸೈಕಲ್ ಅನ್ನು 30 ಕಿಲೋಮೀಟರ್ ದೂರ ವೇಗದಲ್ಲಿ ಓಡಿಸುತ್ತಿದ್ದೆ. ಎದುರುಗಡೆಯಿಂದ ಬಂದ ಮೋಟಾರ್ ವೆಹಿಕಲ್ ವೇಗ ಹೇಳಲಾಗುವುದಿಲ್ಲ. ಅಪಘಾತ ಸ್ಥಳದಲ್ಲಿ ರಸ್ತೆಯ 7-8 ಅಡಿ ರಸ್ತೆ ಇರುತ್ತದೆ. ಅದರ ಮಿಕ್ಕೆಲಗಳಲ್ಲಿ 2 ಮೀಟರ್ನಷ್ಟು ಕಚ್ಚಾ ರಸ್ತೆ ಇರುತ್ತದೆ. ಆರೋಪಿ ಜಾಗರೂಕನಾಗಿ ತನ್ನ ಮೋಟಾರ್ ಸೈಕಲ್ ಚಲಾಯಿಸುತ್ತಿದ್ದ ಎಂದರೆ ಸರಿ. ತಂತೆ ಮುಗಿಸಿಕೊಂಡು ನಾನು ಮತ್ತು ಅಣ್ಣಪ್ಪ ಮಾತನಾಡಿಕೊಂಡು ಹೋಗುತ್ತಿದ್ದೆವು ಎಂದರೆ ಸರಿಯಲ್ಲ. ಅಣ್ಣಪ್ಪನ ತಪ್ಪಿನ ಅವರ ಎಂದು ಸರಿ. ಇದ್ ನೋಡಿ, ಮೋಟಾರ್ ವೆಹಿಕಲ್ಸ್ ಇದ್ರ ರಿಪೋರ್ಟ್ ಏನಿದೆ?
Exhibit P5.
ಇವನು ಎದರಿಂದ ಬಂದವನ? P5
P5.
ಎದರಿಂದ ಬಂದವನ ಅಂದೆ?
Motor.
Front wheel mudguard, left side indicator, headlight, front wheel along with rim damaged. Victim ಹೋಗ್ತಿದ್ ವೆಹಿಕಲ್ ಯಾವ್ದು?
ಇಬ್ರು ಬೈಕ್.
ಇಬ್ರದು ಬೈಕ್.
ಇಬ್ರದು ಬೈಕ್.
ಇಬ್ರದು ಹೀರೋ ಹೊಂಡಾನೆ. Front both side forks damaged, right side fuel front tank both. ಏನ್ ಇಲ್ವಲ್ರಿ? ರಿವಿಷನ್ ಅಲ್ಲಿ ಎಕ್ಸರ್ಸೈಸ್ ಮಾಡೋ ಪವರ್ಸ್ ಏನು ಇಲ್ಲ. In 313 also total denial.
Denial.
Incriminating evidence is very clear that when he tried to overtake the auto rickshaw,
Yes.
he came and dashed against the vehicle.
Vehicle.
ಅದೇ ಬರ್ತಾರೆ 313 ನಲ್ಲಿ he ought to have been explained how an accident was taken place and nothing.
Not explained.
Even not explained also. Third, heard the petitioner counsel and also the counsel appearing for the state. This revision petition is filed against the concurrent finding of trial court and also the first appellate court. The factual matrix of case of the prosecution that on 24/7/2013, the accused being the rider of the motorcycle bearing registration number KA 17EJ 601 drove it around 4:30 PM on the Vannalli Tuminakatte road from Tuminakatte towards Vannalli in a high speed, rash and negligent manner so as to endanger human life and personal safety of others. The CW 16 Vasant Naik was a pillion rider of the motorcycle ridden by the accused. When the motorcycle came near Sri Daba, the accused dashed another motorcycle bearing registration number K17EZ0076, which was coming from the opposite direction from Honali towards Tuminakatte. Due to the impact of the accident between two motor vehicles, both the motorcyclists fell down and sustained injuries. The rider of the motorcycle bearing registration number K17EZ0076, Mr. Annappa, sustained grievous injuries on head and hands and cheek. And CW 16 also sustained grievous injuries. Both of them were taken to the government hospital and later Nimans and the victim died on 25/7/2013. The police investigated the matter and filed the charge sheet against the present revision petitioner, invoking the offence punishment section 279, 338, and also 304A. The prosecution mainly relies upon the evidence of PW 2, who is an eyewitness, and PW6 also an eyewitness. And both of them given the evidence that the revision petitioner who came in the opposite direction came in a rash and negligent manner and dashed against the victim. As a result, he had sustained injuries. No doubt the PW5 who has been examined before the trial court, who is also the occupant of the offending vehicle, deposed that the accident is on account of victim. And having perused the evidence of PW2 and PW6, and they have reiterated with regard to the manner in which an accident was taken place. And in the cross-examination of PW2 and PW6, nothing is elicited. However, the counsel appearing for the petitioner, revision petitioner, would vehemently contend that the evidence of PW2 and PW6 cannot be believed. And both the courts committed an error in convicting the petitioner, and it requires interference. Counsel appearing for the state would submit that PW2 and PW6 evidence is consistent with regard to the accident is concerned. Nothing is elicited from their mouth to disbelieve the case of prosecution. The trial court also taken note of Exhibit P5 AME report, and both the vehicles have sustained damages, and hence doesn't require any interference. The counsel also submits that even appellate court also assess the evidence available on record, and considering the evidence of PW2 and 6, and also the AME report, which is marked as Exhibit P5, and particularly in paragraph number 25, discuss the same, that the AME report discloses that said accident was not due to any mechanical defect of the vehicle, and also noticed the damages caused to both the vehicle. Having heard the petitioner counsel and also the counsel appearing for the state, and also looking into the evidence of PW2 and 6, who are the eyewitnesses, and also their evidence is very clear that immediately after the accident, injured was shifted to the injured, both injured and both the victim was shifted, and PW2 is also an injured, Allah? And PW2 is also an injured witness, and he also sustained grievous injuries. And taking into note of the evidence of PW2 and PW6, nothing is elicited from the mouth of these two witnesses to discredit the evidence of these witnesses. And revisional scope of the court is very limited. Only if material evidence is not considered, and then court can exercise its revisional jurisdiction, whether the order impugned suffers from any legality and correctness. And apart from that, documentary evidence of Exhibit P5 AME report is also very clear that both the vehicles have sustained injuries. And no doubt the PW5 has not supported the case of the prosecution, and he came and gave evidence in favor of the petitioner herein. And court has to take note of the accident was occurred on 24/7/2013, and immediately accident was reported on the very next day. And both the courts taken note of particularly the evidence of PW2 and 6, and PW2 is the injured witness, and PW6 is another eyewitness who was also proceeding at the time of the accident. And hence, I do not find any material to interfere with findings of the trial court. However, the trial court convicted the accused for the offense punishable under section 279 also. When the offense under section 304A is invoked, offense under section 279 merges with the offense under section 304A. And when such being the case, the trial court ought not to have convicted the accused for the offense punishable under section 279, and hence it requires modification of the judgment of the trial court with regard to the conviction under section 279. And apart from that, no other grounds are found to set aside the order of the trial court. In view of the discussions made above, I pass the following order. Revision petition is allowed in part the judgment and conviction. Judgment of conviction and sentence for the offence punishment section 279 is set aside. Remaining offences 338 and also the 304A of IPC is confirmed. The trial court also sentence for 6 months for the offence punishment 304A of IPC. And the same is also commensurate with the allegations of charge of causing of an accident and a death was taken place in the accident. The trial court is directed to refund the amount of fine payment made by the revision petitioner in respect of the offence punishment under section 279 of IPC.
PW2 is not a injured witness.
ಯಾರು
Was a pillion rider with along with PW5 Millard.
ಯಾರಿಗೂ ಇಂಜುರಿ ಆಗಿದೆಯಲ್ರಿ?
PW5 is injured Millard. Who is the pillion rider? PW5.
ಅಗರ್ PW2 ಅಲ್ಲ ಅದು PW5.
He is the pillion rider of the accused Millard. ಹೌದು. ಹೌದು.
PW5 is injured.
ಹೌದು. PW5 is a pillion rider injured.
ಇವನ್ ಒಬ್ಬನೇ ಇದ್ದ. ಇವನ್ ಒಬ್ಬನೇ ಇದ್ದ. ಹಾಗಾದ್ರೆ ಅಲ್ಲಿ ಮೇಡಮ್ ಬರೋಲ್ಲ. Though PW5 is injured, he has not supported the case of the prosecution ಅಂತ ಹಾಕೊಳ್ಳಿ. PW2 and 5 are the independent witnesses ಅಂತ ಹೇಳಿ. Who have witnessed the accident ಅಂತ, not injured. The registry is directed to pay the fee of rupees 5,000 to the amicus curiae.
For appellant.
For respondent.
Hmm?
I'm for respondent matters.
ಏನ್ ಅಫೆನ್ಸ್?
138.
38 Lordship.
138 ಅಲ್ಲೂ ಅಮಿಕಸ್ ಕ್ಯೂರಿ ಅಪಾಯಿಂಟ್ ಮಾಡಿದಾರ. ಅದ್ಯಾಕ್ ಮಾಡ್ಬೇಕ್ರಿ ಅಮಿಕಸ್ ಕ್ಯೂರಿನ? ಇಡೀ ಬೊಕ್ಕಸದಲ್ಲಿರೋ ದುಡ್ಡೆಲ್ಲ ಅವ್ರಿಗೆ ಕೊಡಿ ಅಂತಾನ? ಅವನ್ ಬರ್ಬೇಕು. ಯಾರು ನೋಡಿದ ಅಪಾಯಿಂಟ್ ಮಾಡ್ರು? ಇಲ್ಲ ಅಂದ್ರೆ ವಕೇಟ್ ಮಾಡೋದು ಅಷ್ಟೇ ಆರ್ಡರ್ ಸ್ಟೇ ಇರೋದು.
Both court.
Why court has to, why the state government has to pay the amount from its exchequer? Check bounce case ಅಲ್ಲಿ. ಸ್ಟೇಟ್ ಆದ್ರೆ ಪರವಾಗಿಲ್ಲ, ಸ್ಟೇಟ್ ಮ್ಯಾಟರ್ಸ್ ಅಲ್ಲಿ ಕೊಡೋಣ. ಈಗ ಈಗ ಮಾಡಿದ್ವಿ 279, 338, 304A ಎಲ್ಲ. ಇದ್ರಲ್ಲಿ ಚೆಕ್ ಬೌನ್ಸ್ ಕೇಸ್ ಅಲ್ಲಿ ವೈ ಯು ಹ್ಯಾವ್ ಟು ಸ್ಪೆಂಡ್ ದಿ ಮನಿ ಫ್ರಮ್ ಸ್ಟೇಟ್ ಎಕ್ಸ್ಚೆಕರ್ ರೀ? ಯಾರು ಕೌನ್ಸಿಲ್ ಇದ್ದಾರೆ ಮೊದಲು?
ಡಿ ನಾಗರಾಜ್ ರೆಡ್ಡಿ.
ಈಗ ನೀವು ನಾಗರಾಜ್ ರೆಡ್ಡಿ.
ಶ್ರೀನಿವಾಸ್ ಅಂತ.
ಶ್ರೀನಿವಾಸ ಆರಿದಾರ? ನೀವ್ ಯಾರ ಆಫೀಸ್?
ನಾಗರಾಜ್ ರೆಡ್ಡಿ.
Amicus curiae.
ಶ್ರೀನಿವಾಸ ಆರಿಲ್ವಾ? ಯಾವಾಗ ಬಂದಿಲ್ಲ? ಯಾವಾಗ ಬಂದಿಲ್ರಿ ಇವರು? ವೈ ಯು ಹ್ಯಾವ್ ಟು ಸ್ಪೆಂಡ್ ಮನಿ? ಲಕ್ಷಾಂತರ ಕೇಸ್ ಇದೆ ದೇಶದಲ್ಲಿ, ಎಲ್ಲಾರ್ಗು ಅಮಿಕಸ್ ಕ್ಯೂರಿ ಕೊಡ್ತಾ ಇದ್ರು ಅಷ್ಟೇ. ವೆಕೇಟ್ ಮಾಡೋಣ ಅಷ್ಟೇ.
Lordship, here financial capacity is not shown by the financial capacity Lordship.
ಅದ ಆಮೇಲೆ ನೋಡೋಣ. ಫೈನಾನ್ಷಿಯಲ್ ಕೆಪಾಸಿಟಿ ಇದೆಯಾ ಇಲ್ಲ? ದುಡ್ಡು ಇಸ್ಕೊಂಡು ಚೆಕ್ ಕೊಡೋ ಫೈನಾನ್ಷಿಯಲ್ ಕೆಪಾಸಿಟಿ ನೋಡಲ್ಲ.
Lordship, in the she has
Current counsel for the revision petitioner called out absent 8/10/21. None of the revision petitioner is present calling of cases. Counsel for the petitioner is absent. Workers are stage and also go to show that on several dates of hearings also some interest. Even thereafter, the main counsel for the revision petitioner remained absent and this court still granted adjournment in this matter and 2 or more occasions only to make a submission. Despite the same, since the counsel for the revision petitioner neither appeared nor the petitioner not now.
My lord, the appellant, my lordship, she has lodged the complaint in the.
ಏನ್ ಹರ್ಡ್ ಅಡ್ಮಿಟ್ ಆಮೇಲೆ ಅಡ್ಮಿಟ್ ಆಗಿದೆ ಇದು. ಅಡ್ಮಿಟ್ ಆಗಿದೆ ಇದು 2022 ನಲ್ಲ.
Please, please, 22. As per the complaint, my lordship, in the year 2013.
ಆಯ್ತು ನೋಡೋಣ ಬಿಡಿ 440 ಆಗ್ಲೇ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ನೋಡ್. Amicus Curiae is present and respondent counsel is present. List this matter on 21-3. 45 already adjourned ಆಗಿದೆ. 46 adjourned ಆಗಿದೆ. 47 Prashant BK. NR Naik.
My lords, appearing for the revision of.
ಏನ್ ಮ್ಯಾಟರ್ ಏನ್ರಿ?
My lords.
138 ಏನ?
ಅಲ್ಲ,
Taken cognizance.
private complaint dismiss ಆಗಿದೆ.
Private complaint
dismiss ಆಗಿದೆ. For section 5 and under section 499 and 500 of IPC.
ಯಾವಾಗ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ? ಡಿಸ್ಮಿಸ್ ಆಗಿಂತ ಮುಂಚೆ ಆರ್ಡರ್ ಶೀಟ್
16/11/2021.
16/11/2021 ಆರ್ಡರ್ ಶೀಟ್ ಎಲ್ಲಿದೆ?
Page number 111. 108, my lords.
108.
8.
PCR. Orders on bail application, right? Orders on application filed under section 200 of CRPC.
Private complaint dismiss ಆಗಿದೆ.
ಅಂದ್ರೆ not for non-prosecution.
Non-prosecutional.
Complaint ಅಲ್ಲಿ ಕೇಸ್ ಏನು ಇಲ್ಲ ಅಂತ.
ಹೌದು my lord. In this the.
Next time ನೋಡ. Want of time is this matter on 21-3.
Great. For the respondent, my lord.
48 ಯಾವಾಗ ಬೇಕು ಹೇಳಿ for want of time.
Petitioners.
ಯಾವಾಗ ಬೇಕು? 21-3.
Senior sister expired ಆಗಿರೋ ಸಮಯ ನಿನ್ನೆ ನೈಟ್ ಹಂಗಾಗಿ
ಡೇಟ್ ಕೊಡ್ತಾ ಇದ್ದೀನಿ ನಾನು ನಿಮ್ ಸೀನಿಯರ್ ಕರ್ಕೊ ಬನ್ನಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ಡೇಟ್ 21-3. ರಮೇಶ್ ಕುಮಾರ್ RV and Law Men's Company ಕೃಷ್ಣಮೂರ್ತಿ ಯಾವಾಗ ಬೇಕು? 21-3.
Respond number 1.
21-3. Want of time list this matter on 21-3. 50 also Manjunath BV. SV Srinivas. ಇಬ್ರು ಇದ್ದೀರಾ? Both councils are present. For want of time list this.
Petitioner ಇಲ್ಲ.
52 Hemant Kumar.
I know I'm the respondent in this case. I'm appearing in person.
You are party in person.
Party in person. And this case is going on since 34. 34 years it is going on. So,
not 34 years. Before this court from 23.
From the lower court it was 1990 it was filed.
Petitioner counsel is absent. Party in person respondent is present. List this matter on 21-3. 21-3. Short date. That is 2 weeks. 21-3.
For respondent.
RSA na?
RSA.
ಏನಕ್ಕೆ ಇಷ್ಟ ಆಗಿದೆ?
Final hearing.
ಫೈನಲ್ ಹಿಯರಿಂಗ್ 50 ಡೇಟ್ ಕೊಟ್ರಾಗಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಇದಾರ ಯಾವಾಗ?
Any day, any short time.
19th.
Please.
For want of time list this matter on 19-3.
Can it be taken at 2:30?
Time fix ಮಾಡೋದಿಲ್ಲ. It depends upon case.
Please.
54 final disposal. MK Venkataramanan.
Petitioner my lord.
Azhar Mir.
138.
ಯಾವಾಗ? 21st.
21st, I have an inconvenience, my lord. Any date after the 21st.
20th.
ಅಲ್ಲ 21st I will finish up my part.
ಆಯ್ತು ಆಗ್ಬೋದು 21 ಇರ್ಲಿ.
ನೀವ್ ಯಾವತ್ತಿರಲ್ಲ ಹೇಳಿ? ನೀವ್ ಇರೋ ದಿವಸ ಕೊಡ್ತೀನಿ.
ಅಲ್ಲ 21 ಇರ್ತೀನಿ, ಆದ್ರೆ ಆ ದಿವಸ ನನ್ಗೊಂದ್ ಸ್ವಲ್ಪ ಪರ್ಸನಲ್ ಕಮಿಟ್ಮೆಂಟ್.
22 ಕೊಡ್ತೀನಿ, ಆಗ್ಬೋದಾ? ಆಯ್ತು 22.
ಮಚ್
22-3. ಮುಗೀತಾ ಮೇಡಮ್?
ಫೈನಲ್ ಹಿಯರಿಂಗ್.
ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಬಂದಿರೋದು.
Citation 62.
ಸಿಕ್ತಾ?
ಅದು 439.
ನೋಡಿ 439 ಅಲ್ರಿ, 438. ಇದಲ್ರಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ ಅಂದ್ರೆ.
ತಮ್ಮದು ಜಡ್ಜ್ಮೆಂಟ್.
ಇದಲ್ಲ 438. ಅದು ನಾನು ಆಫೀಸಲ್ಲಿ ಇದೆ ಬಿಡಿ ನೋಡ್ತೀನಿ. ಇದು ಮೆರಿಟ್ ಮೇಲ್ ಮಾಡಿ 439 ಸಕ್ಸೆಸಿವ್ ಬೇಲ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಇದ್ದಾಗ remand application does not disclose the involvement of the petitioner. No vote act is attributed against the petitioner. From the seizure measure of mobile, it is clear that presence of the petitioner is not established contradiction, consideration of successful bail petition. No doubt court can consider the subsequent bail petition when more details are given, but court has to keep in mind whether there is a prima facie case against the petitioner ಅಂತ ಮಾಡಿರೋದು ಅಷ್ಟೇ. Successive bail petition ಗೆ ಇದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಿಲ್ಲ.